Now I request our esteemed chief guest, Professor V. Balakrishna Reddy Garu, on third world countries. Further, he was engaged in drafting laws for the Government of India and the governments of Telangana and Andhra Pradesh. As the director of Center for Aerospace and Defence Laws, he developed master's and postgraduate diploma programs dealing with aviation law, space law, defence law and maritime law. As the director of Center for Tribal and Land Rights, he supervised the drafting of several landmark laws in Telangana and Andhra Pradesh. Professor Reddy Garu has served as a visiting faculty at many reputed institutions across the world, including universities in the USA, Canada, the Netherlands, Germany, France and Sri Lanka, as well as various Indian universities. His publications include articles in national and international journals and several authoritative books on air and space law. He taught numerous courses in international law and all, the strengthening academia industry, collaboration through MOUs, enhancing research and innovation with the launch of Telangana Journal of Higher Education, the TGCHE newsletter, and expanded the internationalization of higher education across Telangana. As the chairperson of various committees, have overseen the revision of undergraduate curriculum for the academic year 2025 to 26. Fee fixation, framework for private unaided professional institutions and successfully conducted all 8 common entrance tests, etc. Several other notable innovations under his leadership also includes mock counseling for engineering admission initiatives, the first year TGEAP SET awareness program in collaboration with JNTU, the TSAT Live Orientation program, a scholarship scheme launched with the Azim Premji Foundation to support girls in Telangana, and the development of comprehensive English training material for first year degree students. Dr. Reddy Garu's dedication and administrative guest of honor for today, Professor Kumar Moligram Garu. Now I request our guest of honor for the workshop, Professor Venkateshwarlu Garu, Head and Dean, Faculty of Law, Osmania University. Now I invite Madhavi for the profile reading of Professor Venkateshwarlu.
Good morning all. It is my privilege and honor to introduce our esteemed guest of honor for today's occasion, Professor Dr. Venkateshwarlu Sir, Dean Faculty of Law, Osmania University, former Joint Secretary, Legal Bureau, UGC, New Delhi. When we speak of commitment to legal education, one name truly stands out, and that is his. Sir has worked from 1998 till date as a professor of corporate and securities law, University College of Law, Osmania University. From the year 2008 to 2011, he worked as a vice principal, University College of Law, Osmania University, and till 2021 as a joint director, Estate Cell, Osmania University. In the year 2016 to 2021, he took as an in-charge director, legal cell and RTI cases under Osmania University and worked as a principal in PG College of Law, Osmania University, Hyderabad. In 2025, he worked as a Dean Faculty of Law, Mahatma Gandhi University, Nalgonda, Telangana. Sir has done his UGC Research Fellowship on ODRs in the year 2014. Later on, he worked as a principal investigator on pre-listing the law and policy of also prison administration in India in the year 2021.
1 second.
Sir has produced almost 23 PhDs and 5 PhD scholars working on the research of comprising of all the streams such as cyber laws, law of insurance and taxation and IPR. His esteemed work also includes research papers which were presented and attended nearly 150 seminars, conferences and workshops. Sir, as a director, conducted 10 days research methodology program sponsored by ICSSR, New Delhi, and conducted national seminars, workshops, and training programs as chairman, co-chairman, and the director. He has conducted the human rights training program sponsored by NHRC New Delhi not once but twice. He has published almost 62 articles in the national reputed journal with ISSN and ISBN number, and was also invited as a resource person for almost 90 institutions, organizations to deliver his lecture on different topics in India and foreign. Sir is an awardee, UGC Research Awardee in the year 2014 to 2016 and successfully completed in the year 2018. He was an awardee on law relating to online dispute resolution in India as studied. Sir has also been awarded for the Telangana Sri Seva Award and nominated to National Teachers Award by the Osmania University. These recognitions stand as a testament to Sir's unwavering dedication. In 2021, he has delivered a lecture on the guest speaker of QMI Arbitration Center UK Limited titled Conflict of Interest between Arbitration Centers and Arbitrators and its impact on the arbitration impartiality, transparency, neutrality and parties' reputation. Sir has also visited Jordan and Nepal and participated and presented the papers in international conferences by invitation. Sir was also invited to deliver lectures at the esteemed State Judicial Academy, Telangana State, and conducted free legal aid camps and legal literacy camps. Sir has also published nearly 16 peer-reviewed papers in different journals with ISBN and ISSN, with 15 published in the UGC recognized journals. Sir has authored almost 5 books and was an editor for the 2 books. Some of the books titled are Law Relating to Online Dispute Resolution in India and Legal Education in India, a Pedagogy and the Role of ICT in the year 2022. We are privileged today to learn from the personality who embodies knowledge, humility and leadership. Thank you, sir. Thank you so much for gracing me.
Now I invite Professor G. Sudarshan Reddy Garu, Secretary and Correspondent of RBVRR Women's College. I invite Kishore sir to present the book. Professor G. Sudarshan Reddy Garu was a former faculty of Department of History and now serving as a Secretary in RBVRR Women's College. Now let's proceed with the lighting of lamp. I also invite Ms. Gayatri, final year student of BSc of RBVRR College, for prayer song.
महागणपतिं मनसा स्मरामि महागणपतिं मनसा स्मरामि महागणपतिं मनसा स्मरामि वशिष्ठवामदेवादिवन्दित महागणपति मनसा स्मरामि वशिष्ठवामदेवादिवन्दित वाहनमोदकप्रियं महाकाव्यनाटकादिप्रियं मूषिकवाहनमोदकप्रियं महागणपतिं मनसा स्मरामि वशिष्ठवामदेवादिवन्दित महागणपतिं. Thank you.
Now I respectfully invite our president for the workshop, Professor Kumar Molugaram Garu. Now I invite our convener for the workshop, Dr. T. Aparna ma'am, principal for the PG College of Law, Usmania University, for welcome address.
Very good morning to one and all. Respected Chief Guest of the session, Professor V. Balakrishna Reddy Garu, and our President of the workshop, Professor Kumar sir, and guest of honors for this session, Professor Venkateshwara sir and Professor Sudarshan sir, along with the faculty members, research scholars, students, dear participants. A very good morning to one and all. It gives me an immense pleasure to extend a warm and heartfelt welcome to all of you for this 2-day national workshop being organized by PG College of Law, Usmania University, Bashir Khan, and RBVRR Women's College affiliated to Usmania University. This workshop has been thoughtfully designed to provide an intensive and scholarly engagement with the application of forensic science within the legal process. In an era where criminal justice increasingly relies on scientific inputs, it becomes imperative for the legal professionals relying on the scientific inputs. It becomes imperative for the professionals, scholars and students to critically understand how forensic methods operate, not in isolation, but within the established legal and procedural framework. Over the next 2 days, this workshop will examine the role of forensic science at a very crucial stage of all the legal process, from investigation and evidence collection to scientific analysis and judicial evaluation. It brings together diverse forms of forensic evidence, including medical, physical, documentary, biological and digital evidence, highlighting their role in supporting fact-finding and adjudication. The special focus of this workshop is on institutional practices, standards of expert opinion, and the manner in which scientific conclusions are assessed by courts. Through close engagement with judicial reasoning and selected landmark case studies, the session will illustrate both the evidentiary potential of forensic science and the serious consequences that arise from procedural lapses and improper handling of the evidences. We are deeply honored to have an eminent members of judges, forensic scientists, medical experts, academicians and legal practitioners whose expertise and experience will greatly enrich our discussions. I sincerely believe that their insights will help and bridge the gap between the science and law, theory and practice. I would like to place on record my special appreciation to Professor V. Achyuta Devi Madam, workshop co-convener, and her support and coordination to all those we have contributed to making the workshop possible. I am confident this workshop will serve as a meaningful platform for learning, crucial reflection and interdisciplinary dialogue with and will greatly benefit all the participants. I once again warmly welcome all of you and wish you a great success for this workshop. Thank you.
Good morning. Respected Professor Balakrishna Garu, Honorable Chairman Telangana Council of Higher Education, Chief Guest of the Day, President of the workshop, Professor Kumar Vangaram Garu, Honorable Vice Chancellor, Usmania University, Guest of Honor, Professor Venkateshwar Garu, Head Team Faculty of Law, Usmania University, Professor G. Sudharshan Reddy Garu, Secretary cum Correspondent, RBVRR Women's College, and Convener Dr. T. Aparna Garu, Principal, PG College of Law, Usmania University, distinguished dignitaries, respected resource persons, faculty members, researchers, and dear students. It is a matter of great pride and pleasure to welcome you all to this conference on Law and Forensic Science, jointly organized by PG Law College of Usmania University and RBVRR Women's College, Autonomous, Narayanguda, Hyderabad. We are honored to host such an important academic gathering that brings together the fields of legal studies and forensic science, two disciplines that are central to the administration of justice. On this occasion, I would like to say a few words about our college. RBVRR Women's College was established in the year 1954 by the Hyderabad Mahila Vidya Sangam, a non-profit education society. The college owes its genesis to the great visionary and philanthropist Sri Rajabahadur Venkatrama Reddy Garu, the then Kotwal of erstwhile state of Nizam, with the mission of providing quality education to women, particularly hailing from the backward regions of Telangana. RBVRR Women's College strives to give the finest education to women with an objective of making them self-reliant. The history of our institution chronicles several milestones in its journey of excellence. On 3rd January 1954, Pandit Jawaharlal Nehru, the first Prime Minister of India, laid the foundation stone of the college building. On 6th January 1955, Dr. Sarvepalli Radhakrishnan, the first Vice President of India, inaugurated the college building. Srimati Indira Gandhi, the then Union Minister for Information and Broadcasting, inaugurated the hostel building on 28 July 1965. On 5th August 2005, Dr. APJ Abdul Kalam, the then President of India, delivered the Golden Jubilee valedictory address. And on 28 November 2018, Sri C.H. Vidyasagar Rao Garu, Honorable Governor of Maharashtra, delivered the valedictory address on the occasion of the closing ceremony of Diamond Jubilee celebrations of the college. On 25th January 2020, Dr. Tamilisai Soundarajan, Honorable Governor of Telangana, graced the occasion as the chief guest and delivered the convocation address. Our college has been granted autonomous status in the year 1989 by the University Grants Commission, and it has been granted the status of college with potential for excellence by UGC in 2010 and extended the same in 2014. The college is the first college in Telangana and sixth college in India accredited with grade A by NAC in the 5th cycle in the year 2024. Our college autonomous status is extended up to 2035 most recently. RBVRR Women's College, with 70 years of dedicated service in the field of women education, is successfully rewarded in its resolve and internal strength to remain a beacon of light in its mission of imparting quality education to women in the state of Telangana. In today's rapidly changing world, the nature of crime is evolving, becoming more complex and technology driven. In such a scenario, law alone is not sufficient. It must be supported by scientific evidence, forensic analysis, and modern investigative tools. Forensic science adds objectively and precision to the justice system, ensuring that truth is established through evidence and not assumptions. This strong partnership between law and science strengthens public trust in the legal system. This conference provides a valuable platform for intellectual exchange, research discussions, and sharing of practical experiences. It encourages dialogue between academicians, legal experts, forensic professionals, and students. Such interactions not only enhance knowledge, but also inspire innovation, critical thinking, and ethical responsibility among young learners. I am confident that the deliberations, presentations, and discussions in this conference will contribute meaningfully to academic growth and professional excellence. I appreciate the efforts of the organizers, collaborators, and the participants who have made this event possible. I thank Principal Madam Aparna Garu, PG College of Law, for collaborating with us. Thank you one and all.
Now I request Professor B. Vijayalakshmi Garu, convener of TG LawSet and TG PG LSET 2026, to kindly grace the dais. I welcome our President for the workshop, Professor Kumar Moluguram Garu, President of the workshop, and I request Dr. T. Aparna ma'am to present a bouquet.
Good morning, ladies and gentlemen. Now I would like to invite our President of the workshop, Senior Professor Kumar Molugaram sir, Vice Chancellor, Usmania University. Senior Professor Kumar Molugaram sir is an eminent academician and distinguished teacher in the civil engineering. Brings with him almost nearly 3 decades of excellence in teaching, research and academic leadership. An alumnus of Usmania University, he pursued his master's degree in JNTU and earned his doctorate from the prestigious Indian University of Technology, Bombay. Since October 19, 2014, he has been serving as the 26th Vice Chancellor of the historic 107 years Usmania University, where he is deeply committed to advancing his alma mater through academic distinction, research innovation, digital transformation and global collaboration. Throughout his career, Senior Professor Kumar Garu has made significant academic and research contributions and authored more than 100 research papers in the reputed national and international journals and conferences. He has supervised over 90 ME dissertations along with several PhD theses. He was instrumental in establishing the ME Transportation Engineering program at the University College of Engineering, Usmania University, a landmark academic initiative. His research work has been widely supported by the major funding agencies including UGC and DST SERB Government of India. His dedication to teaching and research has earned him numerous accolades. He received the State Meritorious Teacher Award from the Government of Telangana in the year 2018, the Engineer of the Year Award from the Institution of the Engineers and Government of Telangana in 2018. He has also been recognized nationally and internationally for the best research papers in 2010 and 2015. Senior Professor Kumar Garu has held several key leadership and administrative roles that reflect his vision and ability to drive institutional growth. He has served as a Dean Faculty of Engineering from 2022 to 2024 and as a Principal of the University College of Engineering from 2018 to 2021. He is the spearheaded digital automation and secured NBA re-accreditation from the UG and PG programs. As a controller of examinations, he introduced transformative digital reforms during the university's centenary celebrations. He has also served as a member of the Executive Council of Usmania University, convener of TS PG SET 2019 and 2020. As a Director of Infrastructure, Director of the Regional Center for the Urban and Environmental Studies, Vice Principal for the University College of Engineering, Head of the Civil Engineering Department and Chairperson of the Board of Studies and Civil Engineering. A globally recognized scholar, Professor Kumar sir has represented Usmania University across 20 cities in 15 countries, where he has delivered keynote addresses and chaired sessions and presented research at the prestigious academic platforms. His leadership exposure has been further enriched by the advanced training and the capacity building programs at the ISB, IIM, Central University of Hyderabad and Monash University under the MHRD's LEAP program. He is also deeply engaged in the professional and technical service. He is a fellow and the life member of the leading professional bodies including Fellow of Institution of Engineers, Indian Roads Congress, Institute of the Urban Transportation Research Group, Indian Institute of Bridge Engineers, and the World Conference Transport Research. He has also served on several important state and central government committees in the higher education and infrastructure development since 2006. He has played a pivotal role as the state technical agency for PMGSY roads in the Telangana and Andhra Pradesh, ensuring sustainability in the rural road infrastructure. Sir has a vision for the Usmania University is rooted in academic excellence, research-driven innovation, technological reforms, and global collaboration. With his proven track record as a scholar, administrator, and the reformer, he is poised to take the Usmania University into its next era of growth, relevance, and global impact. Thank you, sir. Thank you for gracing the event.
Now I respectfully hand over this session to Professor Kumar Molugram Garu to preside the session. I request Madhavi ma'am to present a bouquet to Professor Vijay Lakshmi Garu. Now I request Professor G. Sudarshan Reddy Garu to enlighten us on the workshop.
Very good morning to you all. It's a privilege to stand before you. A lot of humility and a bit emotional also, because this is my alumni. I was a student here, I was a teacher here more than 30 years. Now holding the position of Secretary Correspondent RBVRR Women's College. A 73-year-old not-for-profit organization. We are 36-year-old autonomous institution, 5 times NAC accreditation. So, we are privileged to be part of this particular workshop being organized by the University PG College of Law, led by Professor Venkateshwar Garu and Dr. Aparna and Professor Vijay Lakshmi Garu. We have today with us the Chairman of State Council of Higher Education, Professor Balakೃಷ್ಣ Reddy Garu, and our Vice Chancellor, Sir Professor Kumar Molugram Garu. On our behalf, I welcome these dignitaries. Friends, this is a very important area. You all know that forensic science and in law, one can say 2 phases of what you call criminality as well as civil law and civil society. Because we all know the crime is increased and it's spreading to newer and newer areas. Sometimes to the surprise of the people involved in trying to detect what the exact problem or who the culprit is. And in this context, the research in the area of DNA and fingerprinting, toxicology, and other areas associated with forensic science are growing, are giving wonderful results and helping the law, both criminal and civil law, to focus upon, to pinpoint who the culprit is. And in this context, we have to, as far as my limited knowledge goes, Professor Lalji Singh of CCMB made singular contribution in this area. And as a result of his research, he carved out a separate lab known as Center for DNA Fingerprinting and Diagnostics, in short CDFD, located on the road from Nagol to Elvinagar. So, unfortunately, he did not live long. Soon after retirement, he became Vice Chancellor of Banaras Hindu University, came back, maybe after a couple of years, he passed away. That was a great loss to the science as such, and this particular area of what you call forensic science, fingerprinting and DNA research. So Hyderabad in course of time has become a hub in the area of research, hub of research in the area of this particular area, which I think is certainly helping the law to find out the exact what you call reason for the crime, the culprits, the criminals, and trying them. The civil society is able to bring such culprits to book. So maybe in the years to come, I hope further research in this area with the aid of modern technology will help resolve some of these what you call very heinous crimes that are taking place in our society. I once again thank the organizers for giving a space to our college, RBVR, Women's College, because we have chemistry and forensic science combined department. We have some young teachers involved in teaching as well as research in these areas, and in the years to come we hope to contribute to the best of our ability to this particular area. And I request the people from University College of Law to, whenever they think of forensic science, think of RBVR or Women's College and give us further chances to associate with you. Thank you very much.
Now I invite Professor N. Venkateshwarlu Garu to enlighten us on the workshop.
Very good morning to one and all. Respected dignitaries on the dais, today's chief guest, Professor Balakrishna Reddy sir, Professor M. Kumar sir, Vice Chancellor, Osmania University, dignitaries from the RBVR Degree College, my colleagues in the department, Vijay Lakshmi Madam Aparna, and authorities from the RBVR Degree College, Women's Degree College, PhD scholars, LLM students, LLB students, my dear friends. First of all, I want to congratulate Professor Aparna Madam has taken very good initiative an emerging area, and also welcoming collaboration with the RVRR degree college, because this kind of collaborations are very much required. It is welcome also, because without that you cannot find quality of the seminars, quality of the workshops. This is very welcoming. In future also we are expecting, whatever Sudarshan sir is expecting, we will continue this kind of trend in future also. Coming to this topic, everybody speaks about in the society many wrongs are happening, no proper punishments. 90% of the acquittal rate is there, only 10% people are going inside. Then what? Everybody is bothering. Coming to the reality, here there is no proper criminal investigation system in India, because no coordination in between the prosecution and investigation. Here, after filing the FIR, filing the charge sheet, simply they will submit to the court. Then what happens? Investigation people, they don't know. After filing the charge sheet, investigating officer transfers to some other place. After 5-6 years, when trial starts, court people call him. After coming there, he will simply depend on the constable. What he says, simply he will depose in the court. He is not bothering about charge sheet, he is not bothering about charges, what kind of charges they frame, and what kind of chief examination he has to pose before the judge. He is not bothering about cross-examination. When defense counsel comes, whatever cross-examinations are there, simply they are admitting, and that is the reason punishments are not taking place in the courts. That is the reason crime rate is increasing. Now, in the case of criminal investigation system and the criminal administration system is very, very poor. Coming to forensic science, in the entire India, 2-3 universities are there on forensic science after 2020 only. After 2020, one forensic university came in the Delhi. Professor Pokhriyal is the Vice Chancellor for that. She is conducting many programs, academic programs, research programs, even PhD programs also. But after that, Uttar Pradesh bought one forensic university. Gujarat bought one forensic university. Coming to Telangana, we are depending on private people. Just now Sudarshan sir mentioned about CDFD. How many cases are they are sending for investigation to the CDFD department? Very, very less. Monthly 2-3 cases. Because there is no coordination in between the judicial system as well as forensic science department. And whenever very big issue comes, because of media pressure, society pressure, some of the cases are sending to forensics department. They are finding some results and getting punishments. Here, governments are also not coming forward to give funds to the universities to conduct these kind of forensic awareness programs. It is not happening. Very less opinion on the investigation teams. There is no coordination in between the prosecution side and investigation side. Many loopholes are there. And very important thing is that in criminal investigation system, many loopholes are there. Suppose in 2015, in Chevella court, after filing 304B, dowry death, husband, accused and family members are compromised. He paid some lakhs of rupees as maintenance to children. They are with in-laws. Everybody in trial court, everybody went for cross-examination, trial purpose. Everybody said, my daughter was suffering from stomachache, he was in ill health, That is the reason she was died. But in medical examination, some problem was given by husband, and some inside some problem, technical issues are involved in that investigation, and district court judge, based on the report of the scientific investigation, he given punishment to the husband. And in these type of cases only punishments are coming. Because here there is no proper research on this, in this kind of thing. And just now we are only one college in the Usmania University, entire Usmania University, out of 600, 700 affiliated colleges, degree college, only one college is conducting BSc forensics. Coming to Usmania University, our Vice Chancellor is here, MSc Forensic Science Department is only one. Coming to Usmania University, after 2023 Law Department, we added forensic syllabus in the curriculum. And no coordination in between the MSc Forensics Department and Law College, conducting collaborative kind of programs. Here, lawyers are, they think that lawyers are different and MSc courses are different. No interdisciplinary kind of programs are not there. They are not allowing law students also to visit laboratories. In this kind of situation, how can you expect good things? That is the reason, just now I requested Balakrishna Reddy sir also. Please conduct one workshop, sir. Bring these kind of syllabus in the curriculum. When they bring this kind of curriculum at degree level, automatically students will develop this kind of knowledge in their academics. Otherwise, in future also, many kinds of crimes are coming. Without forensic investigation, you cannot expect punishments also. Because defense counsels are very intelligent, they will take their own kind of thing. That is the reason you cannot expect more punishments. Like RBR Women's College, many colleges have come forward to introduce forensic departments in their colleges and conduct specialized programs and installation of laboratories in their colleges. And every case, whatever the cases are there, simply they have to send to investigation. Then only you can expect more punishments. Suppose if you cross 50% of above punishments, automatically society will set right. Thank you for giving me opportunity to say this few words.
Now I invite Professor Kumar Molugaram Garu to give us insights into the workshop.
So very good morning. Today's chief guest, Professor Balakrishna Reddy Garu, Chairman of State Council of Higher Education, Telangana. Today's Dean, Faculty of Law, Professor Venkateshwar Garu. Because I am from engineering, that's why every time it comes engineering. Yeah. Professor G. Sudarshan Reddy Garu, Secretary and Correspondent, RBVRR Women's College. Professor J. Achita Madam, from the Principal of the College, RBVRR Reddy College. Professor Vijayalakshmi Madam, former Dean and present Law Set Convener. And of course, today's Karma Karta Kriya Hall, Dr. Aparna, Principal of PG College, PG Law College, Bashir Bagh, Usmania University. Very good morning to one and all. Warm welcome to this today's national workshop on law and forensic science. At the outset, I congratulate PG College of Law, specifically Professor Aparna, for conducting or initiating this particular program is need of the hour. I also appreciate RBVR College for coming forward and associating with the Usman University for conducting this excellent program to create awareness among the students, very specifically in general to the society. Yeah, so all the speakers, of course, they talked about various problems. Dean also given one live example. So what happened, what is happening in the society? So every day we are facing some problem, and every day some case. See, each and every case is a different kind of case, and every case is a unique case. Normally we frame the rules, only rules we frame, but each and every case may not fit according to the rule. That is a serious kind of problem. So every case is a unique. For each and every case we cannot frame the rules. That is another important aspect. Only certain guidelines will be given, certain rules will be given, but the cases are totally different in nature. So addressing such kind of the cases, definitely we need some kind of evidences. That too, a scientific evidence is more important. So the forensic science, of course is a totally, the forensic is a science department and law is a separate department, as rightly mentioned by the Dean. So here the problem is the coordination among the various departments, because law and forensic science should go hand in hand, because but if these two departments works in an independent way, so obviously we cannot expect a good kind of results. That is a serious kind of gap. Even the government of India and state government, and recently we conducted under the leadership of Chairman Sir, so 100 days target for the universities what to do. And in that, especially the framing of syllabus is one of the major component, because any core subject in the present day context, only 60% is core and 40% is total interdiscipline. So the days are like that, because the interdiscipline, this core combination will give the wide opportunities to the students, especially the days, the present day and even future, the AI driven education totally. So AI is coming up, even in the forensic science also AI is going to play a key role. The accuracy is more important. In the entire Usman city, 739 colleges are there, only one degree college offering this forensic science, and only the PG course we are offering at Usman city. But the forensic infrastructure also to be established across the country and across the state. This is very, very important. And trained laboratory staff and AI tools must be used in the analysis of the report and interpretation of the report. This is the need of the hour. So the governments also insisting, the education departments also insisting for the interdiscipline and AI driven education system, so that the accuracy levels will be maintained high. So for that the human resources will be trained at a maximum extent, because today everyone is expecting quality education and skill based education. Ultimately that should address the problems of the society. So all the unsolved problems of the society shall be addressed with the help of interdiscipline and with the help of quality education and skill based education. So that is why many innovations are taking place in the present day context, and at the same time each and every field is so important, and if you use the AI driven the research and AI driven exploration will definitely help and simplify the problems. This is a simple kind of observation. And coming to the few 2-3 aspects, especially the infrastructure, especially the forensic related infrastructure is a serious kind of gap in the present day context. In that there is a the lot of demand is there, especially the rapid technological advancements outspace the training of investigators and forensic experts and lawyers and judges, creating gaps in proper collection and interpretation and presentation of evidence. This is very, very important. One should focus. This is a great kind of research area also. So students also should explore on these areas, especially the skills, especially the PhD scholars should focus on these areas. And coming to the certain things like challenges, capacity challenges in crime labs. So with advancements and demand for more sophisticated tests and forensic labs in several regions and are under strain due to increased case loads and funding pressures, highlighting infrastructure needs. As I said, because of the very less number of forensic labs are there across the country, across the state, across all places. This is the need of the hour. The governments also should focus on these aspects. And AI in forensic pathology and cause of death analysis. This is another important subject because it is possible with the interdisciplinary only. Because when you coordinate, when you exchange the things and collaborate, this is possible. And artificial intelligence is being systematically reviewed and deployed to support forensic pathology, including AI frameworks geared towards the automated and cause of death assessments. So this plays a crucial role. So now students should focus on the collaboration with the forensic science. Law students should collaborate with the forensic, and forensic students will collaborate with law. So in this process, obviously, the best of the results will come, and you practice the artificial intelligence, in assessing and interpretation of the results, etc. This is a better kind of a PhD topic or even the PG level topics. You explore, you take as a case study, so that definitely you will get some kind of solution and unsolved problems. See, the society is growing with the digital transformation, and India is the best example. Today, our population is 150 crores. Our mobiles are 200, more than 200 crores. So that is a great kind of transformative change. Our UPI transaction is highest. No country is making such a great kind of UPI. As per the RBI report, 70% of the people, they are using UPI payments. So everything is possible. Even educated and uneducated, they are very intelligent, no doubt in it. But only thing is, people always think that educated are intelligent. So intelligence is not depends upon the education. Intelligence, the inbuilt structure of the human DNA. So therefore, my strong feeling is, our people are very intelligent and they have to make use of the technology for the proper purpose, and at the same time, irrespective of the education and uneducation, everyone is using mobile phone today, right? And even any kind of technology. So therefore, the students make use of these technological benefits for transformation and better society of this particular country. So that country will grow, and we definitely will be the number one in Telangana by 2047 as per Honorable Chief Minister intention, and at the same time Vikasit Bharat objectives also will be fulfilled by 2047, because youth is the major source for the country. Less than 30 years population, youth population is around 60, and less than 25 age population around 50. So therefore the youth is the excellent kind of productive for the development of the country and progress of the country, and the country definitely will become the developed country over a period of time. And because of this all the technological explorations, job opportunities also will increase in future tremendously. So therefore you go ahead with some kind of intention, some kind of commitment, and work hard, and definitely you will definitely create wonders in coming days, and you make part of solving unsolved problems of the society. So with this, I once again congratulate the Department of PG College of Law, Usman University, for hosting such a wonderful program. I also appreciate RBVRR College for associating with this workshop. Thank you one and all.
I invite Professor Balakishna Reddy Garu, the chief guest of the workshop, to give us insights into the workshop.
Good morning to one and all. Respected Vice Chancellor, Professor Kumar Garu, other dignitaries on the dais, off the dais, faculty members, my dear students. Definitely, I too congratulate both RBVR College and PG College for coming out with a futuristic topic. Definitely, I agree, Vice Chancellor Garu. We are living in a multidisciplinary world, interdisciplinary world, intradisciplinary. There is no choice. We have to, one discipline has to mingle with other discipline. That's why I think I should congratulate you all. So, coming to the forensic law. Law and forensic, science and forensic, technology. So I'll just maybe next 2 days you are going to discuss various intricacies of forensic law and forensic science. But I want to just briefly touch about the connection between the law and technology, the nexus between law and technology, the linkage between law and technology, because one has to go with other. General broadly, if you look at what we call as a, because I can see a lot of friends here from law background, that's why I want to speak few minutes about the law. So today, yes, what we call law follows technology. Our technological developments necessitate the legal regulation. First, technology happens and then law will come into it. Unfortunately, today technology is moving in a faster manner. That's why I call it revolutionary technologies and evolutionary laws. Why I am telling revolutionary? Because yesterday was some technology, today was some, tomorrow. But law is not catching up. That's where society is confronted with the challenges. There is a wide gap between the technology and law. That's why this kind of workshops are very important to synergize between the linkage between the technology and law. Of course, what we call as a law people, techno-driven laws. Just now I said technology follows law or technological. For instance, if you look at I will give you a few examples. You all know that, right? Brothers invented aircraft in 1902. The moment when aircraft was invented, aircraft has a cross-border in nature. How to regulate? What kind of, it's going across the border. So how to regulate? What kind of liability? All these things within a month, European countries, those days, sat and they started, talking about the regulation. Same thing with space. I can go on telling space technology. You all know that, on 4th October. I'm trying to link up, law technology. On 4th October 1957, so former Soviet Union successfully launched Sputnik 1. Then after that, so many developments. How technology is happening, I'll give in a minute. So after that, we talk about Yuri Gagarin was the first man in the, space, moon, and space station, space hotel, colonization of space, space tourism, all these things. And why I am talking about, these are the developments which happened with this kind of technology. Today, I can tell you, with all these developments, humanity is solving many problems through technology. That is the kind of dependency humanity has technology. But you may ask, what we have to do with technology. The moment when I say 4th October 1957, 14th November, within 2 months, exactly 40th day, United Nations came out with the General Assembly urging humanity to use this technology for betterment, comfort, peaceful world. So what I mean to say that the moment technology happens, law follows, and what we call techno-driven laws. The moment, whether the air law, space law, defense law, maritime law, forensic, all these things are technology component is very much, and rightly today we are in a multidisciplinary world. There is no doubt. We have to depend on other disciplines. So this is one important. Yes, I agree with Professor V.C. Garu is mentioning about India. Today, definitely we are aiming for, India is in transition for transforming a developing country to developed country. Today we are in transition. Transition for what? A developing country to developed country. A third world economy to third largest economy. A importer economy to exporter. I can go on. This kind of transformation to become a developed country, or Vikasit Bharat, or Telangana rising 2047. Definitely, friend, there is no hesitation in saying that today whole world is eyeing on India, viewing on India, looking towards India. India has a greater response. Why? Because we have to supply. Because I can see a lot of students, so I want to speak a few minutes about India has a greater responsibility, and India is going to play an important role. You all know that, those who possess technology, those who possess knowledge, rule the globe. 19th century belongs to Europe, because of their intellect. And 20th century America, 21st century, Asian century are more particularly countries like India. I am sure, again I am telling you, if not politically, if not economically, India is going to rule the globe in human resources. Because, VC was mentioning about youth population. Today friends, India is the youngest country in the world, youth nation of the world. 65% of the population is 35 years old. And I am happy to share with you that 50% of the population, almost 600 million population is 25 years age, where you all come into. That's why definitely we are going to influence. So, and education system is going to play important role, because India has to supply human resource to the global society. What kind of human resource? Skilled, unskilled, semi-skilled, super skilled, all kinds. That's why I think we as educational institutions have a greater role to help fill this gap. Yes, recently we had a last 5-6 months as a chairman Higher Education Council. I am having a meetings with all the vice chancellors and Department of Education. we are seriously working towards that, how best we can bring the relevance of education, particularly keeping in view global needs. And today's paper, if you look at, all universities are now coming out with their, 100 days plan, and how we can bring the changes in the next semester, at least, by June, July. So we are all, with the help of Vice Chancellors and Education Department, and particularly directions from the Honorable Chief Minister. You all know that he is also, Education Minister. That's why we are all trying to, see that improve the education system. Yes, definitely there are challenges. I'm not going to tell you that, rosy picture. There are challenges in recruitment, infrastructure, all. In spite of that, I think we have to take a lead. So because India, again, I'm telling you, being a youth country, we 2 to 3 decades are our decades. Okay, next to 2 to 3. Our decade only when we give good education, good youth power. If not, we fail. So that's where all thinking is happening in the central level, or otherwise even in our state also. So last point, yes, technology law again. I don't want to, because you are going to deal next to 2 days only these things. But this is a very important. Lastly, opportunity. I said, I can see my young law friends. There is no dearth of opportunity. I can tell you as a law person, I live with the statistics. From deep sea bed to outer space, you name any area, I can give with the statistics. You can Google it. And deep sea bed, when I say one maritime sector, you see, Prime Minister Modi released a document called Maritime India Vision Document 2030 in December 23. That document, it's a government document, you can do it, says 3 lakh crore investment through public-private partnership in maritime sector, 20 lakhs jobs. You want that? I can go on telling, aviation, space, defense, maritime. There is no depth, but only thing is that we have to fill that gap. That's why we as leaders of education sitting here with the Vice Chancellors and others also, we are trying our best to see that next academic year, we are trying again. There is a long way to go, but I have a good team of young, dynamic Vice Chancellor, all universities, including Professor Kumar is here. We are working to make the higher education better, to keep not only Indians. So today, education system has to be one thing. Reality is that we are facing global competition. Yes, competition. Your friend is sitting, your neighbor is not competing with you. We have to compete with the globe. That's why our syllabus keeping in view of the global competition, industry needs. This kind of initiatives we have been initiated. We are trying our best to see that. Yes, lot of transformation today. Education system, legal education is no exception. Globalization, liberalization, privatization, digitization, COVIDization. You all know that. So how COVID impacted education system? Last 5-6 years. If I say globalization, liberalization, history for you. But when I say COVIDization is a friend. It's a coinage by me. I don't say I discovered, invented, but as a scholar I am using how global society influenced because of globalization. Same thing is going to happen with the COVIDization or COVID pandemic, COVIDization. And you all see last 5 years how impacting the COVID, all. I don't think any industry, anybody, any country is escaped from the COVID pandemic. Maybe there is a degree of difference. Somebody more, somebody less, some industry more. But education system affected a lot. That's why I'm telling you exactly. So all these things, challenges are there. But again, coming back to forensic law and science, I think this kind of interdisciplinarity is a very important. And once again, I congratulate the organizers for choosing a topic of topical importance, and I wish you all the best. Thank you very much for being here.
Now I request Professor Kumar Molugaram Garu to felicitate our chief guest, Professor Balakrishna Reddy Garu. Dr. T. Aparna Garu and Professor J. Achyuta Devi Garu to felicitate our remaining dignitaries. Now I request Dr. M. Pallavi ma'am to give a vote of thanks.
Good morning all. Respected Chief Guest, Professor V. Balakrishna Reddy Sir, Honorable Chairman, Telangana Council of Higher Education, Professor Kumar Molugaram Sir, Honorable Vice Chancellor, Osmania University, Guest of Honor, Professor M. Venkateshwaru Sir, Head and Dean, Faculty of Law, Osmania University, Professor G. Sudarshan Reddy Sir, Secretary cum Correspondent, RBVRR Women's College, Professor J. Achyuta Devi Madam, Principal RBVRR Women's College, distinguished faculty, invited guests, participants, and my dear students. I, Dr. M. Pallavi, Assistant Professor Forensic Science, RBVRR Women's College, take this opportunity to propose vote of thanks for this inaugural session. On behalf of PG College of Law, Osmania University, RBVRR Women's College, Naranguda, I express our deep sense of gratitude to our Chief Guest, Professor V. Balakrishna Reddy Sir, for gracing this occasion and for his inspiring address, which has set a meaningful academic tone for this workshop. Your insights on the role of higher education and the evolving interface between law and science will guide our deliberations over the next 2 days. Our heartfelt thanks are due to Professor Kumar Molugaram Sir for your presence. And today it reaffirms that importance of interdisciplinary engagement for the advancement of legal education. We are equally grateful to our guest of honor, Professor N. Venkateshwaru Sir, Head and Dean, Faculty of Law, Osmania University, and Professor G. Sudarshan Reddy Sir, Secretary cum Correspondent, RBVRR Women's College, for their gracious presence and warm words of motivation. Your continued support has been instrumental in enabling us to organize a national level academic event on such a contemporary and a relevant theme. A special note of appreciation goes to our convener, Dr. T. Aparna Madam, Principal, PG College of Law, our co-convener, Professor J. Achyuta Devi Madam, Principal, RBVRR Women's College, and our beloved HOD, Dr. V. Jeevan Jyoti Madam, Head Department of Chemistry and Forensic Science, for their tireless effort and meticulous planning and dynamic leadership in bringing this workshop from concept to reality. Their coordinated efforts, along with those of organizing team, have ensured a seamless and dignified inaugural session. We sincerely acknowledge the support of Rashtriya Uchatar Shiksha Abhiyan for funding this workshop and thereby facilitating meaningful discourse at the intersection of law, forensic science and justice delivery. We also thank the authorities and the staff of Professor G. Ram Reddy Center for Distance Education, Osmania University, for extending their cooperation and providing excellent infrastructural and logistic support as venue hosts. Our gratitude extends to all dignitaries, resource persons, members of legal fraternity, media, fellow colleagues, research scholars, and students who have taken their time out of their schedules to be a part of this inaugural session. Finally, our appreciation for the dedicated efforts of organizing committee team, technical support team, non-teaching staff, volunteers, and student coordinators. Once again, I thank each one of you for your valuable presence and support. We now look forward to 2 days of insightful sessions. Thank you all.
take the privilege in introducing ma'am to all of you. I, A. Shravya, Assistant Professor from Department of Chemistry and Forensic Science, RBBR Women's College, Narayanpura, Hyderabad. It is a great honor and privilege to introduce our esteemed guest speaker, Dr. Sharada Avadhanam ma'am, a distinguished forensic scientist, academician and administrator with over 37 years of exemplary service in the field of forensic science. Ma'am holds an MSc in biochemistry, MA in psychology and LLB, along with several advanced postgraduate qualifications in cyber law, advanced software technology and total quality management. She has served in key leadership positions including Director of Andhra Pradesh Forensic Science Laboratory, APCFSL, and Head of Forensic Science Wing at SPTNPA. She played a pioneering role in establishing the first DNA laboratory in APFSL, setting up the Regional Forensic Science Laboratory at Visakhapatnam, and leading ISO certification initiatives. Ma'am's contributions to forensic investigation, particularly in DNA identification and crime scene management, are widely recognized. An accomplished author, she has written numerous books and training manuals on forensic science, cybercrime, NDPS, asset forfeiture, and digital investigations. She has conducted national workshops in collaboration with organizations such as UNODC and has trained IPS probationers, police officers, custom officials, and judicial officers across India. Ma'am has published many papers in various national and international journals. Her work has earned her prestigious recognitions, including the Ministry of Home Affairs Merit Award for Excellence in Forensic Science and the Best Teacher Award from American University and HMTV. Today, we are privileged to have you, ma'am, with us as a visionary leader and expert among us to share her valuable insights. Now, with this brief introduction, I welcome ma'am to give her session. Thank you, ma'am.
Good afternoon, everybody. I deem it a great privilege and honor to stand before you, whatever little knowledge I have. I believe strongly knowledge enhances when you share it with others. So, with this motto, I am here today, and the organizers have already given my introduction there. But then I have the advantage of interacting with almost all the stakeholders of the criminal justice system, namely the prosecutors, the judiciary, the police. Of course, police has got a long association with them, both at the state police level and also the IPS officers to get trained and books in other relevant areas. And I have the great fortune of working as the HOD of forensic unit there also. So, both in teaching as well as in mannerism, maybe at times you see little reminiscent tendencies of people also, that's only by virtue of long working with police, perhaps. Coming straight to the topic that is given now, keeping the heterogeneity of the group in mind, because I was told about both the lawyers, some of those practicing lawyers, and then of course some students of law and students of forensic science. So forensic science students should not thus be saying that why is she touching upon the basics or fundamentals. It is for the benefit of the law students who are there. Now, some law basics I will be touching upon, and same is the request to the law fraternity also here. They should not feel that it is too insipid by issue touching upon basics, fundamentals. We are at a different level, we are at LLM now studying. It's too basic, they should feel. So just to merge these two groups and then bring them on one single platform, I will be touching upon only the basics and fundamentals. Now, to understand the status, first we need to understand forensic science first. Introduction. What forensic science is. Now, why people are in these days talking too much. Now, all our knowledge as a layman, lay person, comes from the TVC, CSI, Science and Investigation. It's not as dramatic as shown in TVs. It's a very tedious job. It's not that easy. And things what are portrayed in TV are something different from reality. So let me just give you this point. Now, forensic science also, we all know, is progressing by leaps and bounds. Now, let me just give you the journey of forensic science, yesteryear to current, imagined future. So that way you will understand the better the status or the position of forensic science in the criminal justice system. Now, we all know that yesteryears, I'll be showing PowerPoint no doubt, but let me just give you a glimpse of that when something is missing. So that gets covered up by the lecture. PowerPoint is anyway there, it will be shared. Now, the yesteryear, if you try to compare the status and position of forensic science yesteryear vis-a-vis today's positions. Now, it was, the forensic science was stated as a very rudimentary science those days, yesteryear I'm talking about. And then it was almost supplementary or as an adjunct to the criminal justice system. Now, and it was deemed that it is neither on the side of the prosecution nor on the side of the defense. The popular notion was because these people, most of the labs, fortunately and unfortunately, happen to be under police. So people have a misconception that their reports are taken, whatever report the forensic science lab gives, it is somewhat biased because they are under police. They dance to the tune of the police. So definitely they are all in favor of police. That is the misconception. So what I will say is, the position has not changed. Yesterday, or today, or tomorrow, it is going to be the same. That means it is neither the side of the prosecution nor is it on the side of the defense. The golden mean, the truth, lies with the judicial. Wherewithal or infrastructure or manpower or money. So we used to ask them, send a vehicle, will come. So sending a vehicle is again a problem for them. So that was the position, almost optional, at the mercy of the investigating officer. If they want us to call, they'll call. If they want to dispense with calling somebody, if they feel that's the next chapter for them, dispense with this. That was the thing. And our job was mainly restricted to the four walls of the lab. Within the four walls of the lab, we were doing some analysis. Material objects, so-called, that were collected by the police. Don't think that I am against the police. I am only trying to talk to you the reality, ground reality. Now, whatever they feel like this, they are not experts in that area. I am not going to blame anybody. That is not their core area. So he was asked to, or she was asked to, collect the evidences, because the backbone of criminal justice system is evidence only. So, whatever that occurred to their knowledge, they were collecting so-called evidences. And what was the method that they were adopting? Their own methods. There is no reasonable doubt in what is expected. Wilmington and all, we know it doesn't belong to that trade. Some kind of a vague report they give. So, any report which is not substantiated, after all it is an opinion, you need to understand. The inherent weakness in the forensic evidence we need to understand. Just because I am a forensic, I am not here to say that forensic is panacea for it. We are only advisory. We need to remove all my forensic fraternity here. We have to understand, including of course, and I also did law, I can also say law fraternity is also mine. So, we need to understand that it is only advisory in nature. Adjudication is not your duty. give the duty to the judicial. They are the ones, isn't it? So, and just because judge is not conversant himself with some areas, foreign law, handwriting, examination, ballistic, serology, some areas he is, because he is a gentleman and he is a knowledgeable person in law. You can't expect judge to be expert in all fields, isn't it? For that reason only our 45 is there to help him out. When there are issues before the court pertain to some scientific knowledge, some areas which are very specifically written in the Evidence Act or the BSA. So in those areas if he has to offer his judgment, give his dedication, then definitely he did not become an expert. An expert is already available, as I call him. Though he is offering an opinion, he is not giving his personal opinion. Based on some scientific method, some procedure, which is time tested, validated, reliable. These qualities should be there for a method. And you should amply demonstrate. Mere throwing the report on the face of the court is not sufficient. It will not get. Because it's an opinion. And he is a witness like any witness. Maybe he is not a factual witness, but then whatever criteria apply in the eye of the court for a factual witness, equally apply to the expert also. Equally, that means he will be subjected to credibility test, sufficiency test, admissibility, trustworthiness. He will be asked all irrelevant questions also. Cross-examination. Defense has got enormous power. He can ask irrelevant questions which can increase the character of this expert. So like any other witness, we also have to undergo this. But for that we need to understand the court domino. So unfortunately, in the morning also, the dignitaries in the dais, all of them in unison told that this kind of intricacies, understanding the lacunae of one stakeholder of the criminal justice system by the other is wanting and lacking. For example, the forensic scientist, he is good at experiment. He is an expert in doing analysis. But when it comes to court, when he has to depose his evidence, never in his life he has seen court. Maybe for the first time, as an incumbent he is coming, he doesn't know how to answer. If you ask him some technical thing, he is expert. But then to shake his credibility, that is the job of the cross-examiner. Without his understanding, what kind of verdict is he going to pronounce? So it is very, very essential that the language of the report should be very, very simple, without any jargon. So here I want to give another example. I will take my own example by others because I have enough experience and report my knowledge. So in one particular case, it was a serology report, as you all know. Serology is nothing but blood related report, some murder case. So, I don't think some of you had the fortune of seeing the reports also. I don't know, most of you may not have the chance of seeing. But then if you see the report, it is in two halves. The first half will say, because the material objects are numbered, MO1, Exhibit 1, Exhibit 2, so on and so on. So, the first half will say that blood is detected in Exhibit 1, 2, 3, 4, in so in whatever item is detected, we give the number and then we'll say blood is detected. But you may not get blood in all exhibits, though apparently it may look to the eye that there is red color and all that looks red need not be blood. You need to understand that also. Otherwise the constable himself says this is blood, human blood, ठीक है, lab to देखने की जरूरत ही नहीं है. So that is the case. Whatever labs are existing otherwise. So in the first half, as I told you, so and so exhibits blood is not detected. Okay? Then second half, the blood that is detected in the above mentioned exhibits is human. And blood group of these stains could not be detected because it got disintegrated. Please underline the word disintegrated. Then the court, the judge says, Are you the same expert who has done this? With all humbleness, I only did it. Then what is your statement in the first half? You said blood is detected. Okay. But in the second half, how can it disintegrate? Because he taken the literary lexicon dictionary meaning. Disintegrating meant disappearing. You yourself said that it is present in the first half. How can suddenly it disappear, vanish, disintegrate? Then I have to tell him, sir, this is a jargon that we use and it is a common word used in the entire fraternity forensic. It doesn't mean that it has disappeared. The ingredient that is required to say that it is blood, or for that matter that it is human blood in particular, got faded away, vanished. I didn't do my law. I have not gone through beyond one. 293 one beyond, there is also 2 clause, I didn't see that. So nice day I was taking exemption under 293 one. Got a summon from a place which is very far Icha. So I said as usual, wrote self-explanatory, hence my personal deposition may please be dropped. Sent her. She was also a lady judge. The ladies are very, very particular about certain things. So when I said this, second time, arrest warrant. 2 times I think I have denied, but then third time I and then I picked up phone and then tried to contact this gentleman, public prosecutor there. Sir, what do? I got this. How serious is this? Because I am also new to court proceedings. Then she said, ma'am, this is a very serious matter, so better you come down. So what I did, took all the reports and then went to that court located in Icha. Now, I have shown my face and all thinking that I am expert, she will oblige and then she takes my testimony first. So she was in a different mood. Let me teach this lady. She thinks court is so simple and all, why is she giving? Why didn't you present it properly? What is the conclusion? How you have arrived at that particular conclusion? What are the methods that you have adopted? Whether those methods were tested, validated, are they reliable? Have you subjected that to the peer group for this thing? They also got the same concurrent results on that. Only then it will work. Otherwise, no. Now, this was the scenario as to be. But then, thanks to the new laws that have BNSS, PSA, and Nyaya Sanhita, thanks to that, So whatever Malimat and other law commissions have suggested, time and again, they were incorporated in these laws. And then now forensic science position now, if you see, it is somewhat better, I would say. It has not become best. Those days it was a luxury using forensic science. So the luxury because we have to send him the vehicle, feed him when he stays for some time. That's all luxury. But then now it has become a necessity. Those days it was only luxury, but then now it has become necessity, mandatory. Statute mandates. Now we know that there are different processes in the criminal proceedings, right from investigation, probably 2 hits done, now 2L may be in BNSS. Now investigation, then the inquiry. Okay. Now, so as I said, the forensic science used to play only a very limited role in the investigation. That too at the circumstances, as I told you. Now it says crime scene management, because crime scene is the crux of every, the backbone of every case. If the crime scene is mismanaged, your case is gone. You may have a very sophisticated forensic lab, you may have a very talented kind of a police officer who is very good at interrogations, encounters and all will be futile. If you mismanage the crime scene, what do you understand by mismanagement? So I said, right kind of material in the right hand, sent to the right man will yield good results. Otherwise, a wrong man handling a person who doesn't have any knowledge, he handles that. What will the reputation? Your report will be thrown because ego principle, what you give, only that comes out. You give a bad thing, bad thing comes out. You can't expect giving a bad and expecting a good thing to happen. It doesn't happen. You may say that the crime scene management, if it is done in a proper way, will have its own merits. Now, thanks to the BNSS, it gives you, at least in serious cases. Now, the present status of forensic science laboratory is not, it's not at a very happy stage. It is still somewhat progressing, I should say. But some facilities may not be there, depending upon the state exchequer, it may have some facilities, it may not have. So, to give a room for that, the statute itself says that at least in serious cases where 7 years punishment and above, if such thing is there, at least you have the forensic scientist coming to the scene to assist you. Because these days, crimes are driven by technique-savvy person. They are too technical. Criminals are more technical rather than the real expert himself. Okay. Because we are reactive, not proactive. He is proactive. Criminal is proactive. Okay. So, that way, we said, the act very logically said, at least in serious crimes, have your expert, call him, he'll assist you. And they said, don't buy a very high-end kind of a mobile laptop and no need. Your mobile nowadays is good enough. Even the vegetable vendor carries a good mobile. Mobile is good enough. As long as you correctly take it. Your accountability should be there. Your genuineness should be there more than using an equipment or a gadget. Your genuineness. And lot of fairness, transparency, along with the law it comes. Not only for the police, for the scientist, for the judicial also. There is a time frame within which you have to submit everything. Whether it be taken cognizance by the magistrate or pronounce the judgment, whatever it is. And you need not struggle yourself. Say, I am a retired person now, forensic scientist. You cannot call me again because the cases which I have done a lot of years back, I can't remember, I don't have even access to such files now. Even if I go, I am a retired person. Nobody even may recognize me at times. Who knows? So, I don't have the access. And I don't keep a record of all cases which I have done. They may be there in the office. Isn't it? But for such people also, they said audio visual. Good enough. A lot of importance has been given to electronic evidence and digitizing the entire thing. And thanks to the Data Protection Act also we have enacted that also. Isn't it? So a lot of things have come in their own way. You know, whether it be BNS, BNSS, or for that matter, Nyaya Sandhita. So we are given lot of things. And then why some of these things? Earlier if you see the amended version of Identity to Prisoners Act, if you say, now testimonial compulsion also is one thing we have to remove. Constitution also, we are bound by Constitution. Isn't it? So some rights are given to the accused also. Testimonial compulsion in Article 21, 20, bracket 3 and 1. And if somebody wants to remain silent, I cannot force. I want to, Nandini Saraswati case, I remain silent. You cannot force me. I want to remain silent. Now, and privacy. Privacy is very, very important. Somebody cannot intrude into my body without my consent. I'll say, there are tools. Instead of using a third degree, let me use some DDT. What your DDT? This deception detection techniques. DDT is not our DDT, deception detection technique. So they said, the forensic community said, it's a good alternative for third degree. Instead of using a third degree and getting the confession, that is not admissible in the court of law. Why use your manpower, muscle power? Instead go for this alternative. But then, if you see the judgment of Selvi and others versus State of Karnataka, they have clearly said, it is an investigation tool only, to that extent you use it. Beyond that, caution, word of caution. Because you are intruding the privacy of somebody. See, whatever consent you are obtaining, this is when you are making the person unconscious by administering some intravenous kind of an NDPS, so-called sodium pentothal. A consent, when did you take? Before injecting, you have taken consent. For what? For information which is going to give you after the, under the influence of drug. How far is that valid? Is the question, $1,000 question that has been raised in this Selvi case. They said out of the 3 tests that are very popular tests to detect a deception detection techniques, polygraph, in colloquial language lie detector, then comes your the narco test, and then brain mapping test. So they said of all the 3 tests, since the narco test has got a lot of limitations, the word of caution, they said. Why word of caution? Now, NDPS, mere possession, small quantity for personal consumption, is offence. If that being the case, on one hand you are enacting a law which prohibits or penalizes somebody possessing even small quantity. How is it relevant? How is it logical to inject somebody with this narco and then making him unconscious, subconscious, and then trying to extract information? How far is it? Are you not violating his privacy? Are you not intruding into the privacy? So that is one objection. Now, then after all deliberations and the long arguments and all, they said, yes, it can be taken as a tool. Now what happens under 27 old IE Evidence Act? Old Evidence Act, some discovery of a fact, new fact. So, in his narration, when he is under the subconscious state, whatever narrations, whatever revelations that he makes, if suppose that can be verified, objective. For example, Telgi case, Telgi scam, all of you are aware. So he is the first man on whom they narcotics in Bangalore, etc. Of course, later on, her own credibility was lost, and that's the difference. We are not here to discuss that story. So, she did that narco analysis on him, just to know who are all the politicians who are involved in helping this guy, how the entire case has manifested itself, and then how that has been unearthed and all. So long duration of narco analysis has been done on him, and then he came out with some revelations. What were the revelations? Who are all the people to whom he gave the bribe so that he has the facility in jail to talk to people outside and then get his things done, no? And then who are all favoring him, investigation level at different levels. So there was some questionnaire being prepared and then that was administered to him. And then he gave all revelations and then he also said, I have deposited some money and all in the banks of so and so politician, not to take the names of politicians anyway. So I have done. He took the names, but I am not here to take their names. That was there. And then they said, it's an investigation tool, better than that deed. Better than that deed, and that too, it doesn't have any validity admissibility in the court. So there is a scientific method we use it. So in that they said, I have given money on so and so date in the form of so and so check, and I have deposited so and so bank in the name of so and so somebody. So if I can go verify as an IO, investigating officer, that on that particular day there was an entry in the bank account, so called, and then it is a fact. So it is discovery of a fact. So under that you can use it. Verify the fact, whatever utterances that were made by him, revelations that were made by him, you verify. And then if it is, you can prove, bring that as an evidence, it will be allowed. That's what they said. And all others, you have to, it has to be, consent has to be there. Without consent you can't do. You can't force somebody to undergo some test. Of course, they said again blood, vomit, urine and all, as a matter of routine, you can take. Because it doesn't come under testimonial compulsion. It doesn't come under giving a sample for a blood sample for profiling, and it is not at this stage, you cannot invoke Article 2 violation of Article 2. Okay. So, this Selve case and later on some other judgments also, it is very clear that you can use, provided there is a consent, there is a permission in the court that you can do. And I don't know, for some reasons now, South FSs are doing this. Only the North, that too, Gujarat and all, maybe the blessings of so and so, maybe they are able to convince the court, they are able to do a lot of these cases, polygraph cases, the narco analysis, they are doing and courts are accepting, I don't know why they don't have any objection. So they were doing it. So that is about these things. So what I mean to say is, forensic report, forensic science, for that matter, if you see the status, it remained the same. Only thing, some importance is given at the investigation stage, where they said, everything has to be transparent. How will you bring in transparency? Judge is sitting in his chamber. I am sitting in my lab. How to bring the transparency? How to, unless your work is being judged, how are you going to bring in this transparency? They said audio visual. Entire crime scene management has to be taken audio visual. Make a backup and then take. So somebody will say, backup you have taken. What about somebody manipulating that also? Internet people. So they manipulate, then they said hash value. Maybe some cyber expert you also have in the session, he will be able to explain what hash value is, how to convince the court that whatever you have collected from the scene is the same thing that you have deposited in the court. It has not been altered and all. So, if you want the forensic evidence to be accepted, because we are talking about the mainstreaming of forensic evidence processing right from the crime scene to the courtroom, that is what is happening, that is the evolution that has come in now. So for that, they said, let there be some transparency element. So whatever you do, let court also observe that you are doing it in the crime scene only, you are not manipulating that in your police station. Asking somebody to come. There is a material object so called, which they said they have collected from the scene. Touch it. For some reason that fellow has been brought in some other case. So that fellow will be asked to touch it. See his fingerprints. Those days are gone. Everything is transparent because whatever you do, you have to audio record it. You cannot bluff somebody. And there is a time frame. There is no scope for you, no time to manipulate. Not even think of some manipulation. So time frames are so fixed that you have to do everything within time. Even the examination of a rare victim, there is a time bound. No one have 20 days, have 1 month and all. By the time she must have washed her clothes, she must have washed her private partner, nothing is done. 7 days time, that's it. So for everywhere you see, to bring in fairness in trial, fairness in investigation. You cannot expect a fair trial when there is absence of fair investigation. Everything is so linked. Interdisciplinary. I cannot say that I am forensic scientist, nothing to do with the law. I'll close my eyes when it comes to law. I am not aware. I can't have the luxury of saying that now. I need to understand. Because I am also playing a very important role as a forensic scientist in the entire gamut of criminal justice system. A very key role, a pillar, central pillar position I am occupying. Because even in investigation I am involved, because I have to accompany because I told you cyber crimes and all, there are technical, too technical. The policeman cannot understand, though he is also trained and all. Just because there is dog and ass, dog is capable of doing ass work, let dog do ass work. It doesn't happen. Ass is as, dog is dog. So that way, even if you are trained and all, it is good. See, the disadvantage is, you may say, taking a photograph, mobile, obscene and all, everybody can take. What is so great in it? See, if I say and if I as an IO, if I do everything for myself without involving the expert, whatever questions that are intended for you, for the expert, are going to be bombarded to you or not. It's not simple taking the photograph. Why you have taken, what is the relevance, under what provision of relevancy this particular thing. I say I have taken the map. What for? Is it relevant? I should be able to tell under what provision of law this is taken. Some struggle marks and all. What does that indicate? Proof of presence, proof of association, proof of contact. These are all established. Why there is 5 to 52 old IE? Why there are so many? Who doesn't have time to look at all irrelevant things and waste their time? As they are also overburdened. So there is a law of statute itself is that when it is irrelevant, throw it. No, outright throw it. Need not examine. Though if it is irrelevant, don't waste time. Only if it is relevant, take it forward. Okay. In appreciation of the evidence also, there are stages. They say first, see whether relevant, admissible, sufficiency. Whether it is, if it is not sufficient, I can ask for some more corroboration. So we need to understand that forensic science is only supportive, supplemental, and it is corroborative in nature, not substantive. Please, my dear friends from forensic fraternity, understand this. You may say DNA and all wonderful and all, very good, 100%. All okay. When there are procedural lapses, when there are lapses in chain of custody, very, very important. Because you are not the only agent who is handling the evidences. There are a lot of stakeholders who are handling this. From crime scene to the courtroom, it reaches, there is a very long journey. So, at each stage of handing over the evidences, you need to focus on the chain of custody. Who are the authority to hold this? Whether they were holding it in a proper way, whether some manipulation has happened in that, some tampering has happened. So, court is going to, because this is all procedural, CRPC is the entire procedure. Your Nyaya Sanhita, Suraksha, Nagarika Sanhita. It looks into the procedure. When there are lapses in the procedure, whatever may be the outcome, they are not going to accept it. They are not going to accept it. So, you have to be very, very. They said forensic evidence can be accepted. There is a right for police state, there is a DGP kind of a thing. So also we have some chief forensic scientist sitting in Delhi. So he monitors all this. He said it is now mandatory, since the new law has come, where 7 years punishment more than a forensic scientist are required to be present. You need to do an auditing of your lab. Auditing of the lab. What do you understand by auditing? A third party verification. Okay. So third party verification is called accreditation. Accreditation. So courts are also now vigilant. They say, is your lab accredited? Let us say there are 2 reports on the same evidence, 2 different reports from 2 different labs. Let us say. Now one lab is accredited, the other one is not. Now you tell me genuinely which report will be accepted and why. Or is there What difference does it make whether it is accredited or not accredited? We don't mind. How many will you say that it will be unanimously accepted, or with some doubt it will be accepted, or the third category is not accepted or rejected completely? Should it be rejected just because the lab is not accredited? But not all states have the facility of spending a accreditation doesn't come free, nothing, no free lunch in this universe. So it also requires some money. Auditor and all need to be paid, isn't it? So my state is approved, I don't have the facility of accreditation. You are going to just judge me on the basis of just because I am not accredited, are you going to reject my report? So what should be the weightage that should be given? That's what is the point. Should some weightage be given to the accredited labs vis-a-vis non-accredited labs, or what should be the thing? Should it be rejected? Should it be accepted? Partly rejected, partly accepted. Like we have partly reliable, partly unreliable, wholly unreliable witnesses, some kind of a thing for this also. Now accredited labs, because a third party comes and validates. It gives some kind of a transparency, accountability. Right? So they will not come and then tell you that I am going to inspect these areas, these reports keep ready, or these files so alone I will be asking, please update somehow, do manipulation, and when I come, they should be perfect so that I can give a perfect audit report. It's not like that. So they will thoroughly check your procedures, your files, everything, whatever document you make. You have to do it, whatever is mentioned in the document, you have to do it. Whatever you do, it should get reflected in the document. That's how you do it. So naturally, that is the kind of precaution some lab is taking. Definitely some credibility should be given. Do they think that some credibility should be? I cannot outright reject it, but then I can have this kind of a introspection when I see a report generated by accredited lab vis-a-vis a report generated by non-accredited lab. So this is something which we need to remove on. Now, how much time is it? So we will go through the PowerPoint and then try to understand more, or you want only this kind of feature? I think the PowerPoint to finish. Whatever I said is there in the PowerPoint. No problem. So somebody can help me because I can't see that. I'll take my hard copy. Something. Can this be on? Am I audible now? So what does it say? Application of scientific principles. There are some scientific principles, and whatever matters that are there, it may be fact in issue, relevant fact, whatever, some dispute is there before the court. Now with the help of forensic science, what I am trying to do, I try to apply. I have already some principles, procedures. I try to apply these things to the matter which is already there before the court, and then I try to analyze that and then generate reports which are reckoned as pieces of evidence, plus expert evidence is admissible in the court of law. It's relevant under the Evidence Act. So I generate reports, and then based on the reports, which are of course advisory in nature, it will guide the court in arriving at a conclusion and then giving some weightages, because the job of the court is that of a gatekeeper. When it said, Robert he said that the court will act as a gatekeeper. It doesn't allow everybody to get in. So they try to apply some yardstick based on that is relevant, admissible, and which is sufficiently been proved by the court. That is a, so he is acting as a gatekeeper. So these principles are applied. Now how is it helping criminal justice? I told you yesterday, let us not talk about history which is gone. Now, the present status is detection of crime. Some prosecution leads it is trying to give. So, I was thought that a particular case is a suicide. Because it's a 304 case, 488. So, the gender presumption is in-laws, some priority, harassment, this and that kind of a thing will only come. Those presumptions will come. Now, it helps by looking into, let us say, the suicide note left by the disease. Now, there are some, she is in the habit of writing some daily letter, regular letters to the parents. So let us see that. Now, the expert goes there, because now experts are not restricted only to the four walls of the lab. There is field forensics, what is new. Thanks to again Telangana police, they are always in the forefront. They have developed a concept called CLUES, Crime Laboratory Ultimate Criminal System, where some of the lab experts are trained in crime scene management also. And recently Karnataka has also followed the concept of Telangana, where you will be surprised, all forensic scientists, it's a good news that they have recruited almost 200 people in one go as scientific scene officers, So they are now, as per the new law, they will be going to the scene, they will be given vehicles, no dependency on police anymore. So they have their own vehicles, their own communication tactics and all. Even before the policeman reaches, it is the scene officer who reaches the scene. And then he does the required thing, whether it is crime scene management or the accused management or victim if she is there, some counseling, that kind of a thing, helping the police officer, collecting the right kind of evidence. And if they have gone with some, so they were under the presumption here, it is suicide, because there is a suicide matter. He goes and verifies the writings, diary writings vis-a-vis the so-called planted kind of a suicide note. He said, no, these are not our writings. So we doubt. So they come. So the entire prosecution story takes a different turn altogether. So that's how it helps detecting. So he is going in one path and then the expert comes and says, the wrong or the other. It is not suicide. It is planted as it is suicide. So that's how they are identification of the offender. So there is a serial murder happening. I don't know, sometimes some years back, there used to be one offender, very typical offender, who used to target the victims, who are lone victims, outskirts of the city, lone victims, and then in villages, rural scenario, people, especially during summer and all, they sleep outside, he doesn't touch them. So such serial murders have happened several in them. And he had some petty offences and all, where he was caught and then he was jailed and all, he was released. So there must be some record. By way of fingerprints, there was a record. So what happened? Now, in the recent case also, he left his fingerprint. That was processed. That was sent to the Bureau, Fingerprint Bureau. Now, while searching the print, it got matched. It got a match with one of the stored records. And then when they saw it and matched, they said, he is wanted criminal, and then all series of crimes, he only is the one who did. So it helped in detecting the, because he left a typical kind of a situation, modus operandi, the way he commits the crime. He left a very clear picture. So it helped by doing the offender profiling, new concept in forensics, offender profiling, so the identification of the offender can be achieved. Then collection, preservation, examination, interpretation of this. Collection, examination, and then analysis and interpretation. So this is where the court is going to view the report in a very, very critical way. As I said, you give the first in the preamble, what is the preamble? So exhibits are received from so agency, they were examined, and this is how the report. And there is a series of tests, battery of tests. Will not stop at one test. Series of battery of tests, both preliminary, confirmatory, screening, all that has to be done, and only then will do it. And I need to write that I have done these experiments, and the outcome of that is in the form of a chart, or it is in the form of a machine-generated kind of a graph. Please peruse it, isn't it? And this is it. So interpretation of the report is also that also it goes. Now, acts as a bridge between science and law. So what exactly is doing? There are some matters before the court. There are some gray areas for the judge. He wants to understand that. He employs the expert and then he is able to explain his report, interpret the report, and then establish the connectivity between the criminal and the crime scene, or the relation between victim and the court. Why on that particular day, why that particular person happened to be there in the scene and all, he is able to give. Now, converting physical traces into legally admissible evidence. So legality, admissibility and all comes at a later part of it. How are you able to convert this particular trace? First, every contact that gets established, there is a exchange of traces. This is what is the fundamental principle of law. So every transaction, whether it be between inanimate things or animate inanimate things, between two inanimate things, something is going to happen. Some activity, as long as it is there, some exchange will definitely happen. Okay? Now, it is for the expert to see what is the trace, or is it in bulk? What is that getting exchanged? For example, now in a scuffle that ensues between the victim lady, in a case of rape and murder, between the accused and the lady, you see that there is a tuft of hair, head hair of the accused. She doesn't perhaps pluck her own hair, no, this is what she plucks in the process of study, but some of the hair, head hair of the, if compared to ladies, then hair is. So she will catch hold of that, and then somehow they are entangled in the case of the lady. If I can establish through my report that, and of course as a process of investigation we have rounded, because we know that they are the habitual of notice of the locality, so they rounded up some few people, suspects, and then they want me as an expert to say whether any of these persons' head hair is matching with the hair that is there in the cleavage, the fist of the lady. That is what they want. Now, what I try to do is, I try to examine all these things, and then suppose suspect one is dismissed. So I give a report. So the interpretation of that is what? Why his hair is there in the lady? Of all the people in the universe, only why his hair is there? What is time up? Oh. So this goes on. Say, the moment you said, the essence of it I have already told, because it is such an ocean within half an hour, 1 hour, 1.5 hours. So we conduct training programs for months together for police officers. So I don't expect that much is required for you, but anyway, the essence of all the PowerPoint I have already shown, but I will be happy if I can get some questions so that I can, it can be more interactive, because some people I see maybe pre-lunch syndrome. They are almost, some people are sleeping and all actually, I see. But then the best way to avoid this is that let us have some interaction. Persons, if I know, I'll give you the answer. If I can't answer right now, probably I'll refer and yes. Somebody can do my so that everybody has. 1 second. Here is my day. So you can make use of this. Others are able to. I'll repeat it. Yes. Yes. See, what he says is, what is the legality, admissibility of these so-called DDTs? It is deception detection techniques. Isn't it? So, confession admissions, we have one thing. Reliability. See, okay. So, as far as the reliability.
The reliability, do they deliver a finality in terms of whatever confession the person makes when the test is conducted? Whatever confession he makes, can that be finally this is it? Of course, it will be corroborated to someone who says, like you said, the check is presented a check or whatever. That will be there. In certain cases, such thing may not be available. So what happens in such cases?
See, these tests have come as an alternative to, I told you already, third unit. And whatever evidentiary value or admissibility or reliability, whatever. Reliability comes when you do it the way it is being respected. There is a procedure for that. As long as you stick on to the procedure. As long as irrespective of who does it, as long as he is an expert, irrespective of who does it, it should give the same conclusion. Only then you can say it is reliable. Each time you are getting a different result out of it, it's not reliable. That's reliable. So, the reliability is as far as the test and the procedure is concerned. Procedure, as per the procedure laid down, if somebody does it, or give it to the subordinate who is also equally competent, if both of them get a concurrent result, outcome, then it's a reliable.
It's a careless. Ceteris paribus conduct means rest of the things are absolutely in that case.
So it is reliable. But when it comes to any forensic evidence for that matter, you are lawyers and then you are practicing lawyers, but know that it's not substantive. It's not substantive. It has to be, and it is only reliable. So these were there just because to supplement or what we call to give some strength to the evidences which are already before the court. So this is only for whatever big claims we may make. At the end of the day, it is only advisory. In time and again, in plethora of cases, not one case, plethora of cases, they said, please remember that it is advisory. You are not here to adjudicate. For adjudicating, there is a gentleman. So let him do that job. So because he is not aware in some sort of topic, you assist him. You assist, okay. You advise, okay. But rest of it, giving a judgment and a limit. But it's not the only evidence. There are eyewitnesses. There are circumstantial witnesses for that. So there are so many witnesses. Let the factual witnesses also be examined. So whether it is strengthening that or is it a contradictory one, what is that? So that we need to understand. This particular limitation what we call, it is inherent in forensic evidence that we need to understand. How different, sir? You mean to say that they are on the side of the difference? See, some private labs, I told you, some people are approaching. For example, there is a maternity fraternity. These are civil matters which nobody would like to go to the court and then expose and then become a matter of discussion. Some people want to respect the family called rich people in society who don't want to into corridor or court and all. They want some private labs to do it. Okay? But as I told you, if time permits, I will give otherwise how to do it. In that case, they said private lab we can't rely. Where the same procedure which has been adopted by the government lab is taking 10 days. If private lab says I can do it within a day, within half an hour, you can't cut short the procedure. Whatever procedure is there, you need to seamlessly follow. Because the client is paying you money, you can't say that I will cut short the procedure, I will give you within no time. Swab in, result out. As we go to urine sample analysis, morning you give the sample, evening you get it. It's not forensic reports are not that way. So, a procedure requires 48 soaking. You cannot cut short the procedure. 48, maybe in future there is some robotic doing and not, maybe you can reduce it. But not as of now. If procedure says 48 hours, 72 hours, that particular time has to go. So that is the reason why they are little cynical. When it comes to private lab report, the courts are little careful. Because government says 48 hours. How is that you can do? What method you are using? They are not able to explain that method properly. Then what is the credibility of that man? As I told you, one technician with a half an hour, he goes and does it. And then that fellow was never examined cross-examined. And then director comes. Director is a physics man. How can he answer a question related to the DNA? So, in such case, especially when reports come from private lab, so they will do it very serious and then they don't mind very good out of equity. It may be very serious case of double murder or double conspiracy, very serious case. But then they also write it in the report. We are helpless, though we have all sympathy for the victim. Prosecution has not produced the linked case. They don't do it. Yes?
Madam, simple question. Anybody
మేడం, ఇప్పుడు మర్డర్ రేప్ కేసెస్ టు detecting the semens on the woman body part, the method which was using, how many methods are there? There is a different methods are there. Which are using the forensic lab, only one method is universally accepted, and there is several methods are being using. This is the clarity I made.
చూడండి, ఇక్కడ ఏంటంటే నేను ఇందాక చెప్పే నోడల్ ఏజెంట్ ఢిల్లీలో కూర్చుని చీఫ్ ఫోరెన్సిక్ సైంటిస్ట్ అంటారు, ఆయన ప్రొసీజర్స్ కానీ మెథడ్స్ కానీ స్టాండర్డైజ్ చేయడం కానీ మినిమం రిపోర్టింగ్ క్రైటీరియా మినిమం. ఇప్పుడు మీకు బాగా అర్థం కావాలి, మనకి అందరికీ అర్థం అవుతుంది. ఫింగర్ ప్రింట్స్లో ఒక ల్యాబ్లో 8 అంటారు, ఒక ల్యాబ్లో 16 అంటారు. ఏది క్యారెక్టర్స్ ఆ రెండింటిలో క్వశ్చన్లో శాంపుల్లో 8 క్యారెక్టర్స్ మ్యాచ్ అయ్యాయనుకోండి చాలు, ఒకటిదే అని చెప్పచ్చు అని అంటాం. ఇంకో ల్యాబ్లో 16, ఇంకో ల్యాబ్లో 30 ఉన్నారు. బట్ వాట్ ఈస్ వెరీ ఇంపార్టెంట్ ఈస్ ద క్యారెక్టర్ ఈస్ సో యూనిక్ and that uniqueness is available in both the samples, hence they are. ఉదాహరణగా ఒక ట్రైన్లో పాదాలు ఉన్నాయని మీద చెప్తారు. అయితే అక్కడ రౌండ్ అప్ చేస్తే ఒకటి పాదం ఇంత ఉందనుకోండి, కొత్తగా మిగతా ఎందుకంటే రెగ్యులర్గా వాళ్ళు హ్యాబిట్స్ అక్కడ ఉండేస్తాం, వాళ్ళు పట్టుకొచ్చారు రౌండ్ అప్ చేసి. వీడేమిడే అంటాడు, వాడు నేను కాదు 3 రౌండ్లు వాడే అంటాడు. అయితే ఎక్స్పర్ట్ ఏం చేశాడు, అప్పుడు అయ్యా వాడు ఆ సీలో ఉన్నతంగా ఉంది, వీడి కాల్ చేస్తే ఇంతకొంచెంగా ఉంది, సినిమాలు బేతాడు కదా బాగుంటాయి కానీ ఇలా ఇక్కడ సరిపోతుంది. సో యూ కెన్ ఎలిమినేట్. దాంట్లో 10 లక్షణాలు చూడక్కర్లా. ఇంక నేను ఒక్క లక్షణంతోనే టైం సీలో ఉన్నది వీడు ఒకటి కాదని నాకు తెలిసినప్పుడు ఇంకా 10 టెస్టులు నేను టైం చేసేస్తుంది అర్థమవుతుంది. అట్లా చేసే టెస్ట్ చూసే క్యారెక్టర్ ఎంత యూనిక్గా ఉందో మనం తెలుసుకుని అది ఈ 2 శాంపుల్స్లో ఉందా లేదా. ఫర్ ఎగ్జాంపుల్ ఇప్పుడు ఏస్ పర్మియా అని ఒక జడ్జి అంటే ఏస్ పర్మియా అంటే ఆ పర్టికులర్ వ్యక్తిలో స్పందనలో ప్రొడ్యూస్ కావాలి. వాడు ట్రై చేయకూడదని ఎక్కడ రాయలేదు, వాడు రేప్ చేయకూడదని రాయలేదు, వాడు రేప్ చేస్తాడు. మీరు అంత స్పందనతో వ్యక్తిగా లేరు, వాళ్ళు ప్రొడ్యూస్ అవ్వట్లేదు. నేను చాలా అదే చేయమన్నారండి మాకు చెప్పారు ఎస్ఓపీలో, ఎక్కడ స్పందనతో బాగుంది వాడు ప్రొడ్యూసర్ అంటే. సో అట్లా మనం మీటింగ్లో కూర్చోలేదు. ఇది ఒకటే టెస్ట్ చేస్తే నాకు రావచ్చు రిజల్ట్. పాయిజన్ వాడు తీసుకుని దీనికి 2 సిమ్టమ్స్ సరిపోయి అనుకోండి, ఒక టెస్ట్తోనే కథ అయిపోయింది రిపోర్ట్. కానీ రెండింటికి ఒకే లక్షణాలు వస్తున్నాయి, దాని దగ్గర దర్దాపుగా రావచ్చు. అలానే అక్కడ ఆపేయండి. దెర్ ఆర్ 2 టైప్స్, incriminating inclusion, exclusion. If the report is excluding, even though there are 10 tests, I don't bother to do all 10 tests. Extra finger ఉంది వాడికి, ఇక్కడ ఎక్స్ట్రా ఫింగర్ సరిపోతుంది, అక్కడ ఆర్డర్ ఉన్నాయి, అక్కడ ఆర్డర్ సరిపోతుంది. ఇంక నేను ఒకటే చెప్పడానికి నేను ఎందుకు 10 టెస్ట్ చేయాలి? వేరే దగ్గర 10 టెస్ట్ ఎన్ని చేస్తారు, ప్రిస్క్రైబ్ చేయాలి. ఇది కాకపోతే ఇంకోటి రాదు, చాలా అన్ని టెస్ట్ చేయాలని అక్కడ రాస్తారు. The more unique the feature, the more close that feature is with the question vis-a-vis the sample. I don't mind it. I need not waste my time doing all the bad tests. అది చేయడానికి అవకాశం లేదు, ఎందుకంటే సీట్లో దొరికే ఇంత మనకి లగ్నం లేదు, ఇంత ఇన్ని టెస్ట్ చేస్తాను, 1000 రోజులు చేస్తాను, నాకు ఇంత ఇవ్వడండి అంత ఉండదండి. ఇంత చదువు అందులో నేను 10 టెస్టులు చేసిన తర్వాత ఇంకేం మిగులుతుంది? 11 టెస్టులు మిగులుతుందా? మళ్ళా దాన్ని ఇంకో ల్యాబ్కి అన్నాడు అనుకో, కోర్టు నాకు నమ్మకం లేదు, ల్యాబ్ ఇంకో ల్యాబ్ పంపిస్తాను. నేనేం చెప్పాలి, అయ్యా నాకేం మిగలలేదు, ఎవరి మీద లేకుండా పెట్టుకోమన్నాడు. యూ షుడ్ డిజైన్ సచ్ టెస్ట్ విచ్ ఆర్ నాన్ డిస్ట్రక్టివ్ ఇన్ నేచర్. మైక్రోస్కోప్లో చూడు, నీకు శాంపుల్ ఎందుకు తగ్గుతుంది అక్కడ, నువ్వు అట్లా డిజైన్ చేసి తెలియమంతా అలాగా. అంతేగాని శాంపుల్ లేదంటే అది మీద. సో వాట్ యూ అండర్స్టాండ్ ఇస్ ఆల్ ల్యాబ్స్ ప్రెజెంట్లీ దే ఆర్ ఫోకసింగ్ ఆన్ నాన్ డిస్ట్రక్టివ్ టెస్ట్. అంటే నువ్వు టెస్ట్ చేసిన తర్వాత కూడా దాంట్లో చదువు లేదు, అంతే ఉంది, మైక్రోస్కోప్లో చూసిన తరిగేటం. సో అట్లా టెస్టులు డిజైన్ చేయండి అని. సో అది ఒక టెస్ట్తోనే నాకు వచ్చేయచ్చు, ఫింగర్ పెడితే 20. సో దట్ ఈస్ నో మోర్ వ్యాలిడ్. కోర్టే చెప్తుంది వ్యాలిడిటీ. సో అట్లాంటి టెస్ట్ నేను ఇంకా చాలా ఓల్డ్గా అదే చేస్తాను అంటే విల్ బి థ్రోన్ అవుట్ ఆఫ్ ది కమ్యూనిటీ. సో అట్లా మనం అది తెలుసుకోవాలి. స్టాండర్డ్ ల్యాబ్స్ ఉంటారు, వాడు ఎందుకు, ఏమిటికి, ఎంత, ఎప్పుడు, అప్పుడు ఇచ్చాం కదా అదేమైంది, ఇన్ని అడుగుతారు. అవన్నీ మన టీచర్లో కూడా పెండింగ్ విడిపోతుంది. అర్థమవుతుందా? అందుకని ఈ ఫలానా టెస్ట్ అన్నది ఒక మనకి ఏమన్నా ఒక యాడ్స్ అచీవ్మెంట్స్ తీసుకోవడం, అన్ని ల్యాబ్లు యూనిఫామ్గా ఇంటే రాయండి, ఇవే స్టాండర్డ్ టెస్ట్ చేశాము అని ఒక ముద్ర కాగితం, ఒక డాక్యుమెంట్. అంటే డాక్యుమెంట్ గ్రూప్ ఈజ్ రిలయబుల్ రాజధాని ఓవర్. అది కనుక ఉందనుకోండి, అందరు యూనిఫామ్గా అదే ఫాలో అవుతారు. దట్ బికమ్స్ ది రూల్, దట్ బికమ్స్ ది లా. I think I have answered.
Ma'am, here.
ఒక్క నిమిషం, ఇది అయిపోయింది. ఎలా పట్టుకోగలరు? ఇది ఒక ఎగ్జాంపుల్. ఒక కేసు నడుస్తుంది, నేను అన్నట్టు మహామేధావైన క్లాస్ ఎగ్జామినేషన్కి వృద్ధుడిలా ఉండిపోయాడు అని మంచి ప్రాక్టీస్. జత్మలాని ఈ జత్మలాని ఉన్నారు కదా, రామ్ జత్మలాని ప్రాక్టీస్ చెప్తున్నాడు. ఆయన వచ్చాడు, ఈ అమాయకుడైన ఫోరెన్సిక్ సైంటిస్ట్ గారు వెళ్ళిన తర్వాత ఈ పుస్తకాలన్నీ తెచ్చాడు. ఎవరు జత్మలాని అన్ని తెచ్చిన తర్వాత ఫలానా పేమెంట్ టెస్ట్ చేశామయ్యా, తర్వాత ఈయన అన్నాడు, ఫలానా ఆథర్ ఉన్నాడు బుక్ లేటెస్ట్, దాంట్లో ఒక టెస్ట్ చెప్పాడు, అది నువ్వు చదివావా, ఆ పుస్తకం చదివావా, పరీక్ష చేశాను ఓ భాషలు ఏముందా అదే మీరు చెప్పాక ఏదో కొంత నచ్చినది ఉంటుంది. అప్పుడు అన్నాడు, యువర్ ట్రస్ట్ వద్ద నథింగ్ హావ్ గాన్, దేర్ ఇస్ నో సచ్ బుక్. There is no such book. That means your credit worthiness. Procedure and you have to be thorough with the procedure. మీరు సైంటిస్ట్ అయిపోవాలి. మీరు కేసు ఎవరి బాగా తీసుకున్నారనుకోండి, సైంటిస్ట్ ఇంకోటి చేయాలి కదా, మరి న్యాయం చేయాలి కదా. న్యాయం చేయాలంటే మీరు సైంటిస్ట్. ఇప్పుడు వాళ్ళు రేపు ఏం చేస్తారంటే సైంటిస్టులు అందరూ నాలాగా రిటైర్ అయిన వాళ్ళు వీళ్ళు డిఫెన్స్ వాళ్ళు లాయర్లు. ఎందుకంటే ఇక్కడ తెలిసి అక్కడ రెండు వైపులా వాళ్ళు అందుకని వాళ్ళు ఆ పద్ధతి చేస్తారు. లేకపోతే జడ్జిలు అయిపోతారు, మ్యాజిస్ట్రేట్. వాళ్ళకి ఎందుకంటే రూట్ కోర్స్ తెలుసు. డిఎన్ఏ అన్నాను అనుకోండి, డిఎన్ఏ అబ్సల్యూట్ 100% మాట్లాడు అన్ని తర్వాత అయ్యా ఇంకా మ్యుటేషన్ అయ్యేటువంటి ఛాన్స్ ఉంది అని డిఫెన్స్ లాయర్లు అదే అయిన తర్వాత అయ్యా నువ్వు 100 degrees దగ్గర వెయిట్ చేయాలన్నావు, నీవు రాసిన రిపోర్ట్లో 100 కాదు ఏదో 99 రాసినట్టుగా ఉంది, అది చెడిపోతుంది కదా అని అంటారు. ఈయన బుర్రగోపాలు 100 దగ్గర నువ్వు చెడిపోతుంది, ఇప్పుడేమో 99. ఇప్పుడు ఎక్కువ ఎక్కడి నుంచి వచ్చింది ఆ పాయింట్? ప్రొసీజర్. ప్రొసీజర్ గట్టిగా పట్టుకుంటుంది. ఇఫ్ యూ వాంట్ టు బి వెరీ ఇంటెలిజెంట్ క్రాస్ డిఫెన్స్ లాయర్, యూ క్యాచ్ హోల్డ్ ఆఫ్ ది లీగల్ సైడ్ ఎవరిస్తారు. ఫోర్టీస్ మీరు లీగల్ పాయింట్స్ ఇవ్వచ్చు, కానీ ఇవన్నీ ఆయన చీఫ్ అన్ని ఓపెన్ అండ్ ఇవ్వండి. రేపు ఏది దాపరికి ఉండేది అంతా గూగులే. మనకు ఓపిక ఉంటే అది అర్థం చేసుకోవాలి. అర్థం చేసుకుంటే ఎవరైనా ఏ ప్రశ్న అండ్ మోస్ట్ ఆఫ్ క్రాస్ ఎగ్జామినేషన్ అబౌట్ ద లిబర్టీ. చెప్పదగ్గ ప్రశ్నలు, లీగల్ ప్రశ్నలు, ఇంపీచింగ్ క్రెడిబిలిటీ అన్నిటి మీద అడగచ్చు. నువ్వు అనడానికి లేదు, ఇది ఇంటిమేట్ పై ఆన్సర్ అనడానికి లేదు. ఇప్పుడు ప్రాసిక్యూషన్ అవన్నీ అడగవు కానీ దాని మీద. బట్ ఇఫ్ హ్యావ్ టు ఇంపీచ్, యూ హ్యావ్ టు టార్నిష్, ఇఫ్ హ్యావ్ టు టార్నిష్ యువర్ ఇమేజ్, ఐ షుడ్ ఓన్లీ ఆస్క్ దిస్. రైట్ తీసుకున్నాడని తెలిసింది అనుకోండి, సైంటిస్ట్ని అతీతంగా అదని వాళ్ళని దేవుడు వాళ్ళు కూడా ఎక్కడన్నా తక్కువ పడి వాళ్ళు తీసుకున్నారనుకోండి. నాకు తెలిసింది అనుకోండి, ఈ సైంటిస్ట్ చేశాడు కాదు, డబ్బులు తిన్నాడు అన్నారు, అది ప్రూవ్ చేయగలిగితే ఏమైనా మరి ఇలా టార్గెట్ బుక్ ఇమేజ్ అండ్ హౌ కెన్ దే బిలీవ్ సచ్ రిపోర్ట్? వాడు న్యాయంగా చేసుకుంటాడు, విత్ ఆల్ ఫైర్స్ నేచర్ చేసుకుంటాడని ఎక్కడ నమ్మాలి? because there is enough evidence to show that in earlier occasion you have taken some money and then yes, tarmac చేస్తాడు. చెప్పగలిగాను చెప్పారు అనుకోండి. సైంటిస్ట్గా ఇంకోవడం ఎవడైనా అఫ్రికన్ దాని మీద
opinion, which forensic discipline or test underutilized in India, despite having strong evidentiary value? Any test or any discipline?
highly evidential value అన్నదే అది మిత్ అంటారు. హై ఎవిడెన్షియల్ వాల్యూ దేనికి అనే కాదని వాళ్ళు పెద్దగా నామినేట్ చేసి కోర్టులు ఎన్ని కేసులు అన్నిటిలో నాయన ఇదేమి పెద్దగా సూపర్ ఇది అనుకోకండి. ఓన్లీ సప్లిమెంటరీ, కొరాబరేటివ్, సపోర్టివ్, అడ్వైజరీ ఇన్నే మించి ఇది పక్కబట్టింది. అది కూడా సర్కమ్స్టాన్సెస్ గైడ్లైన్స్ ఇచ్చింది. అందులో కన్నా ఉండాలి ఈవెంట్ దేర్ ఆర్ టూ హైపోథిసిస్, వన్ ఫేవరింగ్ అక్యూజ్, ది అదర్ నాట్ ఫేవరింగ్ అక్యూజ్, వెరీ గుడ్ డౌట్ షుడ్ గో టు హిమ్, ఓన్లీ ఇది అని చాలా చెప్పారు. మరి అవన్నీ మన ప్లాన్ ఎగ్జిమెంట్స్ ఉండాలి. మరి ఎవిడెన్స్ వాల్యూ చాలా మొన్న దాకా డిఎన్ఏ ఉన్నారు. డిఎన్ఏలో మ్యుటేషన్ అవ్వలేదు నువ్వు చెప్పగలరు. This evidence is not subject to mutation. Insist అవుతుంది. ఫ్యామిలీ ఏదో మాట్లాడి చెల్లి అది ఒకటే డిఎన్ఏలో వస్తుంది. అదే మన మెథడ్స్ అడ్వాన్స్మెంట్ ఎక్కడ పోలీసు వాళ్ళకి లా తెలుసు, తెలియదు, అలాగే లా వాళ్ళకి లా తెలియదు. ఇలా ఉంటే ఎందుకంటే అందరూ ఇయర్ పార్ట్ అండ్ పార్సల్ ఆఫ్ ది క్రిమినల్ కేసెస్. We cannot watch the side of it. Indicate everything and everybody should do something of the other person saying. అట్లయితే మనం మంచి పోవాలంటే నా ఏరియాలో నేను సైలెన్స్లో పనిచేస్తాను. ఆ పూర్వం కాలం పోయేది అందరికీ అంతా తెలియదు. వాళ్ళు అంటుంది ఇంటిగ్రేటెడ్, వాళ్ళకి తెలుసుకోవాలని తెలుగుతారు. ఇన్వేడింగ్ ప్రైవసీ ఇది కూడా అన్నారు. ఇది కూడా అన్నారు ఇన్వేడింగ్ ప్రైవసీ అని అనలేదని లేదు కదా. తెలుగులో అదే ఉన్నారు, ఇన్వేడింగ్ ప్రైవసీ. ఇట్ ఈస్ నాట్ ఇన్వేడింగ్, బట్ ఓన్లీ థింగ్ వాట్ దే సే లైక్ ఫర్ కన్ఫెషన్ బిఫోర్ ది పోలీస్ 27 ఎట్లా అయితే కొంచెం రైడర్ కొంత లివరేజ్ ఇచ్చారో దీంట్లో కూడా అంతే లివరేజ్ ఇచ్చారు. ఏంటంటే ఆ రెగ్యులేషన్స్లో ఏమన్నా నీకు దాఖలాలు వచ్చాయి బయట, వాడు డిపాజిట్ చేశాడనో లేకపోతే ఏమన్నా ఇచ్చాడనో ఒక ఆబ్జెక్టివ్ పరంగా మన ఎవిడెన్స్ చూపగలిగితే అది నీకు చెల్లుబాటు అవుతుంది. దిస్ రెగ్యులేషన్స్ పర్ సే cyber crime I can venture to talk about there is a specialist study, but cyber forensics అన్నది a very very subspecialized subject. ఎందుకంటారు? Because it's not happening in the physical world, it is happening in cyber space. ఎక్కడ కూర్చుంటాడో తెలియదు, అనామకుడు కనపడ్డు వినపడ్డు వదలడు. అండ్ మోస్ట్ ఫ్రెజైల్ కైండ్ ఆఫ్ ఎవిడెన్స్. ఎందుకంటే మనం తెలిసి కూడా దాన్ని హ్యాండిల్ చేస్తామంటే డేట్ అప్రోచ్ మనం ఏమనుకుంటాము, రీసైకిల్ పోయింది సో రీసైకిల్. ఉదాహరణకి ఒక పుస్తకం లైబ్రరీలో వెళ్తారు, మీకు కావాలి ఏం చేస్తారు? డైరెక్ట్గా పుస్తకం మొత్తం రాసి ఎత్తుతారా? ఏం చేస్తారు? ఇండెక్స్ వస్తాం కదా, ఇండెక్స్ చూసిన తర్వాత ఆథర్ వైజ్ ఆథర్ పేరు తెలిస్తే లేకపోతే బుక్ పేరు తెలిస్తే టైటిల్ పేరు వెతికిన కార్డు ఉంటాయి ఇండెక్స్లో, ఆ కార్డు తీస్తారు. ఏం చేస్తారు? కార్డు తీస్తారు. కార్డు ఇస్ వాట్ అడ్రస్ ఆఫ్ ద బుక్. కార్డు తీస్తారు. Does it mean that you are removing the content in the book? Same with the law. If you leave a file, you are not removing the content unless until you use it again. అందుకనే సైన్స్లో ఉన్న మొబైల్ కానీ ల్యాప్టాప్లు కానీ డెస్క్టాప్ కానీ ముట్టుకోకుండా కానీ నాకు ఎందుకంటే మెటా డేటా ఏదైతే ఆ డేటా జనరేట్ చేసిన దానికి ఒక డేటా ఉంటుంది, అది మ్యానిపులేట్. దాన్ని బట్టి దాన్ని వాడే ఉంటుంది. అది బాగుంది లేదని అయినా లేదని అయినా తెచ్చిపెట్టుకున్నాడు. సో మ్యానిపులేట్ అయినప్పుడు తెలుస్తుంది. దానికి కూడా వచ్చే హ్యాష్ వాల్యూస్ అంటే హ్యాష్ వాల్యూలో ఏం చేస్తామంటే నువ్వు ఏదైతే సీజ్ చేస్తున్నావో దాని యొక్క హ్యాష్ అల్గారిథం దానికి దానికి డైరెక్ట్గా చేయగలిగాము. దానికి డూప్లికేట్ టైప్ చేస్తాం. మన ఫైల్ డూప్లికేట్ ఎట్లా చేస్తామంటే కాపీ ఎట్లా చేస్తాం? కాపీ మామూలుగా కాపీ పేస్ట్ ఉన్నాయి కదా, అవి చేయండి. దిస్ ఇస్ ఎ డిఫరెంట్ కైండ్ ఆఫ్ ఎ కాపీ. దిస్ ఇస్ కాల్డ్ మిర్రర్ ఇమేజ్. కామా ఉంటే కామా, ఫుల్ స్టాప్ ఉంటే ఫుల్ స్టాప్, గ్యాప్ ఉంటే గ్యాప్, అక్కడ ఏది ఉంటే మక్కి మక్కి అంటాం కదా, అట్లా తయారు చేస్తాం. సో ఇలా డూప్లికేట్ వీళ్ళు ట్రై టు డూ. సో అప్పుడు కోర్టుకి ఏం చెప్పాలి? కోర్టుకు ఒక కాపీ సబ్మిట్ చేసే వాళ్ళని ఇది అనాలిసిస్లో ఉంది ఉంటాయి. ఈ మూడు ఒకటే అని చెప్పడానికి కోర్టుకి ఏమర్థం అవుతుంది? నువ్వు ఆబ్జెక్టివ్గా డేటా తెల్లంగా బ్లాక్ అండ్ వైట్ చూపించాలి. ఎట్లా చూపిస్తావు? దీనికి అయ్యా ఒక అల్గారిథం వేరే హ్యాష్, ఇది హ్యాష్ కట్టడం అల్గారిథము. దీంట్లో ఒక ఆల్ఫా న్యూమరికల్ వాల్యూ జనరేట్ అవుతుంది. ఇదే ఆల్ఫా న్యూమరికల్ ఈ మూడిట్లో ఒకటే ఉందనుకో, దాన్ని ఏంటి? ఇది ట్రాన్స్ఫర్ కాదు. ఏ కొంచెం కావాలి ఏదన్నా చేయకపోయారు అనుకోండి, వెంటనే అల్గారిథం పెట్టిన తర్వాత మాట్లాడాలి. అంటే ఏంటి? సంస్థ ఈ రకంగా కోర్టు డెమాన్స్ట్రేట్ చేయబడింది. ఇంకా ఎక్కువ ఏమంటారు? కన్విన్స్ చేయాల్సి వస్తుంది. ఎందుకంటే దిస్ ఈస్ వెరీ వెరీ ప్రెజైల్ అండ్ ఇట్ ఈస్ ప్రోన్ టు మ్యానిపులేషన్. అండ్ అఫెండర్ ఆల్సో ఇట్ ఈస్ వెరీ డిఫికల్ట్ టు డూ. ఇట్ టేక్స్ లాట్ ఆఫ్ టైం. మనీ రెస్టోరింగ్ అని బడ్జెట్ చేస్తున్నారు, దాంట్లో కూడా మన రకరకాల ముందు రాబోయే తరాల్లో ప్రొడక్టివ్ ఫోరెన్సిక్స్ ఏది ఏఐ డేటా మిషన్ లెర్నింగ్ చేసి ఏ ఏరియాలో క్రైమ్ అవ్వడానికి ఆస్కారాలు ఎక్కువ ఉన్నాయి. ఎందుకంటే పోలీస్ బలం కూడా తక్కువ. సో అన్ని చోట్లకి డిప్లై చేయలేదు. So when they know hot spots, these are the most prone areas of attack. And వాళ్ళు తెలుసుకున్నప్పుడు వాటి మీద కేంద్రీకృతం చేస్తారు, రిసోర్స్ అర్థమగిలిస్తారు. సో అట్లా ఏఐ అండ్ మిషన్ లెర్నింగ్ అండ్ అదర్ అడ్వాన్స్ టెక్నాలజీస్ ఆర్ హెల్పింగ్ ఇన్ ఎ గ్రేట్ వే టు టేక్ ది ఫోరెన్సిక్స్ a step forward towards predicting and preventing రాబోయే తరాలు అదే. I think probably the last question. With the permission of the argument, I am not here. I can talk a number of hours. స్టాటిక్గా ఏం చెప్పిందో చెప్పమంటారా? ఐడియల్గా ఉంటే వచ్చి పాజిటివ్ వస్తుంది, ఎప్పుడు వస్తుంది అదే అదే. ఒక్క మాట చెప్తాను. నౌ యు సీ ది డెఫినేషన్ ఆఫ్ బ్రీడ్. ఎవ్రీథింగ్ ఎల్స్ ఇస్ పరంగా ఉండాలి కానీ బ్రీడ్ పెనిట్రేషన్ వెళ్ళి లేదు అన్ని పైన కూడా కాన్సన్ట్రేషన్ పుట్టుకున్నాడంట కదా. ప్రాసిక్యూషన్ ఏది చెప్పకుండా ప్రాసిక్యూషన్ అయిపోయింది అట్లా ఉంటాయి. అందుకని ఈ పదకొండుగా వెతకడం వాటి స్వర్గంలోనే రావట్లేదు. కేసులో ఏ స్వర్గంలో ఉన్నాడు వాడు రావట్లేదు, వాడు వేసుకోవడం. మరి ఎలా డిటెక్ట్ చేస్తాం? ఎందుకంటామంటే మాకు డిటెక్షన్కి మా కళ్ళు పాడవకుండా ఈజీగా ఉంటుంది, తొందరగా పంపిస్తాం. లేకపోతే ఏమవుతాయి? వాటి తోకలు ఉంటాయి, తోకలు ఉంటుంది. ఆ బ్యాక్టీరియల్ సెల్ ఈ స్పందలో ఒకలా కనపడతాయి మాకు. ఎందుకంటే ఒకటే రకమైన స్టెయిన్ డిఫికల్ట్ అవుతుంది. ఆ సైజుని బట్టి కళ్ళు బాగా స్టెయిన్ చేసుకోవాలి. అది బ్యాక్టీరియా కాదు, అది స్పందలో దానికి లోకపోయింది అని చెప్పడానికి మాకు టైం ఎక్కువ పడుతుంది, ఎక్కువ స్టెయిన్ అవ్వాలి. అందుకని ఏం చెప్తామంటే ఈ తక్కువ టైం మరి మ్యాండేట్ చేశారు 7 days అన్నారు. 7 days నమ్ముకుని నీకు లాభం ఉంది, నీకు ఆరే తీసుకుని చేశాను. అందుకని తొందరగా పంపించండి అన్నది ఆ టైం రైడర్ అవుతుంది. ఎందుకంటే చైనాలో నాన్ మోటార్ స్పందలో కొన్ని ఏళ్ళ కూడా ఉంటాయి మమ్మీ బయట పాడేసి అని కూడా ఉంది కాదు. అట్లానే ప్రతి మమ్మీ బయట పాడితే నాకు దొరికింది అక్కడెక్కడ వేసుకుని ప్లాన్ చేసింది ఏం లేదా నేను చెప్పాడు ఎంత ఎక్స్పర్ట్గా ఎందుకు వచ్చింది అక్కడికి ఎక్స్పర్ట్ పంపించారు వాడు ఎగ్జామినేషన్ చేసి ఐ అండర్టేకెన్ ఆల్ టెస్ట్ నథింగ్ ఈజ్ ప్రెజెంట్ అంటే దానికి వ్యాలిడిటీ బికాస్ ఈజ్ ఐ ట్రైన్డ్ ఎక్స్పర్ట్ రాదర్ దాన్ పోలీస్. అందుకని వాళ్ళు ఛాన్సెస్ తీసుకున్నారు. అందులో ఇటుకి ఇస్త్రీ చేసి దాన్ని ఇంకే రకంగా చేసి దాన్ని కాలబెట్టి నాకు పంపిస్తారు. ఎందుకంటే వాళ్ళు ఉంటుంది ఉంటుంది నాకు దాని సందర్భాలను బట్టి అది ఉన్న సిచ్యువేషన్ బట్టి అది చాలా మటుకు చేస్తుందండి. అది ఇట్ అగైన్ డిపెండ్స్ హౌ ద కోర్ట్ ఈజ్ టేకింగ్, హౌ ద ప్రాసిక్యూషన్ ఈజ్ ఏబుల్ టు ప్రూవ్. అన్నీ బాగా చేసి అన్నీ విస్తరించిన వడ్డించిన విస్తరించి అల్లు నోట్లో సెన్ ఉంది ఏం చేయగలుగుతాం. అల్లు నోట్లో సెన్ ఉంటే ఎందులో తినలేదు. అట్లాగే అన్ని ప్రొసీజర్ చేసి ఎక్స్పర్ట్ మ్యామా బాబా అంటున్నాడు చెప్పలేదు. లేకుంటే డిఫెన్స్ చాలా బాగా ఆర్గ్యూ చేస్తారు ఏమన్నా. ఇప్పుడు అట్లాంటప్పుడు ఏం చేయగలుగుతారు? దేర్ ఆర్ కేసెస్, నిర్భయ కేసులో చట్టాలే మారిపోయాయి. ఆ ముఖేష్ కేసులో ఢిల్లీ కేసులో చట్టాలే మారిపోయాయి. బయట మార్క్స్ సబ్జెక్ట్ చేస్తే బయట మార్క్స్ నేను అసలు సైన్సే కాకుండా ఇప్పుడు బయట మార్క్స్తోనే నేను కొన్ని అవి యూనిక్ ఫీచర్లు ఉండాలి. యూనిక్ ఫీచర్ ఎందులో ఎక్కువ ఉంటే అవి మనకు 2 శాంపిల్స్లో నిండుగా ఉంటే దాన్ని బట్టి ఈజీగా రిపోర్ట్ ఇవ్వచ్చు. నమ్ముతారు. వేగ్గా ఉన్నాయి కాటన్ అంటే యూనివర్సల్గా బదిలింది. అక్కడ కాటన్ దొరికింది, వీడి మీద కాటన్ దొరికింది, మీ దగ్గర కాటన్ ఉంటుంది. వాట్ ఈస్ ద యూనిక్ ఫీచర్ ఆఫ్ ద కాటన్ ఈజ్ మోర్ లేదండి దాంట్లో వేరే ఒక థ్రెడ్ ఉంది, ఒక రకమైన వాడు ఎక్కడో ప్లేస్కి వెళ్ళాడు, ఆయిల్ డ్రాప్ ఉంది, అది ఉంది అన్నీ చెప్పగలిగాను అనుకోండి. దెన్ మేబీ ఉంది కాబట్టి ఈ 2 ఒకటే అని చెప్పండి. దాని మీద 100% కూడా చేయొచ్చు. అది ఇట్ అగైన్ డిపెండ్స్ ఆన్ సిచ్యుయేషన్. సర్కమ్స్టాన్షియల్ ఎవిడెన్స్ బేస్ చేసి కన్విక్షన్ చేసింది. ఎందుకు వచ్చింటాయి దాంట్లో సర్కమ్స్టాన్షియల్ ఎవిడెన్స్ ఎక్కడ బ్రేక్ అవ్వకుండా ప్రతి ఒక్క ఈవెంట్ ప్రతి ఒక్క ఫ్యాక్ట్ బియాండ్ రీజనబుల్ డౌట్ ఎస్టాబ్లిష్ చేశాడు. ఒక రైల్వే డివిజనల్ మేనేజర్ ఆయన పేరు సికింద్రాబాద్, ఆయన మొత్తం ఫ్యామిలీ చూసిపెట్టారు. ఇంకా ఏ ఎవిడెన్స్ లేదు. బాడీలు అంతా తీసుకెళ్ళి డెడ్ బాడీస్ ఆల్టో కార్లో సికింద్రాబాద్ రైల్వే స్టేషన్ వెళ్ళి వాడు తగలబెట్టుకుని వాడికి ముందు జుట్టుంది ఇలా కాలింది. కాలితే ఎట్లా ఉంటుంది? జుట్టు ఉండగా చుట్టుపోతుంది. అట్లా కాదు ఇలా పని చెప్తుంది. ఎవరికి? వీడికి ఉపాధ్యాయ అబ్బాయి అవంత పని చెప్తుంది. వాడు హ్యాపీగా అమ్మ అబ్బాయి ఎలా ఉందో పని అట్లా ఆ టైప్ ఉంటుంది. చాలా మటుకు అందరూ ఆఫీసులో ఇది కామన్గా ఉంటుంది. సో దాంట్లో ఏమైంది? నేను చిన్నగా ఉన్నప్పుడు ఎవరు పర్వాలేదండి. బట్ దెన్ యాజ్ దిస్ ఫెలో గ్రూ అప్ అటెండ్ ద ఏజ్ ఆఫ్ మెచ్యూరిటీ ఈ మ్యారేజ్ ఫ్రమ్ మేబీ హిజ్ ఓన్ స్టేట్ ఆర్ నేబర్ స్టేట్ బ్రాట్ లైఫ్. అప్పటిదాకా ఊరుకున్నాడు. లైఫ్ వచ్చింది కొంత దాని ముందు కూడా తిరుగుతూ కూర్చుంటే ఎంతవరకు ఊరుకుంటారు? అది మోటివ్ అంటున్నారు. అది ఎంతవరకు మోటివ్ తెలియదు కానీ దట్ ఇస్ ఓన్లీ మోటివ్ వీ కెన్ సీ. ఇంతమంది మొత్తం ఫ్యామిలీ చుట్టుకోవడానికి అది ఒక్క కారణం అని చెప్తున్నారు. బట్ దాని మోటివ్ సరిగ్గా ఎస్టాబ్లిష్ ఏమన్నాడు? అన్ని తప్పులు విన్నానండి. భార్య వచ్చేప్పుడు తిట్టడం వల్లంటే అప్పటిదాకా చిన్న కూరండి, ఇప్పుడు ఆధునికంగా చెప్తారా ఉంటారు అని వాడు మోటివ్ చెప్తున్నాడు. కానీ బట్ దెన్ ఇందరికీ మోటివ్ వాజ్ నెవర్ ఎస్టాబ్లిష్. బట్ దెన్ అది క్యాపిటల్ పనిష్మెంట్ ఆఫ్ బికాస్ 5 మెంబర్స్ ఆ ఒక్క డాక్టర్ ఎక్కడ ఢిల్లీ చదువుతుందని ఆయన చెప్పలేదు. మీకు అందరినీ సామాన్య డాక్టర్ గ్రాండ్ పేరెంట్స్ ఉన్నారు కాబట్టి డిఎన్ఏ చేసి వాళ్ళ శవాలను తెచ్చారు. కానీ అదర్వైజ్ ఇట్ వాజ్ వెరీ టఫ్ కేస్ వేర్ ఎంటైర్ క్యాష్ వాజ్ రెస్టెడ్ అండ్ సక్సెస్. ఎక్కడ కూడా బ్రేక్ లేదు. విట్నెసెస్ కూడా చాలాసార్లు ఫ్రెండ్స్ని తీసుకెళ్ళారు. వాళ్ళు రేపు కేసు అనగా కూడా తీసుకెళ్ళి అన్నీ వాళ్ళకి చూపించి కరెక్ట్గా చెప్పారు. విట్నెస్ ఆల్సో వెరీ దే హ్యావ్ డిస్ప్లేడ్ ఏ వెరీ ఎక్సలెంట్ కైండ్ ఆఫ్ డిపోజిషన్ చేశారు. మంచి కేసు, సేఫ్ కేసు.
Thank you, ma'am, for your enlightening us with your talk. Now we shall proceed to the clarification of our esteemed guest speaker. Now I invite Dr. P. Aparna ma'am to please join us with the felicitation to Dr. Sharada Avadhanam ma'am. Now I also invite Dr. V. Jeevan Jyoti ma'am, Head Department of Chemistry, Andhra Women's College, to join for the felicitation. Now I invite Ms. Hasina, BSc final year student of RBVRR Women's College, to propose vote of thanks for the session 1.
Good afternoon everyone. I, Hasina Ahmed Jabri from BSc FSCCA final year RBVRR Women's College, on behalf of PG College of Law, Osmania University, RBVRR Women's College, it's my privilege to propose the vote of thanks for today's insightful session on Introduction to Forensic Science and Status in Criminal Justice System by Sharda Ma'am, former Director, APFSL, Hyderabad. We extend our sincere gratitude to our esteemed speaker for sharing her vast knowledge on scope and evolution of forensic science, role of forensic science in investigation, highlighting the importance of analysis, crime scene management, role of various branches and how they contribute to criminal justice system. Criminal justice system has built bridge between science and law. Professional experience and valuable insights into vital role of forensic science in strengthening the criminal justice system. Your words have truly enriched our understanding, ma'am. A warm thank to all the participants for your enthusiastic presence. Thank you one and all.
Dear participants, now we shall proceed for the lunch break. I request all the participants to be here in the auditorium by 2:15. Please see. No, means as we are running behind the schedule, please try to be here in the hall by 2:15. Thank you.
added is about some explanation. The police officer or by any person other than a magistrate who is authorized by the magistrate in his behalf. I want to know from your understanding, what is the meaning for the rider, the other class? It is conducted by the police, well, you know, police officer. Police officer. Besides police officer, who can also conduct, who can also collect, not magistrate, other than magistrate, any person other than magistrate, authorized by the magistrate. Can he be the police officer also? Can he be the police officer also? How many of you say? Maybe. Okay, you say that it cannot be by the police officer. I want to know the meaning. Other class. Conducted by the police officer, well, we know. And any other person, any other person other than magistrate, so magistrate cannot conduct investigation. That's all. Authorized by the magistrate. Any other person authorized by the magistrate. Who is he? Can he be the police officer again? He is correct. He can as well be a police officer. Where do you find it? Where do you find it? Particular section. There is one particular section. Where do you find it? Not that. You must have had 202 CRPC. Understand? 202. It has now become 225. Isn't it? With the same body. Cognizance can be taken under 190. Understand? CRPC. This is now 210 of BNSS. Isn't it? How complaint to be filed? Complaint to be filed under 200 CRPC, which is that of 223 BNSS now. Isn't it? And then that section 202, you are well acquainted with 202 CRPC. The equivalent section also I have given in BNSS. The piece 225, it says the court can authorize a police officer or any other person. The police officer can as well be. Understand? The first thing is that can be conducted by police officer, regular police officer. Suppose court is not satisfied with the way he is conducting prosecution or the investigation, he can authorize some other police officer to conduct it. That is the purport officer. Then next question is, what for, of course, as per the provisions given in the Samhita, where they are given. Where they are given. Because you know, after 20 of the Constitution, the heart of the Constitution, this is the part 3 of the Constitution, the heart of the Constitution. Out of that, 21 is due to the of these parties. You know, nobody can be deprived of life and personal liberty except records the procedure established in law. That is the procedure here, the CRPC, as well as the BNSS. So what the definition says, as per the provisions of the procedure, as per the provisions of Samhita, where are these provisions? They are now in chapter 13 of the BNSS. Previously, chapter 12 of the CRPC. Information to police and investigation thereof. Special chapter is there. There is a chapter. Chapter comprising of sections 173 to 196 now, BNSS. 173 to 190, they speak about the investigation. How to conduct the investigation. That is chapter 13 of the BNSS, comprising sections 173 to 196. Previously, chapter 12 of CRPC, comprising sections 154 to 176. But that is not enough. There are also other chapters we have to take note of. What are they? They are also equally connected. This chapter related to the arrest, chapter 5. Chapter 5, both of the CRPC as well as BNSS. Previously, what are the sections covered by the chapter and the CRPC? Chapter 41 to 60 capital A are the sections. And the chapter 5. dealing with arrest. Arrest is a part of investigation, isn't it? Now, sections 35 to 62, 35 to 62 under BNSS. And also other chapter, when once there is arrest, there is also bail. Chapter 35 of BNSS deals with bails. Sections 478 to 496. 478 to 496. And then, what the other chapter we have to take into consideration simultaneously, there is a chapter 24. Causes relating to the person detained in jails. Once judicial custody is taken, where the person will be in the jail. Now, those are sections 301 to 306. So, strictly speaking, the discussion with regard to investigation necessarily involves all these chapters. At the same time, what I want to impress upon you, because here is the gathering of people well versed in law. So we are aware of the fact that law grows in two ways. Just now I said law continuously grows like a brook, it flows. Understand? It can't be static. Because the goal of the law, the legal luminary, Krishna, the famous judgment, Bengaluru Waterworks was under summarized both the C. Rajappan and others, is the famous judgment of Justice Krishna. Year 1978 Supreme Court, page 548 is the judgment. Year 1978 Supreme Court, 548. It's celebrated judgment of 5 judges. Authored by Justice Krishna. Justice Krishna. Bengaluru Waterworks and summarized both the C. Rajappan and others. There, he said the same thing. Law is not static. It grows. It continuously grows. Because there are no absolutes in law, since the life which is service is relative. There are no absolutes in law, since the life which is service is relative. Of course, in the flowery language of Krishna, of course, we are all fascinated to find out the language of Krishna. Historica is the theme of her law. Beautiful language. Historica is the theme of her law. But the body of Krishna. So what he wanted to impress upon is, suppose you are not aware of the latest judgment of today, you are lagging behind. Understand? Law goes in two ways. Through legislation as well as precedent law, which were called as stare decisions. Understand? Every day, hundreds of judgments come out from the constitutional courts. Understand? So law continuously grows. It cannot be static. It's differently interpreted by one bench. Again, and the larger bench, it may give a different interpretation. So it should be addressed with latest law. So when I am addressing a gathering like this, I must definitely deal with the latest law. That's all. Because all law students in process. So we deal with the latest law. That's all. Not in a routine manner, a monotonous manner. Understand? It should not be precise. It should be logical. It should be logical. So my next question is, what for the investigation, what is it meant for? Is it fact-finding or truth-finding? Somebody says it fact-finding, you say truth-finding. It is correct. What is it meant for? What is the objective of investigation? What is the goal of investigation? Because there is a dichotomy now. Some division between the group of people here. Some say it's fact-finding, some say it's truth-finding. Last minutes are not coming out. The review. So most of you are saying is fact-finding. But such an opinion is created. There is in the tension mind of police officers also. Because I address police officers also in their recordings. Most of the police officers, even senior police officers, they say that's only fact-finding. We do not know what the true reality. Understand? So what is made out of the investigation that we are confined? They say that's only fact-finding. But if you see the judgments of Supreme Court says subject. It's a voice. What for? It's a truth. Understand? But to find out the truth ultimately, recent judgment of Supreme Court, 2024, 19 SCC, page 570 is the latest judgment. 2024, 19 SCC Supreme Court cases, page 570 is the judgment. Two judges, M.M. Sundaresan and S.U. Bhatt. The judgment authored by Sundaresan. Wonderful judgment. I want you to read it. Shailesh Kumar versus State of UP. Shailesh Kumar versus State of UP. State of Uttarakhand. Because UP, you know, is State of Uttarakhand. That's there the capital judgment. Judgment authored by M.M. Sundaresan. Where he elaborately dealt with this aspect, the goal of investigation. What the goal of investigation is? He says it's a fact-finding in search of truth. Combined, fact-finding in search of truth. So ultimately, to find out the truth. This is not merely fact-finding, it's also in search of truth. Truth-finding also, to find out the truth. Understand? But there is also a judgment of Supreme Court about 1 decade ago. Mohanlal Sharma versus State Union of India. Mohanlal Sharma versus Union of India. 2014, there is a 2014 Supreme Court. 2014, 2 SCC, page 532 is the judgment. 3 judges, Kurian Joseph and others. R.M. Lodha, Kurian Joseph, R.M. Lodha, and also Madan Bilotu. There are 3 judges. Mohanlal Sharma versus Union of India. 2014, 2 SCC, page number 532 is the judgment. There also, they are of the view that it's in search of truth. It's in search of truth. Of course, I will show the judgment. The latest judgment of Justice Sundaresan, he dealt with some of the previous judgments of the Supreme Court. At one stage, he also dealt with the judgment of Lord Denning. Lord Denning. Of course, Denning is still considered authority in our Indian judgments. Most judgments, they are the disciples of Denning, I can say, to me, with no hesitation. They refer to the judgment of Jones versus National Coal Board, the judgment of Justice Denning, Lord Denning, UK. Jones versus National Coal Board, the judgment was referred there. The latest judgment, that is 2024, 19 SCC, page 570, just now I said. There, Jones versus National Coal Board. That is what the citation of judgment. That is 1957 to Fields Bench. Fields Bench is UK. Fields Bench, page 55 is the judgment. That you can find the law books. 1957 to Fields Bench, page 55. Justice Denning is the author of the judgment. Then he speaks about the multifarious roles to be played by judge in deciding a matter. The role of a judge. The same judgment is quoted in one of the judgments, third grade judgment of our Supreme Court, Ramachandra versus State of Haryana. Ramachandra versus State of Haryana is also one of the celebrated judgments. It is so celebrated. 1981 3 SCC, page 191 is the judgment. 1981 3 SCC, page 191 is the judgment of celebrated. There also, they dealt with these aspects. The purpose of investigation, the goal of investigation is in search of truth. Because you do not know what happened there. Because already offense taken place. Somebody moved the law by giving a report to the police. The police started investigation. They have to find out the truth. So purpose of investigation is to find out the truth. Ultimately. So there are all these standard judgments you have to take note of. Then coming to the problems under BNSS, just now I said, we start from 173 and end by 196. Understand? Start with 173. 173 previously is that of 154 of CRPC. Information to police, first information report. Understand? A layman may say it's police report, but we say it's not police report. Police report is different so far as law is concerned. Layman may say, suppose offense took place, what we suggest to give a report to the police. We say that it is a report given to the police. As it is report given to the police, we call it as police report. But police report is different. Report by police, that is different. That is under section 173. Now 193. Understand? The wording, phraseology used there is report by police, that is the final report or charge sheet, whatever you call it. Understand? That is report. That is not the. That is not FIR. Understand? FIR is information to police. Understand? Information to police. First information report, FIR, we call it as. That is under section 173. Previously 154. So what is the difference between 154 and 173? For your convenience, of course, I compared both. I will show you from first section to last section. You should be thorough with these provisions because the topic is the investigation. So what the changes brought into and how to understand these things. In 154, there used to be 3 clauses. There used to be, whereas now under 173 there are 4 clauses. Clause 3 is the important clause now introduced into. Clause 1 is further modified and improvised. So compare 154 with 173. So report, suppose the first step is to give a report to the police. To move the law into motion. So first clause says, suppose an offence is, information with regard to offence is given to a police. It can be in a written form or orally also. One need not be literate. Even one is illiterate, he can give a report. An illiterate gives oral report. It's the duty of the police to reduce it. That's all. But now what is introduced is the electronic board also that can be given to electronic communication. Understand? That was not there, is now brought into. Is it so? Is it so? But that is already in practice. That's not new. The police people are unnecessarily confused. They are not new. Already in implementation, because the judgment of the Supreme Court 1999, Satwinder Kaur's case, I will show you, Katie Thomas, 2 decades ago, almost. They got a jurisdiction also. Now, even without jurisdiction, that can be entertained now, isn't it? Jurisdiction. We call it as for our convenience, say zero FIR. But the word zero FIR doesn't appear there. It is for our convenience. Understand? People should not be confused. So that's why the police people have given certain circulars. They say it's zero FIR. Because for every police station, they maintain an FIR register. It starts from 1st of January, ends by 31st of December. So every police station will have different numbers. Now what the section says is that even without jurisdiction, the police are bound to register the FIR. Understand? An offence took place in Hyderabad. A victim was gang raped in Hyderabad. Take for example. Those people are very influential people. They have got political support. She cannot come to the police station under certain circumstances. So she moved to Mumbai. Can she give a report at Mumbai? Now she can give a report. Understand? Now she can give a report. Irrespective of jurisdiction, wherever she gives the report, that should be entertained with the police. Otherwise, that will land them in trouble. They can be booked under 199 of BNS. Isn't it? Penal section is, suppose a public servant fails to receive the report, given a report, conjugal offence, what will happen then? That will land him in trouble because the case can be booked against him 199 of BNS. That's all. BNS. Because we read BNS as well as BSc also whenever the need arises. But what I want to say is it a new thing brought into? Those statute says irrespective of jurisdiction. Is it Is it new thing brought into? No, that's not. It's already there from 1999 onwards. Because Supreme Court celebrated judgment of Justice K.T. Thomas, certainly House case. They already said, even without jurisdiction, you have to register it and then send it to the police station having jurisdiction. That's all. It's already law. Understand? That's what I said. Law goes in two ways, not only through legislation but also through judgment law, which prevails ultimately. What the Supreme Court says that prevails is already law of the land. But that's not found in the statute book. Now it has become a part of the statute book. That's all. That's all. So this zero FIR, why this mode of zero FIR is introduced is, it should not make confusion. Because the victim went to Mumbai, she gave a report. They didn't have any jurisdiction. So the police station where the report is given, they register it as FIR, but for convenience sake, they put zero. Understand? They put zero before that number. Then later it is transferred to Hyderabad, to a particular police station. They again registered that FIR. Suppose they already registered 50 FIRs, 51 will be the number. There it is first number, here is 51 number. So one should not be confused. So zero appears to give an indication that the police who registered the FIR had no jurisdiction. That's why they put the zero. So for a convenience sake only, it's called zero FIR. That's all. A duplication, under confusion also. Confusion. It's not duplication, it's continuation. But to avoid confusion in the mind of the court, that's all. Then another thing is, when it is through electronic communication, through WhatsApp message, to email or something else, you know, well, electronic communication is also defined in BNSS. No, isn't it? There is a separate definition is given. Then, if it is given by way of electronic communication, what does it do, what it doesn't contain then? What doesn't contain? What is the difference between FIR and statement recorded with the police in 161 previously, now 180? Signature. 180, that's correct. Signature. It doesn't bear the signature. Or it doesn't bear the thumb impression. Whatever it may be. Understand? If it is from an illiterate person, it doesn't bear the thumb impression. From literate, it should have the signature. Understand? But the signature must be must so far as FIR is concerned. For 161, there should not be. Understand? For 161, now it's 180. There need not be a signature. It should not be also. There should not be. Understand? There is no authenticity. But so far as FIR is concerned, it should be attached with some authenticity. Otherwise, practical jokes will be played with police. Understand? Some people may say, here are 10 murders committed, please come in. Police may come, they will see that there is nothing happened. Understand? Hoaxes can be played against police, pranks can be played. Understand? So FIR should have some authenticity. It should contain the signature. So when it's given through electronic communication, does it contain signature? There is no possibility, understand? So that's why the section says, if it is given through electronic communication, a time of 3 days is given for the informant to come and sign, understand? So the police should inform in turn, you should come to the police station and sign. You have to wait for 3 days. So if it doesn't turn up within 3 days, then what will they do? They will close it for the time being. Suppose prevented by some other reason, then he comes on the 4th day, then they will register FIR, and with the column meant for explain the delay, there is column 8, they will explain. Understand? Nothing wrong. So that is all about clause 1. So what clause 1 says, what improvements now brought into improvements. Is it visible to all those who are far away? No, it did not be affected. Suppose he did not come somehow. Why did not come, we do not know. What I said, even the 4th day he comes, Okay, comes. The delay can be recorded in the column 8 meant for it. Understand, you can say, and prevent it, that's why it could not come. Even 2 months delay is there, that may be, that may have to take it seriously. Not that. Means, ultimate assumed time is 3 days. Suppose he comes within 5 minutes. He will not wait for 3 days. Understand? He comes within 1 hour. You can record it. We acted upon only 3 days. Understand? Now, to BCP, I will tell you one thing. There is also some more things introduced therein. What they say? Suppose it is an offence under section 63 to 72 and 74 to 79. Understand? It is an offence under 63 to 72 and 74 to 79 of BNS, rape case. Police themselves go to your house. Understand? She need not come. It is already there. How to understand a particular provision, I am just telling you. Fund limit is 3 days. But even if suppose after 10 days, there are some cases where we convicted when there is a delay of 1.5 months. Delay was properly explained, nothing wrong. FIR is not be all and end all. It is not the encyclopedia. Even if a false report is given and properly investigated, the accused can be convicted, isn't it? FIR can be given even by a person who had got no direct knowledge. I went to my village. So by surprise I found a corpse lying there. I am a law-abiding citizen. I inquired to somebody who committed murder. Somebody said the fellow who committed murder is called Kolaya. Unmindful of the fact, the true fact, I went to police station, gave a report against Kolaya. But the police found out that it is committed with Ramarao. Is it fact of the prosecution? No. FIR is not be all and end all. Understand? There are so many judgments. FIR means setting the law into motion. It is the duty of the police to find out the fact, to find out the truth. Just moving the police into action. That's all. There's a controversial question. It's controversial. I say in the recent conferences, of course, I said this can be preferred because it got some authentication. But of course, the Supreme Court judge will wait and see what Supreme Court approves of it. My personal view is the justice is different in the action because it has got authenticity. But now nothing wrong, they will conduct anyhow his statement has to be recorded. Investigation means investigate 175, 176 immediately. Next step is police go to him to record his detailed statement. So FIR need not contain a long statement, it contains only a brief statement. The police will put so many questions and anyhow they will record his statement. So for that also the process is important. That's all. So then friends, this is the first thing. Third one that is introduced in 173 is a new one. Is it a new one? No, it has been practiced since 2014. What I am saying, I will show hundreds of judges with me because time doesn't permit me. So for everything there is a Supreme Court for decades. Understand? Don't think that all of a sudden wisdom has dawned on the government went for this change. The guidance of the Supreme Court from time to time, for decades. Not the Supreme Court, harped for decades, it has finally come to the statute book, that's all. Nothing new. What class 3 says, suppose if the IO is done, the station's officer is doubtful about a particular offense, genuineness of a particular offense. Listen, suppose the faction did in place. There are two groups in the village. One group supports one political party, another group supports another political party. Suppose a report is given. She is doubtful whether there is a probable offense or not, or somebody falls in opening group. Suppose it doesn't register FIR, what will happen? That will land you in trouble, isn't it? It's punishable. That could be understood by the Supreme Court with the famous judgment of Lalita Kumar was state of duty. Lalita Kumar was state of 5 judges bench. Judgment written by the Sadhasivan, legal Chief Justice. It's a wonderful judgment, please read it. Lalita Kumar was state of duty. 2014, 2 SEC page 1. 2014, 2 SEC page 1 is the judgment. Lalita Kumar was the state of duty. where this hardship of a genuine and a bona fide stations officer could be understood by the Supreme Court. Supreme Court is like a mother who will understand the problems of a child better than a mother. She can understand the real trouble being faced by a genuine police officer. Then it said, under those circumstances, he can have a breathing space up to 7 days to conduct a preliminary inquiry. Understand? Inquiry, because inquiry or inquiry, whatever you call it, the story gives same meaning for the two words, different meanings. If it starts with he is inquiry, it starts with I, it's called, you pronounce it inquiry, whatever it may be, same meaning. That's called preliminary inquiry. Preliminary inquiry to be conducted by a police officer. Understand? For how much period is given at the Supreme Court? Only 7 days. To find out the truth, whether there is a prima facie case or not. Understand? With the permission obtained from the superior officer, need not be SP, DSP is enough. But Supreme Court said that can be exercised in 5 categories of cases only. They have given categories the case. What are they? Suppose dowry related cases, 498A, of course, matrimonial cases, because there is some judgments here and there, they speak about some abuse. Understand? So they said, for that you can postpone registration for some days, 7 days, just wait. Or corruption cases, medical negligence cases, all these cases, of course, they have given full category. And suppose there is a delay in giving report for 3 months. For 3 months there is no report given in cognizable offence. You can wait. Supreme Court said in those circumstances IO cannot be found fault. He can wait for 7 days for some. That is brought into statute. So class 3 is now introduced. Class 3 says if there is a doubt entertained by a police officer with regard to the offence, whether it is cognizable offence or not, then he can embark upon inquiry, preliminary inquiry. Understand? Within a period of 15 days. Previously it was Supreme Court said 7 days. You can wait for 15 days. You can do investigation. This preliminary inquiry is not investigation, it is a preliminary inquiry for 15 days. Provided he obtained the permission from the DSP, Supreme Office. But is it a hard and fast rule? No. Because you have to read the words very carefully. Depending on the nature and gravity. Understand? Depending upon the nature and gravity. Suppose a policeman, a superior, a police officer has come, the police should give a report with his hand fractured. What he says, that a mob attacked him, they caused injury. It is visible, isn't it? Should be postponed then? Need not be. Understand? Suppose victim is dying, victim has to be sent to the police, sent to some hospital. You should do. Understand? Part of investigation, you should immediately do. You cannot postpone things. Understand? So, depending upon the nature and the gravity of the offences, that should be an exercise. So, what the 4th class introduced you, previously it was a 3rd class under 154.3. 154.3, what does it speak about? It says, suppose the report is not taken by the SHO. SHO is station's officer. Whomever he may be the SI, he may be the inspector of police, whatever may be the authority of the police station. But the next remedy is to send it by registered post to the superintendent of police, superior officer, isn't it? Even superintendent of police didn't care. Then what is the remedy open? To file a private complaint before the magistrate. Understand? You know. File a private complaint on magistrate under which provision 200 CRPC. You know. The police can refer it to the court of police under 156.3. That is there. Same thing with the rider now. Further, of course, rider is added to class 4 of 173. It says, failing which the remedy is also failing which the application can be filed before the magistrate. That means you have to invoke what is the 223. Previously it was 200 CRPC. Now you have to file a complaint with 223. Then of course, immediately you have to see 175 also. So 156.3 has now become 175.3. Previously it was 156.3, It has now become 173, 175.3. Oh, okay. This is failing which he may make an application under subsection 3 of section 175 as. Basic. Magistrate need not send to the police. It's not a condition to send. Magistrate can entertain also immediately. Understand? Suppose magistrate immediately take cognizance. Because cognizance arises in 3 ways. Cognizance arises 3 ways. Under section 210 class 1. Previously it was 190 class 1. Upon complaint, first thing is complaint. Upon report, upon his personal knowledge. Other than the information permitted by the police. That means, first of all, a report is No, I will tell you, 175, 174 I will tell you just now. This is also, because this is wonderful topic, because you are raising very good questions. 174, but the thing is, time constraints. Otherwise, 173, I will tell you, 174 speaks about the report in non-cardinal offences. Non-cardinal offences, what the duty of the police? Police will not register in FIR. They just wait for the fiat from the court. They will ask him to obtain the order from the court. But now, what is insisted in 174 is that there is also a duty now cast upon them. Previously, that was not there. 155 doesn't speak about the duty. 174 says you should maintain a record and you should send a fortnight statement to the magistrate. Daily report. Understand? No. DNSS 174 says, 174 speaks about the non-cardinal offence. Suppose I give a report to the police, it's non-cardinal offence. Police also duty bound. They should send a fortnight statement to the magistrate in regard to all offences where they took complaints or whatever you say, reports or informations with regard to non-cardinal offences. Daily report. What is daily report to us? What they have recorded for every day in the GD. No, that is different. They will wait. In non-cardinal offences, the court will straight away take ordinance. Suppose if I file a complaint, I would impress upon the court. There is a case, a strong case against the accused. They can straight away take ordinance. They need not send it to the police. It is not a condition to say. But they feel that some more investigation is required to be done. Some document evidence to be collected. Search has to be conducted. Who will conduct search? Police people should normally conduct search. Under those circumstances, they may send it to the police. It's not a condition to see. That's all. Then, coming to this non-cardinal offences, what is required is to send a daily report. Then 175 and 176, they speak about the investigation. What is investigation? Investigation means the police officer, first of all, you should study the case first. You should form an opinion. Then you should visit the scene. Then you should record the statements of the witnesses. Then you should conduct the CDM, crime detail form. Understand? You should collect the material if any available therein. That's called forensic evidence. Just to collect. Here, of course, the change is in between CRPC and BNSS. Was there a distinction drawn in CRPC in connection with the investigations related to offences? Was there a distinction drawn in the entire CRPC about the investigations to be conducted by the police with regard to certain offences? No to CRPC, no. But to BNS, the distinction is wrong. Though it doesn't appear on the face of BNS, they have divided the offence into 3 categories. Whole BNS, you can easily understand. To keep it in mind, you can have a grasp over BNSs. Easy. BNSs has divided the offences into 3 categories. The first category is the offences punishable with imprisonment less than 3 years. Understand? Second category, the offences punishable with imprisonment more than 3 years, less than 7 years. The third category is offences which are punishable with imprisonment more than 7 years. I will put you one question. This category is given a specific name, nomenclatures for this category in one act, one famous act. What is the act? In one act, the same category is given different nomenclatures. Names, phraseology is used there. What is the offense? What is the act? Very famous act. He is correct. Juvenile justice, care and protection. Juvenile justice, care and protection. They have given definitions. What the first time they have given for the offences which are punishable with the imprisonment less than 3 years, they call it petty offences. And above 3 years, less than 7 years, they call it as serious offences. And above 7 years, they call it as serious offences. In BNS is also same category runs. We go to 35(7). For 35(7), of course, I am jumping into a different chapter. 35(7). 35(7) is the amalgamation of 2 sections. 41, 41A. 41A, of course, you know, very famous. 41A notice, of course, you are all aware. 35 is a combination of both 41 and 41A. Understand? 41 is from clauses 1 to 1 and 2 of 41. 41A, clauses 3 to 6. Understand? Now 41A notice, 35(3) notice. Now it's not 41A notice, we are using it. What is it? It is a 35(3) notice. What is the famous judgment for 41A notice? Every day there is troubling. The police officers and also judicial officers also, some of them in trouble also, if they couldn't understand it. Anish Kumar is the state of Bihar. 2014. It's wonderful judgment. 2014, 8 SCC, page 273 is judgment. 2014, 8 SCC, page 273 is judgment. Excellent judgment. PC Ghosh. Two judges, PC Ghosh and Prasad. Prasad. 2 judges. Of course, Padmesh Kumar has now recently it's further explained in one famous judgment. What is it? Mohammed Isfaq Alam versus state of Jharkhand. Mohammed Isfaq Alam versus state of Jharkhand is the latest judgment. Mohammed Isfaq Alam versus state of Jharkhand. Isfaq Alam versus state of Jharkhand. 2024, this is 23, 8 SCC, 632 is the judgment. Latest judgment. There, of course, they re-emphasize this. Anish Kumar explained in lucid manner how to understand. But of course, what the difficulty in implementing the Anish Kumar's guidelines? Because the police always follow in a hackneyed manner. That is hackneyed manner, routine manner, traditional manner. They can't understand the change. Understand? Something is not given in the appendix or in any form of appended to CRPC. They do not know how to give a notice. They are in confusion. Understand? Anish Kumar says about the offence is punishment with imprisonment less than 7 years. What is required is to give a notice. Understand? 41A. How to give a notice? Is it appended to CRPC? No. Is it given the rules? No. So they are in confusion. To resolve that confusion and to dissolve that confusion, now a form is appended to BNSs, where it is given chapter 2 of the schedule 2 of BNSs. There are 2 schedules appended to BNSs, isn't it? In schedule 2, the forms are given. How many forms? 58 forms. First form is that of the notice required to be given. First form is the notice that is required to be given at 35(3), equivalent to 41A of CRPC. Easy. They can fill up the columns and give notice. template is given. What the police do is, they can just fill up. So also in BSA, what is BSA? Saksha Adhiniyam. It has come in the place of Indian Evidence Act. Understand? Now a schedule is appended, isn't it? Previously there was no schedule to Indian Evidence Act. Schedule which originally existed there was repealed in 1938. It used to be one schedule appended to Indian Evidence Act. That was taken out in 1938. And then thereafter there was no schedule appended to Indian Evidence Act. But now there is a schedule appended to BNSS. What for it is appended now? The reason behind it. Because it contains two certificates, certificate A, certificate B, which are very much useful with regard to electronic evidence under 63.4. Understand? Previously 65.4, now 63.4. Previously the 65B4, 65B4. 65B4, the police didn't know how to use them, the certificates, how to obtain certificates. So even the best evidence they couldn't produce. In some sessions cases, where we were conducting, the best evidence they couldn't produce, they couldn't get them marked because they didn't know how to produce the certificate. Because now everything is made tailor-made. That is given in the appendix now, they can fill up and they can file, that's all. So now the form which you find is there in appendix form 1 in schedule 2 of BNSS. Then coming to 35, just I define 35. 35 contain now one class, that is class 7. Previously 40 and 41 are now amalgamated into 35. Well, but that should have ended with class 6. Understand? But now a new class is added, that is class 7. What for? Just now I said, offences are categorized into 3 categories. The first category is petty offences for which the punishment is less than 3 years. Now what this class says is, suppose offence is punishable with an imprisonment less than 3 years. In some cases, they need not arrest the accused. Suppose the accused is about 60 years of age, is informed. They need not arrest now, provided permission is obtained from the DSP. Understand? Then coming to 175 and 176. 175 just what I said. 156.3 now has become 175.3. Understand? But now police are also given some right. Natural justice. Adi altum partum. What is adi altum partum? Nobody should be condemned and unheard. Previously they had such opportunity of killing. Even now police, public servant is also given such an opportunity. Suppose you file a complaint before the police, before the court, ignoring the police. What do you say? I went to police station, but the policeman demanded bribe, or he asked me this and that. I couldn't yield, therefore he didn't entertain a complaint, therefore I filed the complaint. So such the allegations are made against the police officer. Previously he had no voice. Can he be heard? No. Now we have got that voice. 223 recognizes the right of the police. It says, whenever a private complaint is filed, policeman can as well be heard. The opportunity. Then also a public servant. You are also public servants, you know. Suppose a essay is a public servant. So allegations, basis allegations are made against the public servant. You know, of course, sanction is necessary, I know, 218, but taking cognizance. But before that, you should be given an opportunity. That is recognized there, both of 175 as well as under 223. What it says, suppose the report is, a complaint is filed in the public servant, the court will not directly take cognizance. It will call for a report from the superior officer of the public servant within 14 days, or as well as possible. Understand? Then, after considering that report, as well as the assistance made to the police public servant. Understand? When I was telling this, one of the police officers said, "Sir, should the public servant be servant?" It's genuine question. How can the court know the assistance made to the public servant? Because section doesn't speak about it. Understand? How can you understand that? That means he need not come. He need not be summoned. But once a report is summoned, a call from the superior officer of the public servant, normally the superior officer, after receiving this from the court, what does he do? He will give a charge memo to the public servant, asking him to explain. Then he will give his own explanation. Then part of the report to be submitted to the court by the superior officer, isn't it? Assessment can as well be known to the court. This is the wonderful changes brought in. Then coming to other important provision, because we are running with time. Had I been given at least half a day, I would have dealt with all these elements thoroughly. Anyhow, of course, we have to deal with some important things. 187 is the radical change brought in. 187, of course, is in the place of 167. You know the difference between judicial custody and police custody? What is the difference between those two? Suppose somebody is in jail, jail authorities, they function directly under the control of the court. That's called judicial custody. A layman may not be knowing the difference. Suppose somebody is produced to the jail, central jail, somebody is produced. That those people are called judicial police. They are under the direct control of the courts. Business department is independent. The policeman cannot go there, cannot meddle with them. They work under the command of the court. Every court may not have that much of accommodation to give the people taken into judicial custody. The custody of law. What a beautiful definition they give. Custody of law. Understand? Somebody is taking the custody of law, released from the custody of law. That's called bail. If it is with sureties, it's called bail bond. It is without surety, that's normally bond. But the state is also bond. That means a man is accuser produced to the court. So constitutional guarantee, you know, it should be produced in 24 hours after excluding the time taken for transit. Then court takes him to judicial custody, keeps him in jail. Policeman, he wants to investigate him or interrogate him to collect some evidence. What does he do? He seeks the permission of the court by moving an application to the court. And if the court is convinced with the presentation, the court may grant police custody. That means transformation from judicial custody to police custody. This policeman will go to the jail and file an application with the superintendent. So this is the order given by the court. And then the superintendent will hand over the man who is in his custody to this man. Understand? Then he will be under the custody of the police. After completion of the police custody, he will be again produced to the magistrate. Magistrate will question him over the treatment rendered to him during the police custody and takes him back to the judicial custody and then sends him to the judicial remand. So for filing judicial police custody, what are the initial period there under CRPC? 15 days. 15 days. But now the period is a little bit elongated for moving an application. But the total period of police custody should not be more than 50 days. Keep it in mind. Understand? Some people are in the impression that police custody can be given 40 days and 60 days. That's not correct. Section says police custody for 50 in whole or in part. What the section says, in whole or in part. But in whole means for a total period or in part. Suppose 2 days is given to be further extended to another 2 days. Total period should not be more than 15 days. Total period is only 15 days. When to file an application? For certain offences, the period given for investigation, for completion of investigation, 90 days. Offence is punishable with imprisonment of more than 10 years. What is the total period the police can do investigation? 90 days. And for other offences, it is only 60 days. So what the section says on 187 is, it is guided by other sections, I will tell you. If the offence, the total period of investigation is not more than 90 days, they can move such an application within 60 days. And if an offence for investigation time is only 60 days, they can move such an application within 40 days. But can they sleep and then leisurely file such an application? There is check again under 480. You have to read 480. Where is that chapter 5? Chapter 5, there is a check. Why I said law should be read as a whole, not in parts. It should not be read in seclusion of other provisions. You should read the total law. That's why we can understand things well. So 187 is controlled by 480. 480 is in chapter 35. What 480 says, suppose the application is not filed with the police, seeking police custody, and a reasonable cause is not explained by them, or not moving the application within the uppermost time, this accused can be released on bail. Released on bail. So that's why in 187, certain beautiful words are used. Charges of the accused. Charges of the accused. Read it, 187. Charges of the accused. That's two things. He should not be on bail, or if the bail is cancelled. Understand? If he is on bail, no question of police custody. If his bail is cancelled, where he will be? Then police custody. That's wonderful word, magical words are used in 187. You should understand carefully. So also, suppose if a search is conducted, conducting the search of 185, police officer conducted search 185. You have to read 3 sections together. Section 44, section 185, 105. What are they? 4 and 6, of course, because we have to deal with 4 and 6, I am telling this. 176 says, suppose the offence is punishable with imprisonment of more than 7 years. First of all, 173, what does it say? Just now I said. Offence is punishable with imprisonment of more than 3 years and less than 7 years. Then the police have got an opportunity of conducting preliminary inquiry. That is the 173. Suppose the offence is punishable with imprisonment of more than 7 years. A mandatory procedure is laid down under 176(3). Previously there was not there on the CRPC. There should be a collection of forensic evidence. No other go. Compulsorily they should collect the forensic evidence. What is forensic evidence? In Telangana and Andhra and Tamil Nadu and other states there is no problem. Here of course, in respect of the investigation related to serious offences, new streams will come into, because in Hyderabad we are having forensic labs, forensic teams readily available. Because they are deployed immediately. They bring the forensic experts with them. They collect the Directive 1763, that is, collection of forensic evidence is a must. They cannot be dispensed with. Then coming to the other question that just now I said, police people are conducting search. 44, why I asked you to read 44 along with 185 and 105. 3 sections you should read together. Suppose a policeman is chasing an accused. He entered into a private house. He entered into a hotel, a private residence somewhere. Strictly speaking, the policeman had to enter into the residence of this man before he entered into his private residence somewhere. He should obtain the search warrant. Under certain circumstances, there may not be the possibility of having time to obtain the search warrant. Then he can dispense with it. He can dispense with it, provided he makes the reason. He makes a reason in the diary to be maintained. What is the diary? CD. It's called CD. Understand? If he maintains a CD, case diary, then he has to make a mention of that. That is mandatory now at 185. Understand? 44 speaks about the search, and 185 mandates that you should mention it in the case diary. CD is different from GD. Understand? GD is applicable to all the cases, all the happenings in the police station. But CD to be maintained only after the investigation is taken up. Because the CD, importance of CD is also explained in the recent judgment. Just now I said, Sailesh Kumar's judgment. Because I will show you shortly. There, what the procedure to be followed by conducting search? 105. That means that should be recorded, videographed. So, can he have the opportunity of carrying a videographer always with him? That's why preferably by mobile phone. Understand? So it is preferable with mobile phone. What kind of evidence that is? What kind of evidence that is? Electronic evidence. Electronic evidence now, is it primary evidence or secondary evidence? Primary evidence under which section? 57 up to BSA. 57 class 5 for 4 onward to speak about. Understand? 57, that's why I say you should read all the laws together. Otherwise you cannot understand. Investigation topic is very wide topic. Police people also should have that knowledge. When it is considered electronic evidence, both primary evidence, both as well as secondary evidence. When it is considered secondary evidence, then it needs a certificate with 63(4). Previously 65(b)(4). Understand? When it is considered secondary evidence, it needs a certificate under 65(b)(4). And now 63(4). Understand? Otherwise, it's the electronic evidence is primary evidence on 57. 57 speaks about primary evidence, chapter 5 of BSA. Now, Indian Evidence Act, wonderful enactment, they could not be touched much by the present legislation because it's drafted by a great man, Fridtjof Stephen. Yes, Fridtjof Stephen is a great man. Of course, that cannot be touched by anybody, but it is made some improvisations. So, chapter 5 is elaborately improvised. Now 57 speaks about the electronic evidence being considered as a primary evidence. Understand? What it says, if it is produced from proper custody, it is electronic, it is a primary evidence. Understand? One judgment of the Supreme Court, electronic evidence, students who get more marks to the electronic evidence should be thorough with law. For the latest judgment of the Supreme Court, that was behind this change brought into 57. Arjun Pandit was Kailas Kushan Rao. 2020 class 7 or 2020 part 7 SCC the judgment. You will note of this. 2020 7 SCC page 1 is the judgment. Arjun Pandit was Kailas Kushan Rao. Wonderful judgment justice. FM Nariman. Green Joseph also shared the bench. Wonderful. Ramasubramanian. V. Ramasubramanian wrote separate judgment. Not even judgment is of course thorough judgment. You can read it. He referred all the previous laws. Nariman was also part of the earlier bench, Shafi Mohammad's case. Understand? How the law grew so far as electronic evidence is concerned. The first judgment is that of State NCT Delhi versus Navjot Sandhu is the first judgment, 2005. State NCT Delhi versus Navjot Sandhu, Parliament attack case. First judgment that dealt with electronic evidence. Two judges. P. Venkatram Reddy and D. Lokar. Authored by Justice Venkatram Reddy. 2005, 11 SCC, page 600 is the judgment. 2005, 11 SCC page, 600 is the page. There is the first judgment, two judges, Venkatram Reddy and Justice D. Lokar. Then it was the law for 1 decade. Till it is changed, Anwar P.V. versus P.K. Bashir. Anwar P.V. versus P.K. Bashir, that was judgment Supreme Court 2015. AR 2015, Supreme Court page 180. AR 2015, judgment page 180. Three judgments. They interfered with law. They said that 65(b)(4) is mandatory. Let's not can't discuss it. P. Venkatram Reddy's judgment, of course, in the Parliament attack, what he said, even without the certificate, that can be admissible under 63 and 65 of Indian Evidence Act. That was not accepted by the Supreme Court, larger judge. Then Shafi Mohammad's case, third judgment, 2018, Shafi Mohammad's case. Then Hiramaz's case, 2019. Then, of course, finally, there are the Arjun Pandit Rao versus Kailas Kushan Rao, 2027 SCC page 1 is the latest judgment. There, of course, the judges obviously discussed. It can have both shades. It can be considered primary evidence as well as secondary evidence. That is what I am saying is, suppose the layman feels that a new thing is brought into, who will accept. But as people who deal with the law, who don't accept that is new law, already there. Understand? Though it's not part of the statute book. Which governs, Supreme Court judgments govern. Already the law laid down the Supreme Court. That is brought into the statute book, that's all. Now there is harmony. suppose a law student buys a book, he may have the impression that that is not the law, because he might not have studied the latest law. But the law is already there, that is brought into statute. So what this IO should have the knowledge, that is the primary evidence. Suppose he produced his memory card, it is the primary evidence, isn't it? But now, there is some controversy now. Suppose in artificial intelligence, something can be tampered with. Understand, nowadays it's very easy to create things. Further, of course, the need of production of these two certificates. First certificate with regard to hash value, second certificate with regard to the authority over the system, who is managing the system. The two certificates are given under schedule appended to the BSA. Then what the other important change is brought is with regard to 193. What was 193, previously 173, has now become 193. So I said it's report to the police. It's not called as charge sheet. Colloquially we are calling it as charge sheet. Colloquially we are calling it as interchangeably using the word final report. But those things are not used in code as well as in BNSS. They call it as report filed by the police after investigation. What the law now brought into, the changes brought into, rights of the victim are recognized. A poor victim who went to police station gave a report. What is happening in the investigation, she doesn't know. She doesn't know what the case, understand? Police will file a final report later stage. Then of course court may give a notice. Suppose something, the police feel that is the report they filed as mistake of law or false, they didn't want to proceed further. What does the court do? The court may give a notice and protest application to call for protest application. That is different. Normally, the victim may not be knowing what is done by the police. Now that is disputed. Victim should be apprised about the investigation within 90 days. Within 90 days. And what is the mode of such appraisal? Through electronic communications. The electronic communications. This electronic communication, we are feeling that is a new thing. It's not correct. There are judgments Supreme Court 2003, judgments Supreme Court 2013. They encourage this electronic mode of giving information, electronic mode of supplying copies also they recognize long back. The judgments, they are there, I'm having the judgments with you. So what is now brought into 193 is that, of course, I am delaying the next speaker. Okay. Anyhow, I will show some citations, of course, you may see. This is a wonderful topic, though. Of course. If you go on discussing it with you, even 1 week is not sufficient. That's a safety. The goal of investigation, please read this judgment. The recent judgment of the Supreme Court, I already quoted it. You open out the word. Shailesh Kumar, just now we noted, Shailesh Kumar was the state of Uttar Pradesh, now state of Uttarakhand. I quoted. To 19 SCC 570. Page number also has stated this. Two judges, this M.M. Sundaresh and Justice S.V.M. Bhatt. Goal of investigation, there's the purport of our lecture also. They said, what for this? It's fact-finding in search of truth. Of course, I will take you to paragraphs 18 and onwards. Wonderful discussion they made. Every line has got its importance. M.M. Sundaresh is the judge. Investigation, the role of investigating officer. An investigation is a crime in a lawful search of men and materials relevant in reconstructing and recreating the circumstances of an offence said to have committed. Said to have committed, because we do not know. Said to have committed. With the evidence in possession, an investigating officer shall travel back in time, and therefore tick off the time zone to reach the exact time and date of occurrence of the incident and investigation. The goal of investigation is to determine the truth. See friends, determine the truth. Understand? Determine the truth. Determine the truth, which would help the investigating officer to form a correct opinion on the culpability of the named accused or suspect. Every opinion, of course, the positive style I cannot read it, but it's got a lot of importance. You have to read it again and again. This judgment. The other judgment, of course, I quoted is that of 2014 is also very, very important. In search of truth, investigation in search of truth. This is Manohar Lal Sharma. The last question is this: can the court make interference in the investigation? Can the court make an interference in the investigation? So most of you are saying yes. He is saying yes. No. He is right to some extent. Because the traditional view is that the court should not make an interference. The court's domain comes into operation only when it takes cognizance. It can dictate cognizance. Otherwise, it's the prerogative of a police officer. The court cannot ask him to file the report before a particular day. Suppose he fails to file the report before a particular day, the accused is entitled to default bail. Understand? Except he releasing the accused on default bail. But of course, you are also correct. Supreme Court said the court can monitor. Superior courts can monitor. Understand? Superior courts can monitor also. The monitor is different from interference. Understand? Dictating terms is different. Or supervising is different. Supervision is different. But what the Supreme Court said cautiously, Mother Bill law plus Ishwar Pratap Singh versus Union of India. They said, of course, that the court can, Superior Courts can monitor. Suppose investigation is totally served the wrong way. Understand? The court has to separate things. It's not interference. Normally, we find magistrates visiting jails and conducting identification parades. Understand? Recording the statements from the witnesses on 164. Understand? Recording dying declarations. Or conducting searches, issuing search warrants and all these things. We are under the impression that the court is interfering. It's not interfering, it's only assistance. The court interference comes only when court takes cognizance under 210. But now this judgment, Ishwar Pratap Singh's case, 2018, what the Supreme 2018 13 SCC. 13 SCC case 612. 2018 13 SCC case 612 is a beautiful judgment, we read it. They say these three distinctions they have drawn. Superior courts can monitor. Monitoring is different. Interference is different from monitoring. There are all the interesting points with regard to investigation. Those things they discuss. Those things they discuss there. The adversarial system is also discussed. Lord Denning, Jones judgment, of course, you read it. Of course, I suggest all the law students to read the books of Lord Denning. The 3 books of Lord Denning are very much available in Hyderabad also. You can go anywhere. Andhra Law Times, of course, Asian Law House. Where you find these books, Himalayan Law House. 3 books, very good. The process of law is one thing, discipline of law is another book. Thank you, friends. I have taken much of your time. Thank you.
Thank you, sir, for the knowledge enriching session. Now we shall proceed for the felicitation of our guest speaker. I request Dr. Aparna ma'am to join for the felicitation. Now I invite Ms. Chandralekha BSc second year student of RBVRR Women's College to propose vote of thanks.
Good evening everyone, I am Chandralekha from RBVRR studying in BSc second year. I am here to present the vote of thanks. I would like to express my sincere gratitude to our esteemed speaker Sri C. Hari Krishna Bhupati sir for today's enlightening lecture on investigation under Bharatiya Nagarika Suraksha Sanhita. The session was extremely informative and thoughtful, provoking. Sir clearly explained important aspects such as objectives of BNS, changes from Criminal Procedure Code, new provisions related to investigation and use of technologies and forensic evidences in criminal investigations. These points gave us deeper understanding of the procedure reforms and their practical application. I am sure the knowledge will help us in our future career and studies also. Once again, I sincerely thank Sir C. Hari Krishnan Bhupati sir for taking the time out of his busy schedule and guide and inspire us.
about. So we will start about, So first and foremost, how does this forensic science enter? Because you have a legal background with you, so what is the role of FS, that is forensic science, in the criminal justice? When I'm talking about the role of forensic science, it is not only as an awareness, but because you are from the legal background, I want you all to understand about it, where you can pull up the experts who come to depose their evidence, and where you can help being the perpetrator of the crime to be punished is very important. So this class, I suppose, will be more useful to the legal persons, because I want you all to understand it. Maybe at the end of it, I will take the questions. Right. Now, crime scene management. It starts, the forensic science starts from the root level. That is, when I'm saying root level, wherever the crime happens, how the crime scene should be managed, and who are the people apart from the first-hand respondents, that is the police, who can manage this crime scene is very important, because the story starts like a flashback. So it starts from the crime scene itself. So how do the people who are involved in this, looking into the crime scene evidences which are found at the scene of crime, what is that, how they have to manage, what knowledge they have to have, and what is the scientific principles in managing it. It's not just time management or any other goal management. It is how the science, it is written. According to the facts, according to the scientific principles, the people who handle these evidences at the scene of crime is very important, that you have to follow certain guidelines. So these are some of the guidelines which I am going to run through within 1 hour. I'll try my level best. Right, start. So when I say a crime scene management, I just told you that it is an approach towards the collection of whatever the clues or the scientific evidences which are found at the scene of crime in a systematic, legal and scientific. These are the 3 important ways how it should be collected. So you should have either of these 3 or all of these 3, depending upon the situation. So it is a systematic, legal and scientific approach of what? Of not only securing the clues or the physical evidences which are at the scene of crime, but also looking to the chain of custody. Chain of custody is nothing but documenting everything. Later on, maybe after a couple of years also, you should be able to know when, what, who, where and how. So these things can be recorded right from the first stage itself, that is the crime scene management. So these systems, the process of securing these, documenting that, everything you have to, you in the sense that the respondents and the other persons who are handling it, they have to collect it from the scene of crime, and they have to systematically and scientifically preserve these particular physical evidence without any contamination. That is the main aim, is to prevent further contamination. I use the prefix of further because almost all the forensic samples are contaminated. We do not know how they are strewn about and where they are. So already contaminated, already in the form of disappearing or decomposing and all such adjectives to it. So it is very necessary that you will not add a special thing to it by contaminating it. So when I am saying contaminated, it means that whenever you are handling it, you have to handle with care. So that there are certain precautions as to how you have to lay your hands on these particular physical evidence which are found only once in when the crime occurs. Again and again we cannot pick it because it will not be available for us. So it is very important that they have to be openly very vigilant in doing so in a systematic way. And as I told you, all this is necessary because of one particular thing, that is the chain of custody. Chain of custody. So whenever they are handling it, right from the crime scene till the prosecution, till the verdict is finally done, where the evidences are, how they are collected, what are the documentation, at that particular stage where exactly is the physical evidence, and how it is that particular physical evidence, how it is. These particular things, documentation all together means the chain of custody. When there's physical evidence, at the scene of crime will be under the custody of the first respondent, that is the police, and also the scientific people who go there, like our previous sir was telling about the clues. So their responsibility is to handle them, they have to preserve it. So that is the first role, the first entry of those people. And then later on that will go to the concerned departments. So it can be food lab, or it can be bomb labs, or it can be FSL, so wherever it is. So same thing again for the second step, how it is going. What are the documentation? What is the condition? Is there any tampering, or is there any the loss of the integrity of the officers over there? So everything should be not manipulated. That is why the chain of custody is very important, because it will ensure the integrity not only of the person who is handling it, also the product, that is the physical evidence, that integrity also should be there. So because it will help the court while the prosecution is being done, because these thorough steps, that is the securings or surveying, that is looking into it, and the documentation. Documentation again is of two types. Writing is one, videography and photography is another one. So those things are very important, and later on all of them should be sent to the laboratory, and once a report comes, at the initial stage you may think that it is a suicide, any case for example, but after the reports are radiated from the lab, there will be a version change because of the reports which speak, it may be a homicide or vice versa, whatever it is. So these particular steps not only help us to preserve all this documentation and everything, the physical evidence, but it will also help us to reconstruct it, rethink about it, how this might have happened. So the reconstruction is also a very important step in this, where it supports and it identified who the criminal is, and it will also help the prosecutors in trying to nab the offender. Next slide. So when we are talking about the crime scene, because that is where the initial stage where you get the physical evidences, not all the cases, as we talk about the sections we will come to it, but for now you understand that the scene of crime, what exactly is the scene of crime? That is a scene, a particular place where the crime has occurred. That is the scene of crime. Now in this scene of crime only you will see that the physical evidences are found. It will not be available in any mall, it will not be available in Google, it will not be available anywhere, but only in the scene of crime, that too for a certain period. If you say tomorrow is Sunday, I'll come back later, I'm on a vacation or something else, and then I'll come back, the crime scene will not be there. These particular physical evidence may deteriorate, it may vanish, it may transform, it may disappear, or it may be disturbed. So that is why initially the priority is to first identify them and pick it up scientifically. Now, few others may have no such scenes. That is, scene of crimes may not be there. For example, document, there is a document of disputed signatures. So what is the scene of crime? You don't have a scene of crime. The document itself is a disputed document where two persons are in disagreement. So in such cases, the embezzlement of the money and all, you will not have a pakka scene of crime as such. So depending upon the case, you will have the scene of crimes, like the cheating case or the forgery case or the embezzlement or the conspiracy case or the, so such things will not have a pakka crime scene, you do not have it. Next slide. Now, when we are talking about the scene of crime, there are two types of scene of crime. One is the fixed one, another one is the, one is the indoor and outdoor. Indoor, outdoor means there is a boundary for it. When the crime scene we talk about, there is a boundary, 4 walls are there, means a limited space, that which is earmarked within that. It can be within the car or within a room or within a building premises where the boundaries you can know about it. So these are the indoor, where you know from where you have to start, from where it ends. Outdoor, sky is the limit. We do not know how or whether that is the actual place or not, we do not know. So we call it as an outdoor. So these outdoor crime scenes, actually the crime might have happened there or might not have happened there. For example, a little passing remark remark I would like to say about the Disha case, that is Priyanka Reddy's case, where the actual, the burnt body pieces were found under the culvert. That is not the crime scene at all. But at the last, the remnants of the burnt body was found over there. So that you can say that it is an outdoor crime scene, because we do not know from where the body was brought and what exactly has happened before it was burnt. So that becomes the outdoor. Otherwise near the beach, like that. Even in a flight also it cannot be outdoor, it is indoor, because within the flight, that is the area is earmarked, right? So that is it. So, here crime committed in a carrier or a vehicle in a burglary or a robbery case where the house is looted or that particular premises is looted. So that is all indoor, where we can know the boundaries. Right. And we say that for the purpose of examination, the scene of crime committed in a railway carriage. Now even that railway carriage is an outdoor or indoor? Indoor. Because carriage, space is earmarked. A boat or such, all these are the indoor crime scene. Next slide. Right. So even if it is the indoor or the outdoor, again depending upon the background or the history of how that crime has occurred. So initially you cannot decide and say this is the actual crime scene, because actual crime scene is where actually the murder or that offense or the crime corpus that has happened, like that will be the initial crime scene. But a person might have killed a person over there, took that body and thrown it somewhere, right? So it becomes the secondary crime scene. For example, if a person was strangulated and the dead body, after ensuring that that person is dead, the body is taken and dumped into a well. So the well becomes the secondary crime scene. Unless the report from the lab comes, we cannot say whether it is a primary crime scene or the primary or secondary crime scene. So secondary is where the body was found maybe, but actually what has happened can be known only after the report is radiated from the lab. That is why it is very necessary that before forming an opinion about how this crime has occurred, it is very much needed that the police, the IO should wait till they get the report from the laboratory. Initially it may look as something, but because of that, the reconstruction of the crime scene becomes very important. So only when you are able to reconstruct the crime scene after receiving the report, it will be easy for the IO to decide whether that particular crime scene was an actual crime scene, or it is a primary crime scene, or it can be a tertiary crime scene. Here I would like to quote one particular example. There, one particular case was registered with the police, and the police have gone to the site. That is the scene, and they found a dead body over there. And when the police started their investigation, they found to know that the dead body has no link or no relationship with the flat. In that particular flat basement, they found the body. Now when the people, inmates of that particular apartment were asked, the watchman was asked, nobody said, we know this person, but he doesn't live over here. We do not know how the body has come over here. So what is the doubt now? That is not the actual crime scene. So from where did the body come and be dumped over here is the question mark for the IO to solve it. So that is absolutely not the actual crime scene. So it can be secondary, it can be tertiary. And as the police were going around and searching the crime scene, they found that on the parapet wall, which was there in that particular apartment, there was drag marks of the blood, as if somebody has pulled that particular body. So they were thinking now how these particular blood marks are there on the wall as such. Suppose you touch the blood and you put it, maybe fingerprints will be there or some stains will be there, but it looks as if somebody has pulled it, the drag marks were there. So that was a questionable, from where did that drag mark come? So again they thought that the body will belong to the adjacent apartment. There also they inquired. They said no, this man doesn't belong to this apartment. So the drag marks, from where did it come? So one particular answer was they might have brought the body from that side to this particular flat by pulling the body. But from where that body has come to that flat is again questionable. So here what happens, I'm trying to throw light that the secondary or the tertiary crime scene is very important for the IOs to decide. Then only if you can look into the motive of why that person was killed and the background of that, then maybe you can just link up and say that how this particular body has come into that particular vicinity of the apartment. So it is not known until the reconstruction of the crime scene happens, until the report is received from the laboratory. The IO cannot decide in many a times, in many a cases, whether it is what type of a crime scene it is. Right. Next slide. Now, why is necessary that a crime scene, you need to think about so much about the crime scene. We should be bothered only about the physical evidence. But why the crime scene? Because in the crime scene only the physical evidences are stood there. Right? So that whole area becomes very, very sensitive. It is very important because once it is lost, it can never be reconstructed again. The crime scene cannot be. It is only one time. Suppose there is a road accident. You can't say, you can't close the road. There was Dilsud Nagar blast. And within few minutes, the road had to be cleared because of the traffic congestion and all that. So you cannot, so minimum time, maximum answers for the questions of the IO should be solved. So this can happen only when they thoroughly examine the scene of crime. So the objectives of the crime scene inspection is very, very important. The IO should have a microscopic eye in order to, look for any such physical evidence. Because not all physical evidence you can just identify it by laying your eyes. Some are in macro level, some you don't even know. It cannot be seen by the naked eye. So it is very important how you inspect it. So the reason for this particular crime scene importance, the objective we can say, is it helps to link. The linking of the crime scene and the objectives, the crime scene and the suspects, the crime scene and the victim, and the crime scene with the material objects or whatever it is, where the link is established. So this inspection supplies the missing link of the chain of evidence between the crime scene and the physical evidence or whatever, the 4 ways. Another one is to strengthen the weakened link. So once the IO is looking into it, he can try to, now for example, just now I've quoted that the drag marks of the blood stains on the parapet, from where did it come? Those are the weak stains, but weak links. But it will definitely give some way, throw some light about it. So they will be able to concentrate not on the body of the person, but from where that has been thrown into this particular place. So that strengthen the weakened links and enable checking of the accuracy, whether whatever they have laid their hands on the physical evidence, whether it is accurate or not, whether it is manipulated or whether it is, they may think that it is it. For example, in narcotic cases, some consignment of a person, he is in a position of white powder. So they cannot think that that is some NDPS substance. That white powder can be salt, it can be sugar, or it can be anything. So unless it is tested in the laboratory, you cannot conclude and say that this is what it is like. So that is why it is very, very important that the accuracy of that particular physical evidence is collected. That is why in the narcotic case, more than the submission of the physical evidences or the material objects itself, first and foremost the IOs, once they lay their hands on this consignment, it can be from the, these peddlers, it can be a Switzerland fellow or some Nigerian. They can't straight away nab them and, put them in the remand because of the other country being involved. We have certain rules and regulations. So until they prove themselves, until they are accurately, say that this is an illegal position that that particular person is having, he cannot do anything about that person. So that is why the task force persons, before submitting the case in the laboratory, they come with a 0.5 or 1 mg of that particular caught consignment, and they say, ma'am, will you please check and tell me whether we can, arrest this person like that. So because of that, checking of the accuracy is very, very needed. And the third one is to study the material object. What is there to study? Like, whatever you see may not be true. unless again you have to get it examined in the laboratory, then only you can say that that is a real precious physical evidence or the material object. Otherwise we cannot appreciate the value of that particular physical evidence. And as I am always repeating, it helps in the reconstruction. So thorough inspection of the crime scene will definitely help the reconstruction and then enable clearing of the doubtful points. That is why the IO always should put himself the questions, why, where, what, all those 5 questions. When he can answer them, then only he will come to know the motive or why this has happened. In case of further confusion, wait for the evidence from the laboratory. So at the preliminary stage only they have to collect or they have to clear all these doubts. And the most important step for the IO is that as they are collecting all these physical evidences or the material objects, whatever you call it, they have to ensure that even the controls are collected. Suppose the blood stains are there. In order to know whether the body, I'm talking about the example I have given, whether the that blood stains which are found on the parapet wall, whether it belongs to this particular person whose body is there in that particular apartment. Suppose his blood group is something else and on that wall the blood group is something else. That means that person's body was not dragged, isn't it? So there is a controversy. So in order to clear all those doubts and in order to have a comparison done, it is necessary that the control samples are sent. Even if it is a rape and murder case also, the control sample for the semen. It is already always a doubt for the IOs that whenever they collect the vaginal swabs of a sexual assaulted woman, they think that the semen of that particular suspected person only should be collected. But that is not correct. Not only the semen, if it is available, it's fine. But otherwise, even the blood also, from there also the DNA can be segregated. So not all the time actually, that knowledge of what to collect and all should be there. So it is very much important that control should be collected. Because after all, in the laboratory, we mostly do the comparison. We compare with the crime samples and that with the controlled samples and then come to an inference whether what the report should be given, whether they are deceptive ones or they are matching or not tallying or whatever it is. Next slide. Yeah, this is a slide. Just now I was thinking how the crime scene is connected to these all the 4. So this particular figure should be always printed in the eyes of the the IO and also the defense lawyers or the advocates over here. Because when you can think about it, you will be able to question the defense or the advocates, whoever they are. Next slide. This is about the crime scene we were talking about. Fine. You have, you know about what a crime scene is, you know what you get at the crime scene, you know the value of the physical evidence, now you know how it should be collected, and you know that how important these particular evidences are, that they should be immediately collected as soon as the crime occurs. Now the collection is there, the treasure is there in the hands of the IO or whoever is handling it, right? Now where do they send this? They have to go to the forensic lab only in order to get them examined. Or it can be the physical examination, or it can be the chemical examination, or it can be the instrumental examination. Whatever it is, it has to be gone to the laboratory. Now, in the laboratory, here the value of the forensic science enters, right? So, what is forensic? The word, I think the morning session must be an introduction session for you. The word forensic means, it is a Latin word, but it means belonging to the court. But this physical evidence belongs to the crime scene. This physical evidence can be linked to the, the victim or the suspect or the crime scene, whatever it is. And these crimes, physical evidence are sent to the laboratory. Now we are talking about forensic belonging to the court. Now the entry of the court. Culmination of the entire process, right from the scene of crime, it will have to go to the court. That is the end. The end is over there. Because the court there, after going through the evidences, the report and the deposition of the experts, subject experts who come there, be it from the forensic science or from the police themselves or from the medical people, after listening to their deposition of their evidences, now depending upon the availability of the report, now the burden is on the judge to decide, after listening to the defense and the lawyer, the prosecutor, to decide whether the suspected person is a guilty person to be punished, or he is just an innocent being implicated in the crime. So if it is just an innocent implicated in the crime, based upon all these whatever we have told about, the judge will decide to exonerate that person. But sometimes, or most of the times, what happens, because of the non-scientific way of approach to the crime scene, because of the non-scientific lifting of the crime, the physical evidence, because of the lack of scientific knowledge of appreciating the value of the physical evidence, the whole process is done. And when the end comes, when the prosecution have to decide whether to give punishment or not, most of the cases are just removed of acquittals. Now this acquittal may be, the major portion may be because they are innocent, exonerating them, but because of the negligence of the IO in handling the physical evidence, because of the wrong way of lifting the physical evidence, sometimes the case is diluted. And then the judge has to forcibly, acquit that particular case. So that is the reason the crime rates will go high. Because the acquittals are more, the conviction is less. So that will definitely affect the society in such. So in the criminal justice system, the responsibility of carrying all these things not only lies on the police and the forensic, but also on the judiciary and the prosecution. Because all the four pillars, along with the medical, the four pillars are very important to do justice to the society, so that the society can be crime-free, so that most of the cases, it can have the conviction rather than acquittal for silly reasons, right? So this is I hope I'm not very fast. Am I clear? Yes, thank you for the response. Yes. So as I said, the forensic means it belongs to the court. So you know how important these first steps are. As the baby is born and as the baby is learning to walk, how precious and how much you appreciate the initial steps the baby takes. The same way here also, the initial processing of the crime scene also is very important. If it is well maintained, then in the end, the culmination of that whole process will be the punishment of the real accused person. Okay. Now, the forensic science can be defined. That is the reason that the forensic science will help the prosecution or the advocates or the police or whoever that is to recognize the physical evidence. Yes, this is the physical evidence. Now, where does this recognition come? Suppose there is a handwriting in dispute. Somebody has just forged the handwriting. So there, the forensic science, after the examination, physical examination of that particular handwriting, they will recognize whether that particular signature is the original signature or it is a forged one. So there, the recognition comes. And identification, like as I told you in narcotics, to identify actual NDPS substance, to identify the actual blood group, or to identify a major perpetrator through DNA or the fingerprinting is very important. That is the identification. And here, the DNA or the fingerprint, it is the individualization. Suppose there is a gang rape. 4 persons are suspected in that particular gang rape. Did all the 4 of them commit the crime? Or one has planned it, one is executed, another is keeping a watch, and another is just a superior man, mediator like that. We do not know. So in order to know who exactly is the person, who is the actual criminal, so that is what is meant by the individualization. That is to nailing the perpetrator of the crime. That can be done by 2 techniques. That is the DNA is the authentic one, and also the fingerprinting, because it is very unique to one particular individual. Okay, so that is what individualization means. And then in the last, the evaluation. Once the report comes, the reconstruction and the evaluation, how valuable is the physical evidence, the evaluation is done. of the physical evidence depending upon the application of the principles and the objectives of the methodology that forensic science has it. So this particular forensic science, it can be said as a simple sentence, it is the study of the material objects which are lifted from the crime scene, which are also called as the physical evidence, right? So all these physical evidence are collected from the scene of crime and are transported scientifically to the laboratory for further getting the report and examination being done, whether it is the chemical or the physical examination. Next slide. Right, the hero of the FSL is Edmund Locard. That is why this particular principle, the main principle, the heart of the FSL, is called as the principle of exchange. This particular principle is taken after his name. He is Edmund Locard. So what does he say? What does he say? When two objects come in close contact with each other, collision. So there is a transfer of material from one surface to the other surface. Suppose the hit and run. Two cars, one is white car, another one is a colored car. When both of them collide with each other, the paint of the white car will go on to the other one and the colored paint pieces will be transferred. Vice versa with the glass pieces and all. So that is understandable. But here this particular transfer, exchange of transfer, that is principle, can be explained even in the sexual offense cases also. When two bodies come in collision, because there is a defense, the lady has a defense where she might pull the hair of the person who is trying to commit rape on her. She must have scratched his body, she might have bit his body, or so when she is doing it, the hair samples of the accused may be transferred to this particular female, and the female's nail, the bite marks and all the marks can be transferred onto the male body. So this is also exchange of this particular material. So that is why this particular exchange principle is also very, very important, because that will help to link the crime, the victim and the actual criminal, the offender or the perpetrator. Next slide. Yeah. So when I'm talking about the physical evidence, like you go to a hotel, you want to know what the hotel management, what is the menu like, isn't it? So what are the different types of the physical evidence which are there, which you can identify in the scene of crime is, it depends upon the case. It depends upon if it is a firearm, you look for the firearm concerned physical evidence. If it is a sexual offense, you look for the hair or bite mark or the, the body fluids being transferred from one body to another. If it is a poison, maybe the person who was administered that poison or who has taken it, he may vomit, there may be motion or all these things. So even that can be, seen onto the external, the other areas. So here, sky is the limit for it. So you can just run through it. Already 1 hour late, so I will not go by each and every physical evidence. Actually, my plan was, whenever we are talking about the physical evidence, I thought of telling you each case study. But there is paucity of the time. I cannot, bind myself for this slide. So we'll go further. Yes. Now, as there are many types of scene of crimes, even physical evidence also, you can say that you can categorize into two things. One is movable, another one is immovable. As the meaning, the English word movable and immovable means that which can be moved, that which cannot be moved, right? Suppose there is a murder happening and there are the blood stains on the road. Now these blood stains have to be transferred to the laboratory. They can't dig the road and take it to the laboratory. What do? They remove the swabs of that particular blood stain. If it is a liquid is there, they try to collect the liquid blood from there. If it is a dried one, they try to scrape it. The same thing if it is on the wall also. So those on the furniture of such places like wall, roof, because there is a blast, task force blast. You all are, very intelligent target group over here. You must be knowing about that case, task force blast, where the human bomb has entered into that particular police station and where the whole police station was blasted. And it was such a deadly blast that the pieces of that particular person, when the gillette sticks, when they have exploded, his body flesh were onto the roof itself. On the roof, the pieces were hanging. So it was very, very dangerous site it was. So like that, we do not know where these particular physical evidence. So if it is on the roof, that will become movable or immovable? Movable. Immovable. So how do you move the physical evidence? Collect it. The piece by piece you collect it and then you pack it and send it. If it is on the specs, maybe one person is sitting and reading and there is a stab over there, or he has been, firearm accident, something has happened, somebody came and shot him. So there is a blood spilled over the, his specs or a book and all. So is that movable or not movable? Movable. The whole book, but the only criteria here is dried. Don't send the wet things. It can be, with the blood, or it can be with the semen or vomit material. You have to ensure that it dries. Why? Because if it is wet, not only the contamination, if it is wet, it will attract the fungus. And that will hinder when the chemical examination or such examinations are done over there. So it is a golden rule for the IOs that when you are collecting a blood shirt which is soaked with blood, or a bed sheet which is having the stain marks of semen, like that, they have to ensure that it is dried. Dried means you don't have to have a big thread over there, hang it with the clips. No, dry it under the shade or under the fan. But it should be in a dried condition. And then you, depending upon the sample, whether you have to pack it in the paper or in the polythene cover, it has to, we will, as we go, we will also discuss about that. So now here we are only talking about the movable and immovable. The first one is the fixed one. Fixed one is immovable. You cannot move such evidences. The whole structure cannot be moved, but the evidence can be collected from that and sent to the laboratory. Like, as I said, here I have shown that it is the stain marks on the wall. Next slide. Next slide. Yeah, these are on the specs or a book or on the table. These are movable. You can just collect it, or a cell phone. Like that, you can collect it and you can send it. Suppose there are blood marks on the carpet. Some houses will have a big carpet, whole of the area. So there you cannot move the carpet. Neither can you take a swab from the carpet, because even the fibers will be there. So ask the permission of the inmates of the house, and till that, you have to cut it. But I'm an IO, I'm a uniform card, there will be again dispute. So take the permission from them amicably, you have to go and do the collection. Okay, so these hair samples or fiber is from where the clothes. There was one particular case at Madhapur, right? One MNC student went missing. And late night, the police have received a complaint from the parents of this particular lady that their child, that their daughter did not come home on the regular time. She will be home by maybe 6 or 5, whatever. But beyond certain hours also she has not come home. So they were little disturbed, they waited, they have contacted all their friends, and friends said, yes, we know that she came to the office. We know that at a particular time she left the office. The CC cameras in the office also have that recording of this lady punching her last, biometry and going out of that. And she was standing there outside the office for the cab. But as the cabs were not coming that way, she was moving here and there. And as she was walking, after a certain time, certain distance, the CC camera coverage was not there. From there, we do not know where that lady has gone. So this was the complaint from the police, and after the complaint was lodged by the parents. Now it was a question. Then with the help of the CC cameras, the IOs have done a very beautiful work. Whatever the CC cameras were there beyond that, they first tried to know what color of vehicles have passed from the time that that girl was waiting, right? And that is how they have tried to screen down everything, minimize everything. Scanning was done, and at last they have identified some maroon car was the culprit car. Where exactly, because it was coming onto the next camera, all of them were passing. But for these 3 vehicles, they did not capture this particular passing of these particular vehicle in that particular CC camera. When they have enhanced that, zoomed it, and they knew the name of it, they tried to know who is the owner of that car, and out of these 3 cars, they have said that 2 cars, the houses were there, and they came to know that genuinely the cars were somewhere there only. It was nothing to do with this particular. But one particular car, they could not get any information, but they know that that is the crime car. I mean the crime car, where exactly this particular happened. And after 2 days, there was a complaint for a little distance that one particular foul smell was coming. Some passerby have complained to the police station, and there they came to that particular site. They have identified one dead body of a female, where the whole face was mutilated beyond recognition. So they did not know whose body it was. And distance from that body, they found one particular bag which has her ID and all. And through those particular belongings, and after the family claim, and they have recognized this particular girl by the jewelry and the dress that she was wearing, that the body was identified that it belongs to the missing girl. But she was brutally murdered beyond recognition. The body was now taken to the medical hospital, where the forensic doctor has conducted a test on that lady was sexually assaulted. And all this has happened, so there must be some culprit. But who is that particular perpetrator of the crime is a debatable question again. I was, vehemently they were searching and all, and after 2-3 days, they were trying to identify in that particular vicinity the movement of the car. And finally, they have traced one particular service center where the car washing will be done. They went there, they inquired, and to their surprise, they saw that the car was over there. But it was neatly washed car, covered everything. And once they have inquired, they said that this car has come for servicing. 2-3 days back, this was ready. We were waiting for the owners to come and collect it. When the owner was contacted, he said, I had some emergency work, so I left the city. And yes, they told me that the car is ready. So yes, that is my car. I will come and collect it. That the identity of that car is now established. But why did that car go out? When everybody in the garage were asked, everybody said, no, nobody has taken the car out. But the car has definitely gone out. After a couple of, after a day or so, again the IO have come. They have inspected the whole car and everything. But there also they could not find any mud or any such thing, because it was neatly washed. And the police, Telangana police are very clever, because they were trying to look into the rooftop of the car. In the crevices, they found one lavender color dried flower was there. Right? In Telugu they say Vangapulu. That. So that IO, because he thought there's something, the constable, he just collected it with the forces, put it in a cover, and he kept it. And seeing that fellow do it, another constable said, now I have to also do something. So he went into the car and he took this, the poly light and everything. He was looking, he could not find anything. But still, very blindly, he put this, the sucker, that is vacuum cleaner, and all the seat covers and all was pulled. And that debris, they were searching, there they found one fiber, which has come from that is the cloth line, that fiber from some cloth. Then they tried to call that particular parents, because that was a gold color, very peculiar color. They said, do you recognize this? The moment that the girl's mother saw it, she said, yes, this belongs to my daughter's chunni, because that gold dory, that is from there. That means the body was there into the car. But they are not accepting it. They have refused. And that chunni was collected from their parents' place. And that chunni and this fiber was sent to the laboratory. Through the wear and tear. It is not a new fiber. They have washed it, don't know how many years. So that wear and tear and that fading of the color, everything was matching from this one fiber to the chunni. The whole the chunni what was sent. That means to say that definitely belongs to that particular girl. Again they have gone with the polylite and all. They saw the stains. The semen stains were there. And then they have collected that semen stain and sent it for the DNA. All the people's blood was collected from the service center, was sent for the DNA. Out of that, one person's DNA was matching with the stains of that. That means to say, and the swab which was collected by the doctor of that dead female also was collected. And then they came to know that they were trying to link it up. then he confessed and he said. So here, the integrity of the officer is one thing. The patient's way of going through all this observation is another thing, which has really led to crack this particular case. So kudos to the police people who are having such observant microscopic, yes. So the duty of the advocate over here is, even if Hanuman doesn't know the strength the Hanuman has, isn't it? The people, we look at him and say, wow, Hanuman. So you people, you identify the strength of the IO. You tell them what is needed. You tell them, ask them the questions which can lead and really help the case to be solved. So that particular awareness should be there with those particular law background people also seated over here in this particular hall. That is what I mean to say. And the glass and garments and everything, you know about it. Next slide, ma'am. Yeah. And we know that where do we look? Not in a mall, not in a shop, not at home, but wherever the crime has happened. That is, we look at the crime scene and then we try to locate who is the perpetrator of the crime. And we also look into the victimology, that is, we also look into the version of the victim. So all the three are very important. Next slide. Right. So we know the objective of the crime scene. Now we have to know what is the objective, what is the value of the physical evidence which is found at the scene of crime. That also you should be there. So that physical evidence may prove that the crime has happened, right? That is proving the crime has happened. Second thing is, it is the element, the key element, the vital, clue, very valuable, very treasurable. So it may also throw some light upon how and who the perpetrator of the crime is. And of course, it will definitely help in the linkage, establishing the linkage. And it will also help you to identify the real victim also. I'll tell you why I have put this sentence. And then sometimes when nothing is found, no evidences are there, not all the crime scenes will have ready elements, come pick me up, they won't tell like that. There are certain crime scenes, where nothing is found, but crime has happened. So what do the police, the IOs do? They rely on the witnesses' statement. Those who have seen it, those who have heard it, those who have knowledge about this, so they rely on the witness. Now this witness, just because they are talking to the uniform service, they may be to prove the involvement or the exoneration of the innocence. There is one beautiful technique, that is the test, that is the IO should depend upon the psychological test. That is, brain fingerprinting or the narco analysis or the lie detection. Out of these three, why these three? Why not these three? Why only this? We will talk about when we are talking about that. But here I want you all to only understand, when there is no direct evidence available at the scene of crime, you need to depend upon the psychological test where you can eliminate, at least the innocence can be eliminated for the IO to concentrate on the minimum number of people who are into the crime. Right. And of course, it protects the innocent. Next. Our sir was also talking about, the previous guest speaker was talking about the role of clues, right? So now because of the change in the law system, the entry of the clues, or indirectly the entry of the forensic scientists in form of the these particular crime scene officers, CSO we say, crime scene officers, is very important because they have the scientific temper. They can understand about these particular value of the physical evidence, how to go about all these things, right? So the clues team, is very important. They are not only there in Hyderabad, but they are also in the districts level, also in the zonal levels, and they are controlled in the districts. They are controlled by the SPs and here by the commissionerates, and each police station, jurisdiction, zonal wise, these people are available for their services, and their services is only to aid the investigating officers. They will help the investigating officers how to go about in searching, how to go about in lifting, how to handle them, how to pack them, and where to transport them. All this the guidance can be obtained by these particular clues people. Next. Right. So, when we are talking about the physical evidence, we only said two types of physical evidence, fixed and that which can be moved. Apart from it, we also can say that there are types of physical evidences. First one is where the investigation purpose, these are very helpful. When corpus delicti, the body of the crime, exactly the crime has happened, like where the body is there, something is there for you all to know that from the normal it has become abnormal, so something has happened. As this CID team has kuch to baat hai, like that, this particular corpus delicti, there should be the body of the crime, then only we can appreciate it, if we can get the crime body. But sometimes the body is not there. So what is there? Other type of evidences like associate, tracing, screening and identifying evidences. Now what are these? We will see it. Next slide. Yes, corpus delicti, as I said, the body of the crime. The body is there. The poison, the person has taken the poison, you have the tin, you have the vomit material. So something to prove that this has happened, like the body of the crime. Next. These are the associate crime. That is, you can link up to the suspect. Right? So, when there is a collision of two vehicles, the broken glass pieces, the vehicle must have run away, hit and run. There is no vehicle for you all to nab, for the police to nab. But the pieces, broken pieces are there. On the tire, if it has run over a person, his flesh or his blood stains or hair may be adhering to the tire, or the thread marks on the tire. All these, broken pieces, the paint exchange, these are all, they will associate, they will be helping in the linking of that particular crime. Next slide. Now these are the tracing. Now they assist in locating the this particular suspect. Like for example, one particular case, I think it was in Lalaguda, nobody was there, nobody saw anything, but one businessman went missing. And later on they have identified that particular person over there. His body was badly, mutilated, everything. Nobody could identify. Even the car was also not his car. Somewhere in others' car he was. But who is that person is only by the shirt that he was wearing, the label that he had, the laundry marks or the tailor's label, or the Grandi Madhavi's case where the suspect's pocket diary was there, found on the bed. Those are called as the tracing evidence or the jewelry. Like, in one of the case, nothing was there, only one ring was there on one finger. Because of that ring, they were able to identify who that particular identity of that particular body was done. So all this is tracing evidence. We can trace to know who is that particular person. Next slide, please. Now this is screening. Suppose there is a dead body. He is in this particular position, his face is down onto the ground, and there is pool of blood. Unless that body is turned back, he is dead. There is blood oozing out. There is no movement of the body. He is dead. Now how did he die? Did anybody swear? Or did he fall and he broke his skull or something like that? The blood has come. Or somebody has shot him with a firearm. These are the screening evidence. You screen. No, this is not strangulation. This is not stabbing. Or this is not a firearm like that. But if there is such marks over there, so it can be understood that it is due to the firearm. The shooting happens. So where you screen, not this, not that, and you just fix onto one particular thing. So these are spread of that, the shape of that feet, we can know who that particular person is. So that will be your trying to identify how many people have come, from which direction they have come, from which direction they have gone. So these are also very important. Every IO should have a notes about whatever we are talking about. Because these are the preliminary things which will really help to understand the core value of the particular case, how it has happened like. Right. So footprints or footprints, sometimes occupational murder, like some blood prints will be there, or some oil industry is there, oil prints are there, like that, we will not know. So these are very important and they help a person not immediately, over a period of time. So over a period of time, the sample is changing. What can that be? The best example I would give is, if suppose I give to Aparna madam, I give her the ice cubes. I say that, you see, I'm giving this tiffin dabba full of ice cubes. Madam, you go and give to the Vice Chancellor, and that is at the midsummer, when the temperature is 50 or maybe beyond that, and I'm giving her in a steel tiffin, and I'm not giving her any ice packs or nothing. I'm just saying, madam, go. And don't take a vehicle. Walk and go and give it to Vice Chancellor. Say that Dr. Anita Evangeline is giving cube of ice. She will definitely take it and go and give. The moment the box is opened by the VC, what does he see inside? Water. But what is that I've given, madam? What is that he is receiving? Water. What has happened? There is a change. Over a period of time that has changed. And suppose it is in a cold condition, -degree. I'm giving her water and asking her, I have to go and give her, I'm giving you grape juice or something like that, stimulation, madam, energy drink, madam, and she goes and poor thing he opens and everything is in ice. He'll say, what happened? What do I do with this ice? Do I bite it? My teeth are very weak. They're very sensitive. I can't do that. So what is happening? It is changing. So here also at the scene of crime, whenever the physical evidences are there, it can be due to the rain, it can be due to the sun, or it can be due to the wind, or it can be due to the onlookers who are coming, who may stamp the evidences over there, or it can be the pet animals also. There is a chance of that being changed to another form. So before it decomposes, before it is getting spoiled, it is better that as soon as possible, ASP, as soon as possible, the young generation language, isn't it? ASP, okay, even I'm learning that. So ASP, as soon as possible, you have to identify it, lift it, and pack and send it to the laboratory for the correct type of examination to be done. Otherwise, the sent sample will not be useful for the forensic examination, and in the last, you will not have a concrete result at all, and the result will be inconclusive. Then the IO will say that, madam, we have sent this, we have sent the blood, we have sent the fetus, but what is it? Okay, you have sent. In what condition did you send? It was beyond the decomposition, beyond the recognition, or beyond the sample being used for any such analysis at all. So because of that, as soon as possible, before it changes, it is getting transformed. The sample should be collected and then should be transported to the law. And law of probability means not all samples which are sent to the laboratory will have 100% results, because it all depends upon the progressive change. It all depends upon the quantity, how much you have lifted from there. It depends upon the condition of that particular sample. If it is decomposed, after 1 week or 10 days you are identifying the body and you are asking whether any poison is consumed by that. Already the body is decomposed, so it is not possible. So in such cases, the probability of results from the sent sample is 50-50 Mosca Jessica type. It can be yes, it can be no. That is the reason, the IO should be as quick as possible in order to, lift it and send it before it, getting deteriorated. So that is about the law of probability. And the law of principle of exchange, we have dealt it in detail. And the last also we said, when nothing is available, no evidence is there at all, depend upon the circumstantial evidence. Depend upon the people who heard, who saw or who know about how the case has happened. And even their verdict also, in order to verify their statements, whatever they are saying is true or false, take the help of the psychological test. But this is another principle, that is law of circumstantial facts. Men may lie, but never lie. True. Next slide. Yeah. So this crime scene is that important. So how do you process it? As I said, every step has a scientific way of doing it. I do not know, this should have come in the morning hours when Sharda madam might have taken your class, but I'll just run through it. I'll just take a minute for this particular topic, crime scene processing. What you are doing is you are looking into it, you are inspecting it in micro level, and you are searching it, and you are lifting the samples from the scene of crime. So what is the way of doing it? Because first thing is when the IO enters into the crime scene, if any person is there, in the last breath of life, he's just battling for life. See that the medical aid is given to that person. But don't neglect that person and concentrate only on the physical evidence. Because more than the physical evidence, the life is very important. So if there is any injured person, see that the medical attention is already had from the doctor to that particular person. The next, secure, condoning. That is, no crime scene, do not touch. That you have to condone, separate the walking area and the crime scene, segregate it, quarantine it, so that no onlookers, nothing may disturb the sample till the IO collects it. And it can be secured from, as we have discussed, it can be from the intruders, that is inmates, or the onlookers, or the animals, or the climate, whatever it is. Sometimes even the photographers or the media and the people who are inquisitive as to what exactly has happened. Today morning there was an incident at Red Hills Forensic Lab, where the computer section of the forensic lab is all burnt due to the short circuit, they said. But the fire engines and all 4 fire engines were called for, and they wanted to enter to stop the fire and the smoke. They wanted to have a control on it so that they can safeguard the physical evidence samples, the digital evidences and other things. But because of the onlookers, because of the people who were surrounded, it was delayed 10 to 15 minutes. So that will be a loss to the lab itself, isn't it? So that is why, it is always necessary that the photographers and all, should not be allowed at the initial stage. Next slide now. Right. So first, when the police are informed, they have to condone that, they have to secure it, and they have to. And if there are any eyewitnesses and all, you ask them to stay back. You, in the sense, when I'm using this word you, it doesn't mean the people seated over here, it means the IO. Okay? And just don't go to the police and say, Madam said you, so we have come to safeguard. No, and it's just a word that I'm using it. Right. So when the police are informed, when they come over there, if you find any witnesses over there, you try to detain them, and you don't allow anybody to disturb the crime scene. And if it is overnight, you want it to be retained for some more time, because it takes time. You ensure that the police personnel are posted over there, the guards are posted over there to safeguard the crime scene. Next one. And if there is any confusion for the IO, it is should and mandatory that IO should contact the subject expert. If there is a fire accident, call the fire experts. If there is a poison case, call the toxicological expert. If there is rape and such cases where the DNA is needed, call the DNA experts. So you should ensure. So when you are taking the expert evidences, these things you can keep in mind. You can ask them whether they have contacted or with the limited knowledge they have. Because subject expert, they are more than the experts, isn't it? They know the purview. They know in and out about that. So they should be definitely called, because the questions, what exactly they have to lift and how they have to write the letter of advice, what examination is needed, all that they can have from the first information from the experts themselves. Right. Right. And you have to ask them not to touch anything. The golden rule is not to touch anything, even the IO also. Next one. Yeah, the golden rule is never touch, never alter. Suppose something is disturbed, you don't say that, my superior will come, let me put the chair back, let me just wipe it and do everything clean. No, leave it as it is. Right. Next one. How you secure, whether it is a door or the vicinity and all, you have to have the condoning tape, barriers. Next. Yeah, this is also how you, pack it, the chain of custody and everything should be valued and kept. Next. And it will always help in the reconstruction. Again, pictorially they will try to know from where they have entered, how it might have happened. Many number of, rehearsals can be done. And reconstruction can be done in order to know exactly how the case has happened. Next. Yeah. So one thing they have to avoid is contamination. That is a major disturbance, and it is very important. And the second thing is documentation. When, what, at what time, in presence of whom, the panchas and everything, all that should be documented. And the third one is releasing the crime scene. Before you collect, don't say open to the public. Ensure that your work, the IO should ensure that his work is done. Then only it can be thrown open. Till that time, they have to have the control of the crime scene. So these three things are very important for them. Next. Yeah. This is methods of recording. How you record it. First thing is you have to condone, segregate it. Second is the IO should take notes. What he is thinking preliminarily. What is his understanding of the crime? Because after the report comes, he may change his version of what he is thinking. A homicide may become a suicide, and a suicide may become a homicide. He may, suspect somebody, and that somebody can be innocent. Or he will think that this particular person is innocent, but that person may be the actual suspect. So we do not know. So that is the reason, he has to take notes, what he thinks. And videographing is very needed, because not only can you keep that particular crime scene over the years, and this crime scene can go into the court also. The court scene, the judge also can see that. The superiors, the DGP or whoever, the higher officials, they don't have to go to the crime scene, but they can visualize this. So that is why photography and videography is very important. And then the IO themselves have to have the sketches, drawing, from which area, which direction they have to. Yeah. Okay, next. So this is how the search methods are done. Next, all pictorial, I'll just run through it. So these are the notes. Next, search methods. Before, search methods. Depending upon the area, one person can search. Depending upon the area and the intensity of the case, how many people can search? Right? It can be more than one people. In what way? Left to right, or left to right to left, or from the center to the end, or from the end to the center. These are the search methods. Next. These are the without contaminating, because forensic samples are already contaminated, so do not contaminate it more. Yes. So these are the preliminary gloves, and all these things will safeguard the person. Next. Yeah. These are how we are using the gloves. Next mark. Yes. And marking the evidence. 1, 2, 3, 4 marking should be given. Next. Yeah. Not all the time, you can just lift it with the hand, sometimes with the tape. Suppose hair is there, fingerprints are there, which you cannot see it with your naked eye also. The lifting mechanisms, that has to be changed. Yeah, next. Yeah, and the instruments what you have to use, not your naked hand, not even when you are wearing a glove, but you have to ensure that you have the tweezers or the forceps. With this only you can lift them. Next. Yeah, if it is something glass or some liquid is being sent, some poison is sent, or some acid is sent, so you have to, the IO should ensure whether it is top or bottom, because if it is turned, everything will leak out and nothing will be there to examine. So this also should be marked. Next. Yeah, swabs, how they are collected, yes. If it is dried one, scrape it, with a scalpel and all, you have to collect it. Yes, next. If it is a stain, if it can be cut, you have to cut it and remove it. Next. And packing material is also very important. Like for example, digital evidence, you just can't pack it in this. You have to have a separate package, that is Faraday bags, so that anti-static, even if they fall down also, it will not open, or it will not be, the data will not be lost. So Faraday bags, like that, it is very important. Next. Yeah, these are the big ones. Yes, pillows on that, and how the clothes should be, folded, the stained ones. Next. Yeah, how it should be, the IO should have this minimal knowledge. Yes. Suppose that is having seminal stage. What is the semen, spermatozoa? It has a tail, it has a trunk, and it has a tail. The head, trunk, and tail. If they are just holding it, the head will be broken, the tail will be broken, and under the microscope you cannot identify it. The whole spermatozoa should be there. So the stain, how they should fold it also is scientifically very important for us to identify the number of sperms, to know whether the sexual assault has happened or not. Next. Yeah, some of the, for the IO, yeah, next. Do's and don'ts for the IO, it should be. Sealing is very important. How the physical evidence should not be left loose, because chain of custody, that seal and labeling and the pancha signature with the IO signature, date and time. These are the very important things which should be there on each of the material which is packed. Next. Yeah. Next. So we have in forensic lab, we have divisions. The first division is the chemical division. Under the chemical division, we have the toxicology that deals with the poison cases. And next we have the chemistry that deals with the chemicals or the post-blast explosives ones. And then we have the narcotic section which deals with the alcohol or the NDPS substance, the drugs. So all these, these are the toxicological evidences which are collected. Viscera, they say, that is the body. From the dead body also the viscera, that is stomach, intestine, liver, kidneys, said to be safe. So these are collected. From this we will know whether that person has a suspicious death. What is the cause of death? Whether they have consumed any poison or intoxication, alcohol or so can be deciphered. Next. Drugs. Chemistry, post-blast or chemicals. Aarti Agarwal, you heard about, she's no more. But she wanted to commit suicide. She drank cleaning acid, phenyl. And then she was unconscious on the bed. Her maid, identified her, and immediately medical people were alerted. And in the hospital, her gastric, that is stomach wash, was removed. And it was sent to the laboratory. And with that stomach wash, we identified that that lady consumed phenyl. And immediately when the doctor were told about it, they have started the antidote for it, and she survived. Later on, because of the cosmetic surgery, she is no more. She succumbed to death. But we can identify the suspicious death, the cause of death. Yeah. Next. Narcotics, we have already told about the drugs and all the NDPS substance. Yes. Next. Yeah. Next. Yeah, drugs. This is all drugs. Yes. Next. Yeah. Next division is the biological division. In the biological division, we have the biology, we have the serology, and the DNA. Now, DNA is the authentic one, where the direct evidence, it can be admissible in the court of law. And even the other evidences are also admissible, but more so because law of individuality, we can apply to the DNA as such. Yes. Next. So these are the common samples we can find. It can be the semen stains or the blood stains, it can be, or the saliva, it can be even the cigarette butts, because at the end the saliva will be there. Through that even the DNA can be identified. Yes. Next. Now these are some of the samples again, hair, fiber, and another beautiful thing is diatoms. Diatoms, next slide, ma'am. These are the biological ones where the car incident, that lavender flowers, it comes under the biology, where the fibers or the pollen grains, these are identified by the leaves and all. Yeah, next. Yeah, these are also roots, seeds, and leaves, pollen. Next. Sometimes the hair is sent, synthetic hair. This Saki case, Saki, that is zoological, in our zoo over there. One tiger was skinned out, the skin was removed, and it was dead. And later on it found that the curator was into that, and he was the one who wanted to have business with the skin of the tiger. And many a times police will seize these tiger skins to know whether it is the true skin or it is synthetic ones. So even that can be done. Yeah. Next. As I said, diatom test, which is very important, because once the person is dead and his body is thrown in the well, the water is collected from the stomach, the water is also collected, and both the water, when they are compared, the presence of the microalgae, that is these diatoms, if they are absent, that means before the body was thrown into the particular well, he was dead. If there is no diatoms in that, if the diatoms are found in the body, that means that he was alive when he was thrown in the well. So after death or before death, you can know about these diatoms. Next. Hairs and fibers, we have already discussed about it. Next. 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 These are the different blood samples are there, how it is, depending upon the velocity, the force with which it is hit, by the pattern which is made on the wall. There was one particular case where on the mirror, there was the blood splatter was there. And everybody thought that, somebody came and he hacked it. But he was hacked like. But when his body was examined, there was only a minute cut over here. Then the police were very much, in confusion. Later on, the medical doctor was called, and the doctor examined the body and said that he has committed this. He only has cut it. It is a suicide because with the sharp blade, he has cut the main artery, from where the blood comes. So the blood, when he was looking at the mirror and he was cutting it. So when he has cut it, the blood moved out like that and it splattered on the mirror. So everybody thought that it is a homicide, but it turned to be a suicide. Yeah. So as the blood, from the altitude, as you go high, the drops of the blood which falls on the ground becomes more and more. Like that, yeah. Yes, even this. So from the blood stains, the direction from which he was hit, with what he was hit, all this can be with what height the blood has fallen down, whether he was killed here and carried up or killed there and brought him down by the blood stains, you can identify. Next. As I told you, the footprints from the blood or from the oil or transfer of the footprints. This is blood stain transfers. Yes, next. Yeah, next. These are the blood spatters. Next. Next, next, next. Till you see it. Yeah, this is also blood splatter. Next. Yes, next. This is the suicide case. This is the gait pattern. Usually in the dacoity case and all, when the thieves, the robbers, they walk on the wet area. How their footprints, the gait, they will know about it. Yeah, next. Yeah, here comes the DNA fingerprinting. That is the authentic one, and it is the law of individuality, and the credit goes to Alex Jeffrey, who is the founder of this particular DNA technique. Yeah, that's why he's called as the father of the DNA. And for the DNA sample, not always the blood and the semen, but also even if some bone remnants, fossils, like skull it can be, next teeth, yeah, next nails. In the nails also the blood stains will be there or the skin parts will be there. Even that nail clipping also will help to get the DNA profile from that particular person. Next. Semen swabs, how they are collected, and even the tissue, the flesh also can be collected. Yes. These are the swabs and the DNA, spermatozoa, how it looks like. Yes. The bones also can be collected for the DNA samples. These are the sources of DNA. Next. Yeah. Whenever the result comes, there are three types of results. One is, yes ma'am, keep on clicking it. Okay. Exclusive. Because the decomposition, law of probability. Because of decomposition or non-availability of the enough sample, the result may be, inconclusive. The third one. And if they are innocent, they are excluded from being implicated. And inclusion means they are the person, they are nailed, they are the actual suspects. Next. Yeah. All the cases which are referred to the lab should be forwarded either from the court or from the police. Other than that, we do not accept any private cases. Yes. Of course, medical doctor also, because sometimes the wound certificate, PME, it comes from there. And letter of advice is the communication between the IO and the experts in the lab. What exactly are the IO looking for? What type of a test they want? What is the result they want? What is to be compared with what? That is what is letter of advice. Yes. Yeah. These are for the different type of cases. We have different letter of advices. So you need to know whether they have sent the letter of advice or not. Otherwise, the experts cannot take their own decision and do the case. It has to come from the IO themselves. Yeah, next. Yeah, cases. Yeah, next. So DNA mass, accident like Bhavanagar Palam case or flight, where many people are involved in that, whose flesh or whose bone or whose body is what. That can be segregated through the DNA profiling. From their kith and kin, we can compare. Law of comparison over here. Yeah, next. Poaching cases where the Salman Khan was involved, isn't it? Where the animal, looking at the blood, the origin of the blood can be known, whether it is the human origin or whether it is the animal origin. Next. Yeah, Saki, I was telling about the zoo, how they have skinned out the tiger's skin. Next. Yeah, this is a tiger, fake tiger. Now coming to the physical division, where the hit and run cases or stolen vehicle cases, the chassis number is changed and the color painting of the vehicle, theft vehicles are changed. All these tests are done in the physical department. So in the physical division, we have two sections, that is the physics and the ballistics. Ballistics means everything to do with the firearms. Next. Yeah, glass, paint, salt, everything. Yes. Next. Yeah, this is glass. Yeah, next. Yeah, hit and run cases where the exchange principle is applying over here. Next. Yeah, through this tire marks also, we can know the model of the case, the vehicle, and whether it was loaded or not loaded. Many cases are there, but because of the paucity of time, I cannot discuss the cases in here. Yeah, next. By the skid marks, why the accident happened, what must be the speed of the vehicle, the velocity, with what speed, whether it was a negligence or under the influence of the intoxication or technical snag or just by accident it has happened. So depending upon the skid marks, what is the skid marks? With force when the vehicle is in speed, with force when you apply brake, that will create such blue marks on the road. Next. Ballistics, we deal with, it deals with the firearms, all shooting trajectory. Next. So what is the firearm, whether the bullet is from that firearm or not, whether the firearm is in working condition or not, whether it is handmade one or whether it is AK-47, what type of an ammunition they have used, whether it is a gelatin one or the country-made bombs, all this information can be gauged from this particular section. Yeah. Next. Yeah, internal everything. General division, a previous slide mark. In the general division, we have the computers, and then a previous slide. Next. 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 Yeah. Computers, we have an AV section, audio video authentication, where morphing and everything will be done. And CC cameras also are integrated in this. And you have the documents, forgery, simulations and everything, handwriting experts, everything, all document related, type matter related will be discussed in this. And psychology, as I told you, these particular three tests, brain fingerprinting, narco-analysis and polygraph. All this comes under the general division. And in this general division, computer division is now affected. Computer section is affected in the forensic lab today. Next. So this is how the forensic computer, we try to identify whatever the material, messages are there, the IP addresses. You know that digital evidence, Sarah also was talking, so I don't have to stress much about it. Yeah. So everything to do with the digital evidence. Next. Next. So audio video, hash value is very important to know that. So before the analysis is done, after the analysis is done, hash value should be maintained. If there is a disturbance in the hash value, that means the evidence is tampered. Yeah, next. Yeah. Audio video detection, like note to quote, note for a vote and all that is there, no? Where the string operations and all, the audio, whether it is edited one and something added to it or deleted ones, everything will be done this. And phone tapping and everything comes under this only. And video analysis, whether morphing and all, AI, everything comes. Yeah, next. Yeah, these are some of the type of, tests which are done over there. Next one. Next. Next. CC camera. Documents, you know that. Next. Next. These are the reconstruction for each and every section, each and every case. The reconstruction should be done. Then only you will have authentic, information out of that particular case. Next. Next. chain of custody is very important. That is why they say even one link goes, the chain is waste. So this chain is keeping everything in contact, everything in one position. Yes, nothing should be missed. Now these are the fingerprints. Now fingerprints also, it is also unique to every person, and you have many types of fingerprints, and those fingerprints, latent and chance fingerprints, that which you can see with your naked eye and which you cannot see it with your naked eye. From brushes, you put some powders on it and you lift it with a tape, or you also do some chemical spraying on that and you take a photography of that. Depending upon the change of color, you know that whether the fingerprints are there or not, and you take the actual fingerprints of the person, and through the data bank which is there, you compare it and you try to fix whether that person's fingerprints are matching or whether that person is involved in the case or not. Yes, next. Yeah, these are about the fingerprints. Now I just want to read you somewhere. The father of the fingerprints is Sir Francis Galton. Next. Yeah, next. Yeah, these are loops, ridges, next one. Yeah, whorls and arches, and these are the type of fingerprints which are found on the hands. Yeah, next. Yeah, what is the most common fingerprints that anybody can find is loops. Loops are there for any crime, but you should look out for the uncommon fingerprints. Sometimes because there are no fingerprints, and that condition is called as admissibility. So this is also glycia. This is also no fingerprints are available. Next. Yeah, the stages, of course, we have done. Yeah, next. Rare. Most common is loop. Very rare is arches, the plain arch. So people should look in for these particular things. We can find that Aisha Meera case. Vijayawada case, where Gurvinder Singh had the sixth finger onto his feet. That was a deciding factor. Yeah, next. Methods of detection, these are all the chemical staining systems. Next. Yeah, remove this. Remove. Next. Yeah, these are the psychological. We have another 3 slides and we end with it. This is the psychological test. We have 3 things. This is non-invasive lie detection. The statements when they are spoken, the person should say yes or no. That's all. Then it is very good technique to identify the innocence, and it is very helpful because it is what you think in the mind. The physiological parameters are changing, like respiration, blood pressure, and the skin response. With these 3 changes, we can know whether the person is innocent or whether he is trying to be a deceptive person. Next. Now we have the second test, that is narcoanalysis, which is an invasive technique. Something is sent into the body, and that something is nothing but the sodium pentothal. That is a benzodiazepine group of drugs. Under the influence of this sodium pentothal, that is 1 gram of sodium pentothal is diluted in 1 liter of distilled water, and then it is administered to the person who is undergoing the test. And then under the influence of that, the person will get into a condition known as trance, that is subconscious, not unconscious, not conscious, in between. When he is in this subconscious state only, you have to ask the crime-related questions. Whatever the revelation he gives, they are said to be truthful. That is why this system, this particular sodium pentothal is called as the truth serum. They talk only about this, about truth. That's it. So this is only the invasive technique. The first one was the polygraph is non-invasive, nothing goes into the body. Like how you go and check your BP, even that can be done in the laboratory. But this particular test should be done in the hospital, in the operation theatre, because if the dose is more, he may get into the coma and he may die. Or if the dose is less, he will be still conscious. So whatever the questions you answer, the revelation that he gives may be correct or may not be correct. It is unreliable. And most important is, these particular drug, when administered on the body of a person, it may disturb the central nervous system and the person may become paralytic, or he may lose his consciousness and become amnesia. That's why it is risky. This is not recommended by the court. It is not admissible. But whereas the first one, that is the polygraph, though it is recommended, the consent, any of these 3, the consent of the person who is undergoing the test should be there. And in the first one, only the person who is taking the test and the person who is doing the test, only two persons can be there in the room. But here in this particular technique, videographer should be there, the anesthesia person should be there, one medical doctor should be there, and the person psychiatrist or the psychologist who asked the question should be there. So many people should be there, and it is conducted in the operation theatre, and the full-fledged answers, whatever he tells, will be recorded in a CD, and unedited CD will be given to the police. In Bangalore, Dr. Malini has edited the CD to her own convenience, and she has presented it. That is why it was proven in the court of law when she was dismissed from the service. So this non-invasive technique is not very much familiar or not very much recommended by the law people. Next, last one is the brain fingerprinting. This is called as a silent test, where in the first instant you have to say yes or no for the questions answered. In the second test, you have to give an elaborate answer. But in the third question, the test, you don't have to do anything. You just see and your mind recognizes it, and that recognition will be in form of waves, and the graph will be maintained. At the peak 300, the actual person's response will be calculated. That is why this test is also called as P300 test. This is also non-invasive but not recommended. As per the Selvi versus Karnataka judgment of Karnataka, the Supreme Court, they say that ban the psychological test because it's all risky. But except for the narco-analysis, this test also is silent. We do not know when the questions are being asked, whether he's listening to the questions or not, we do not know. So his fantasies or his imagination may be also playing a role. That's why even this is not recommended, but out of these three, polygraph is the best one because it is non-invasive. And any of these three, consent by the person is very much needed. Without his consent, we cannot do anything. Next. Yeah, this is the Deshi one, Dr. Mukund of our India. He has also introduced this. The first one is brain fingerprinting is Lawrence Farwell, a foreigner, but this is from our own India. Next. Until you are proven, you are still innocent. And last slide is very important. Next one. A big thank you for listening.
Thank you so much, ma'am, for sharing your deeper insights on the topic privacy management and forensic science. Now, I request Dr. T. Aparna ma'am and Jyoti ma'am to join for the felicitation. Now I invite Ms. Neha, a student of BSc second year from RBVRR Women's College, to propose vote of thanks.
Good evening to the one and all present here, respected dignitaries and chief guest ma'am. Thank you for your valuable speech. You have said many points about the FS forensic science. Dr. Anita Evangelil, Additional Director, retired FSL Hyderabad. These points may, I hope, all the friends and everyone have gained the knowledge about FSL with your valuable points. And I consider it's a great privilege to propose the vote of thanks on this occasion. My sincere thanks to all the participants and the audience for their enthusiastic presence and cooperation. Thank you, everyone.
నీళ్ళు అట్రా పో